Dude, chill the fuck out, dude. I got it.
All right, we live.
We are live, and we have some camera or ceiling fan action as of right now. I believe the rumor is we're going to hear something about the from the medical examiner today, but I think we still have a witness on the stand, do we not?
I believe so. I think it's the guy from
No, wait,
don't
I don't
Sullivan.
know if it was a witness on the stand from. It had to be from Tuesday.
Oh, that's right. Yeah.
No, wouldn't be even Tuesday either. 'Cause Tuesday they did. Yeah, no, Tuesday. So no, it's gonna be interesting here from the medical examiner. If we're talking medical examiner, um, we should be able to hear what the state's assertion is on how these injuries got there. It should be a good cross examination. Should allow the the defense to dig in and take hold of that and challenge some of the stuff that we're talking about. Talking about whether that damage can be done by a vehicle, whether these are uh, uh, dog bite wounds versus lacerations, abrasions, and all the other things that everyone who's not qualified to say has said on the stand. So I'm really looking forward to the medical examiner. I will say if the medical examiner comes in tight, it seems believable and has a plausible story, that is going to be another good day for the prosecution. We'll see. I will say there's a lot going on there when it comes to those injuries, not finding abrasions, skid marks, so to speak, on the clothing. No, those wounds, even on the arm, don't appear to be uh, uh, abrasions. Like, quite honestly, everyone said they are. They appear to be uh, lacerations, cuts at best, puncture wounds at worst for the state. Those are there. You don't see any real injuries below the shoulder level, except for on the right arm. Not even to the knees. Uh, the injury on the back of the head should be some sort of determination about that. Now, I say that the medical examiner could come in and say, "This is what I found." I can just say it was caused by blunt force trauma, and this is what I found, and I can only say it was blunt force trauma. So there's a lot of things that the medical examiner can come in and be vague about. If they do that, it's not going to be great for the state at all. It's going to bolster the defense for sure. Or it's going to leave room for the defense to poke holes in it. Maybe that's a better assertion.
Yeah, like I was saying the other day, I also wonder if the jury hasn't already made their mind up. They're just sitting there listening now, just taking it in.
You say you think the jury has made their mind up?
I think so. I mean, I think if you've already established a reasonable doubt, um, and are 100% sure on that, based on whatever testimony somebody gave or evidence somebody produced, um, I mean, I'm not saying it's the right thing to do, but we're all human. I mean, I can't help but wonder that.
Well, that's the way it goes. I mean, if the state puts on such a weak case that the defense has decided early and just has to ride it out, I mean, that's kind of on the state. Let's don't forget it's the state's uh, obligation to do so.
Looks like we have Mr. Ron Roby in the live chat this morning.
Is he in the live chat?
He is in the comment section. Him and his boss, Miss Roby.
Yeah, it looks
Morning,
like
Vic.
good morning, Vet. But Kingdom, is it going to be the Emmy? I know it says in the title. I hadn't seen it anywhere else, whether the Emmy's here today. But like I said, I haven't keeping up with that necessarily.
Yeah, that's going to be interesting. Interesting to see.
I've been waiting for this. I've been waiting for that ever since they started talking about wounds and vehicles hits and dog bites, all this stuff. Everyone else comes in is like, yeah, they can speak a little bit about it, but the scope has got to be narrow. The medical examiner is going to get up there, and that's what they're there to say. They're there to tell us what these things are, why he died. The medical examiner's opinion. It's essentially as good as the lead investigator, which in this case wasn't that great. But in a case, it's as good as a lead investigator because the ME is actually an investigator in a case. I think I've heard it in this trial, but there's like state laws that mandate that law enforcement work hand in hand with the medical examiners as investigators on a case to determine the cause of death and methods of death, and if there's any criminal activity.
After hearing the what the lady from California had to say on Tuesday uh, about the dog bites and all that, she said that she had reviewed all the information that had been given to her, and one of the things was the medical examiner's report. So I can't help but wonder, is the medical examiner also going to mention that the wounds on his arm are consistent with that of a dog bite?
Oh, got audio.
Because we know she's seen that same
May I
thing.
Well,
call the
man,
case back?
Yes,
I think if the
please.
state is
For the
saying that
record,
it could have
before
been
the
a dog
court is
bite,
Commonwealth versus Karen Reed, 2282 CR
might be having a different
00117. The
case.
parties are present, the jury is not present. The council has asked to see Judge Canoni.
Oh,
Okay. Did
man,
you want
look,
to see me at sidebar?
I get, we can do it sidebar or an open court, it's up to the court.
Why don't I see you up here and see?
let's do a sidebar because I don't know what you're going to say. I don't want everybody to hear what you got to say.
Yeah.
A little court business this morning before the jury comes in. Court business in this case has been interesting.
And there's Miss Karen Reed, all dressed in black. Good morning, vet.
Have vet with us.
Got Big Ron.
What? Big Ron's with us too. There we go,
Big
folks.
Ron is in the chat. Big Ron, you missed a good show last night. So, am I understanding correctly that the prosecution is going to finish up tomorrow and then the defense starts on Monday? Is
I
that the
believe
plan?
that's what the schedule is.
Okay.
Now, going to know that can, the judge always can give more time if they've got a
Yeah.
good foundation to do.
Well, I know the other week when she was talking about scheduling, she said something about they had told her, let the jury know that they would probably be done or wrapping up by the end of the month. So if defense starts Monday, that's only going to give them 5 days. But I think they can do it with what they've already established. I think Alan Jackson has done a marvelous job in Cross.
Yeah, I think he has. So I was reading a text message, but and the way the judge does that, they do these sidebars. Defense, how long do you need? So she's giving the defense as long as they're asking for. So, Big Ron's talking about the smoke show last night. Yeah, brother, that was supposed to start a little bit earlier, but I got stuck in a space with not stuck in a space, but I was in a space with Tickle on some COVID vaccine things, and uh, I don't want to say she asked me to stay, but she made a comment that if once we got to the audience questions, she'd throw me a mic and do an introduction and had some questions in there. It just got to the point where I had to pull out, and go start that show. But it was unscheduled, impromptu thing. Turned out real well though.
Oh, so on that note, so Office Depot, jeez, it's early. Home Depot does price matching. So they're already Home Depot's already $50 cheaper than Lowe's, and I got a $25 gift card for Father's Day. So I'm gonna walk out of there with that smoker for about 2 3/4.
That's not bad at all.
No, I'm
No,
thinking.
that smoker will do you great. You'll be able to you'll perform with that pretty quick. Doo, doo, doo. Yeah, I'm looking
So
forward to tonight's night court with Tickle Text or Tickle. That's going to be a pretty interesting show when it comes to just getting down to some history on what's going on in South Africa and why things are the way that they are there. And um, I mean, some of the things that I heard the other night. I mean, it's literally like living in a war zone. These folks that are living in encampments or communities that are like patrol bases. They do roving patrol on the inside. Everybody's got the perimeter security. When people go for groceries, they go with fire teams, literal fire teams, and communications. That sounds like a total breakdown of society.
So, and not to go ahead and get into that, but just hopefully a quick question. So about a month or so ago, Matt Gaetz was questioning I forget which high-ranking military person up on the Hill, and he was mentioning how U.S. troops are over there in Africa, and they were not able to get supplies, they were not able to get mail and some other essentials that they needed. So Matt was questioning this guy on what was being done. Now I may have misheard, but the other day I thought I heard that I think he said Army. There's some Army personnel over there that are being held against their will. They're not allowing them to do anything and leave, or so I'm like,
That's in Niger. That's not South Africa, but
oh, okay,
Niger
okay.
was essentially still a French colony, French territory, so to speak, up until this year, and then they kicked the French out, kind of forcibly. They've married up with the BRICS nations. I mean, we saw that over the weekend. Putin's doing a tour in the Asia East, North Korea. They've signed a pact with North Korea to get around the sanctions that the rest of the world's put on them. So China and Russia will help them avoid sanctions, which is good for North Korea. Vietnam, I think they're going to sign a pact there as well. So they're building essentially another Soviet Union or an Axis power against the West. We're sitting back watching it happen. It's just like it really reminds me of the days prior to World War II. All of these things are happening, and nobody wants to be heavy-handed. Nobody wants to push back. Uh, no, we're not going to take Czechoslovakia. Oh, well, we did. No, we're not going to take Austria. Well, oh, they did, but don't take any more. Don't go to Poland. Oh, well, they took Poland. Oh, well, I guess we got to go to war now.
Yeah, I
It
took
feels,
Poland, but I ain't gonna take nothing else.
yeah. Well, they didn't get fooled at Poland. That's when the United Kingdom and France declared war finally. But they did Czechoslovakia. They did Austria. There was even some parts of France right on the sign that they had taken. And everybody's like, well, don't go any further now. Don't do it anymore. But we're watching it happen. But Niger is where the U.S. troops are there, but they will be leaving that location or leaving that base by September, is what Biden has agreed on.
All right, so what we got today, boys?
I think we got the medical. I'm hoping the medical examiner.
Well, I think you got to finish out with the police officer that's talking about those text messages. I think they're going to play some voicemails of her cussing John out and shit like that. I think you're going to go through those voicemails first, and then you have the cross examination of him. Which it's going to sound bad. She's going to be talking bad about him and saying all the bad things about him, which really just proves she didn't do it. Because if she did, she'd be saying nice things, in my opinion. And then you have the two medical examiners, which is really what you almost wanted to call first. But the prosecution or the Commonwealth thinks that these two medical examiners are their best witnesses. So they must be saying something along the lines of, she hit him. But I would say you've seen Alan Jackson pointing out the shoulder injury is what the bald headed action reconstructed for the Massachusetts State Police, saying that, oh, you got hit in the shoulder, but there's no bruising. I think you're going to see Alan Jackson try to drive that point home.
Yeah, I'm curious to see what the cross examination of the medical examiner. I do expect the defense to come hard on that. Now, go back to. I thought that we ended all testimony on Monday. Tuesday was voir dire. Today is the first day back in court. We should have a brand new, fresh witness. Or am I not remembering correctly?
I don't think they were done with him. Not quite.
Who is him?
No,
The bald headed.
no,
state-
this guy had hair. The guy who was saying, because Lally was like, I just have one more thing, Your Honor, and he kept fiddle farting around. She goes, we're just done for the day. But he was,
You know what?
he was
You're
still,
right.
yeah.
Yeah, you're right. I remember now. Okay. So yeah, I guess they could play these voice messages in, but man, I don't know if that has a lot of weight. Anybody that's been in a relationship for more than a week, you know.
I think Karen Reed has a
Ron, I'm
future.
actually from
Regardless.
the University of Texas, is where I'm at today, so I'm remote. Sorry, I sound like a tin can and not the normal microphone.
Yeah, I was going to comment on that.
I'll be commenting with you guys online throughout the day. Laura and I have a little business we need to attend to, but I was just checking in with you guys this morning and looking for a good day.
10 fur. Watching Karen, she's going through some post-it notes. I believe she's a legal aid now, legal aid / client.
Tell you what, you're on defense for your life. Participating in that defense is probably not a bad idea. I want to stay on top of what's going on, you know.
Yeah, I mean, my nerves would be shot, but I guess at this point, there ain't nothing you can do but help.
Yeah, well, I guess Kingdom has dropped out. Kingdom, yeah, is doing remote. He's actually in Austin, Texas, on some business, but he'll be popping in and out from his laptop on occasion, just like he said. But we'll still get Kingdom's fresh look on this and his point of view as the day goes on. I'm just curious to see how far we get. I'm really hoping we don't get into a bunch of text messages on a relationship of people kind of yelling back and forth at each other. I think that's going to be quite honestly boring. And the other part too, it's like I don't know how much it really sways anyone to say that people had been to a man and a woman that's been in a relationship, long term relationship, for any length of time, really, that hasn't had a spat or something going on, some issues. You know, they already tried to bring up the state's trying to assert that the fact that he adopted his orphaned niece and nephew, that was a problem for her to the point where it was like jeopardizing the relationship. Which, you know what, there could be some truth to that. You got the text message back to Higgins. It doesn't sound like their relationship was all that necessarily solid. But I think the thing with Higgins, if you believe that she's ready to jump ship and, you know, as a monkey does, grab one branch, but hold on to the branch you're holding on to, you grab another. If she was doing that, then it almost doesn't bode well for her having a motive like, I'm going to kill this guy to get rid of him. It's not like it's a divorce where you got to go through child custody and division of assets and you know, for some people, the embarrassment of a divorce that you kill the spouse to avoid that, or you love them so much that, you know, if I can't have him, nobody else will type of murder. So to me, it doesn't really sound, to me, it doesn't bolster the state's case as much as I think they think it does by saying that there's this relationship wasn't like headed towards you know, wedding bells, in my opinion.
Yeah. I mean, if anything, after they were reading the text messages and all that on Tuesday, if anything, I mean, I think I see some narcissism in there. maybe some controlling tendencies, but with the manipulation text and
From who?
from Karen. I mean,
Oh,
I
yeah,
did
no
that,
doubt.
yeah, but I don't think she killed him.
Yeah, I'll be quite honest with you. It's so muddied right now. It's really hard to say. It's like I was saying, I think on Tuesday, or maybe it was, and I think it was Tuesday. If if you believe those taillight pieces were not planted by the police, that they got there on their own, then you have to believe she did it. If you don't believe that, then there's no way you can believe she did it. See what I'm getting at? That's why I
Oh,
say
yeah.
taillight pieces. How you feel about the evidence that was found near his body, the taillight lens pieces, is to whether or not you're guilty or not guilty on
All
this.
right, so,
Because if you're hung in any other area, you still got to make a decision in your mind. Are you for or against those taillight pieces? It's the
so
thing you can get
moving
around.
on to the voir dire motion the other day, or the voir dire hearing in response to the Commonwealth's renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. So the Commonwealth was alleging violations of Rule 14's reciprocal discovery requirement, and the Commonwealth asked for exclusion of Dr. Russell. I did find and do find that there was a violation of the reciprocal discovery obligations of the defendants. I was looking for a remedy. You called it a sanction, Mr. Jackson, but I called it a remedy. And I did tell counsel, as you know, at sidebar a couple of times, at least last week, that I did not want to exclude the testimony if I did not have to. So we had the voir dire, and I'm satisfied that the voir dire provided the Commonwealth the information that the defense should have provided the Commonwealth. So I am going to allow Dr. Russell to testify, but her testimony is very limited, and I think you even sort of acknowledged it the other day, Mr. Jackson. So she'll be allowed only to opine whether or not the marks on John O'Keefe's arm were the result of an animal attack. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in this regard. But she can't testify as an expert on police activity. There'll be none of that. And she will not be able to testify as to what the injuries are inconsistent with. She cannot testify that they're inconsistent with having been struck by a vehicle, road rash, scratches from broken glass, or taillight matter, or anything else. So that's beyond the scope of which she can testify. The second part of the Commonwealth's motion, Commonwealth argued that they were not provided reciprocal discovery regarding the biomechanical engineers and others, but specifically ARCCA, Dr. Wolf, and Dr. Rentschler. And I do find, though I understand why the defense didn't respond, but it is a violation of Rule 14. So we had this voir dire. The Commonwealth was looking to see what each person did, their independent opinion, what their testimony would be, and whether they were qualified to render the opinions that they qualified. So from what I heard the other day, Dr. Wolf can testify to what his involvement. Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So,
Yes, Your Honor.
okay, so those are my rulings. Are they clear, Mr. Jackson? Are they clear, Mr. Lally?
Yes, Your Honor.
Okay. All right, so are they ready to come
Well,
in?
that's a win for
Thank
the
you.
defense in a way.
Yeah.
It's odd that you say that only medical doctors can testify to injuries, but we've heard from police officers do
Thank
that.
you.
That might be a strong argument for Jackson, but if there is some statute or case law in Massachusetts that says that, they may exclude this guy from actually talking about what could have caused the injury, which is really that guy's strong point, I think. But yeah, as Kingdom says, that's a win.
Absolutely. I'm actually tickled to hear that.
Tickled.
Yay. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right, good morning again, counsel and Ms. Reed. Good morning, jurors. So we appreciate that you were patient, that we got a lot of work done this morning before you came out. It's cool in here now, as long as you're away from the sun from the windows, it should be fine. The county has done a really terrific job of making sure that they got this building nice and cool for us today. So I appreciate what the county's done as well. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left on Tuesday?
Yes.
Everyone said yes, nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Tuesday?
Not since you dismissed the last juror, Judge.
All right, thank you very much.
They're like,
So
oh,
may we
she
call
ain't
the witness,
playing.
please? Trooper Garino, please.
Trooper Garino. Let's hear this guy read a script from a phone that he read.
Same situation. If you might please step up. Stay standing.
You solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Good morning, Trooper.
Morning, everyone.
Whenever you're ready, Mr. Lally.
Thank you.
Just speak up so we don't have to turn the air conditioner off. It's
Morning.
damn hot up here today.
Taking you back to the other day, I have been showing you, so you had testified about some extraction reports that you had conducted from the various forensic extractions that you had done pertaining to both the defendant's phone and Mr. O'Keefe's phone, correct?
Yes, sir.
And Your Honor, may I approach?
Yes.
I'm showing you a document, asking you to review that with a couple of minutes.
Okay. Okay.
You recognize that, sir?
Yes, it's
What do you recognize that to be?
Karen Reed's phone call logs.
And that's specifically from January 28th and January 29th, is that correct?
Yes, it starts the 28th at 12:33 to, I'm sorry, the 29th at 12:33 to 3:19 p.m. on the 29th.
And just for ease of reference, does it sort of go in descending order as far as the earlier calls are on the last page and then the more recent calls are on the first page?
Yes, that's correct.
May I approach, Your Honor?
Yes.
I'm going to introduce them as an exhibit. May we approach, please?
Okay.
And we're back at it. Let's talk about it on sidebar. You know, that happened so fast, I'm not even sure what the issue is.
Well, what's his name? The co-counsel, he was looking at another set of text messages for him to review while he went forward with the first set. So it must be an issue with whatever was in that. Lally handed him 2 sets of text messages.
Are you talking about the defense co-counsel?
Yeah, what's his name? Not Jackson, but the other guy.
Okay, yeah, I know what you're talking about. Doo-doo-doo. Interesting. Yeah, I see a lot of ways that you could, the defense would argue or struggle to have text messages brought in. You don't know, almost don't know context. It's just like words out of the atmosphere pulled out that you're reading. Um, we all know that people can interpret text in whatever way they want. That you really can't uh, get the rhythm or the texture of the conversation that's going on. That you could make excerpts, pulling them out of context. So I can see where the defense could actually maybe make some roads with that.
Yeah, that's why I haven't. And I'll be the first one to admit, I think we've all done it, argued over text. I try not to do that because you can't ever tell the tone of the text either.
No, 100%.
Yes.
Showing you another document, sir. Do you recognize that?
Yes.
What do you recognize that to be?
This is Karen Reed and Kerry Roberts' call log.
And that's an extraction report that you created from the defendant's phone, is that correct? Yes, sir.
Yes. Sorry. Yes.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce and admit as the next exhibit.
Okay.
No objection.
634.
May I approach again, Your Honor?
Yes.
Showing you another document, sir. Do you recognize that?
Yes.
What do you recognize that to be?
This is the chats from John O'Keefe and Chris Albert.
And again, that's an extraction report that you created from Mr. O'Keefe's phone, is that correct?
Yes, it is.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce and admit as the next exhibit. No objection.
Mr. Lally, you really do need to keep on stuff. 6:35.
Yeah, they're experiencing like severe heat up there for them guys. I bet they do not want that air conditioner to go off. She's
And
gonna
may I
lose
approach-
her.
Oh, I'm sorry.
She's gonna lose her stuff if she's got to turn that AC off.
Yeah, I read somewhere, I think it was yesterday, it was like 93.
My apologies. May I approach again, Your
I
Honor?
believe the highest temperature in the country was in Bangor,
Another
Maine
document,
yesterday.
sir. I ask you to look at that. Look up when you're finished.
Yes.
Do you recognize that, sir?
Yes, this is Karen Reed's the full chat report of everyone from the 29th on. So,
May I approach, Your Honor?
Yes.
I'm going to seek to introduce and admit as the next exhibit. We have no objection.
6:36.
I'm sorry, may I have the last one? May I approach the witness, Your Honor?
Yes.
So returning to you what's now been marked as Exhibit 636. Your Honor, with the court's permission, may I publish a portion of this to the jury?
Yes.
Yeah, it's already 80 degrees in Canton.
That's like 100 degrees anywhere else.
And sir, I'm going to direct your
All
attention
right.
Yeah.
to
Real
the
feel,
exhibit
90
before
feet.
you that's now been marked as Exhibit 636. And Ms. Gilman, if I could, I'm sorry, Mr. Garino and Ms. Gilman, if I could direct your attention to page 3. And do you have that before you, sir?
yes, I do.
And on page 3, who is that a conversation with?
Laura Sullivan.
And that conversation essentially continues from page 3 to page 6. Is that correct?
Yes, it does.
And so I'm going to ask you, similar to what I asked you the other day, if you could read from that conversation in its entirety, indicating who's speaking, content of what's being said, and the date and time associated with that message.
Yes. All right. First message from Laura Sullivan. at 12:45 p.m. on January 29th, 2022. Karen, it's Laura. Please call me. Karen says, hi, Laura, at 1:07 p.m. Karen then says, John passed away, 1:07 p.m. Laura, Karen, I'm shaking. I'm so sorry. At 1:07, Karen says, we found him outside in the snow at 5 a.m., 1:07 p.m. Laura, I can't stop crying, 1:07 p.m. again. Karen, thank you, 1:07. And Laura finally says, why was he out there, 1:07 p.m. Oh, sorry. Karen replies, he left the party we were at. I don't know what time. I didn't even go in. I went to bed. That's at 1:08 p.m. Laura says, oh my God, 1:08. Karen, my heart breaks for, my heart breaks for everyone at 1:09 p.m.
Thank you, sir. So in those text messages, Ms. Sullivan, in the afternoon of the 29th, she indicates to Ms. Sullivan that they located Mr. O'Keefe around 5 a.m. Is that correct?
Yes, it is.
Now, sir, if I could direct your attention to page 28 through 29 of those messages in the exhibit before you. In page 28 through 29, who was that a conversation with?
This is Karen Reed and John O'Keefe.
These are conversations from the early.
I'm having trouble. Yeah.
These conversations on page 28 through 29 of this exhibit occur in the early morning hours of January 29th, correct?
Yes, that's correct.
And if you could, sir, again, please read as far as who's speaking, what they're saying, and what date and time these are being sent.
Yes. So, Karen Reed to John O'Keefe at 12:55 a.m. on the 29th. I'm going home. Followed by, I'll see you later. At 1:02 a.m., she texts John again saying, your kids are cucking alone. And at 1:04 a.m., she says, I'm back in Mansfield. The kids are home alone.
Thank you, Ron. May I approach this to retreat?
Yes.
Did you notice how the messages had not been read?
May I have a moment, Chairman?
Yes.
To John O'Keefe?
Yeah, it just says sent. They were not read. The other text messages had been read.
Okay. The other text message to other people or John O'Keefe?
May I approach?
No, to other people. It just showed that it had been read. What
Yeah,
I'm
no,
saying is,
they asserted that all along, that she sent text messages and phone calls that went unanswered.
yeah, like he didn't, according to that right there, he didn't even see them. Like he didn't even click on them to read
But-
them.
Well, the state says he's dead at this point at 1 o'clock in the morning.
Right, yeah.
And I think even the defense is saying that he's dead at this point.
So I'm showing you two documents. And Mr. Officer, we can put the lights on. You recognize each of those documents, sir?
Yes, one is Karen Reed call log report. Just want to confirm which one this is. Yeah. For John O'Keefe, and then John O'Keefe's full call log report on the 29th.
Now, sir, if I could direct your attention to the defendant, Ms. Reed's call log reports, and specifically, if I could draw your attention to what's been, they're enumerated as far as certain box numbers, correct? 1 through whatever it goes on the last page.
Yes.
If I could direct your attention to boxes 113 and 114.
Okay.
See those entries, sir?
Yes.
Now, as far as the time related to box 113 and 114, what are the timestamps associated with that?
1/29/2022 at 12:36 a.m. 41 seconds, and then another one at 12:36 and 10 seconds a.m. on the 29th.
And is there any indication within that report as far as whether or not those calls are answered, those calls are missed, those calls are rejected? What's listed?
It says answered.
And we'll get to this a little bit more in a moment, but with regard to that 12:36 time, from your review of both the defendant's phone and Mr. O'Keefe's phone, is there a voicemail that the defendant left Mr. O'Keefe at that time frame?
There was a voicemail at 12:37 a.m. These ones here, it looks like they're 3 seconds and 5 seconds long.
And they're listed as answered, is that correct?
That is correct.
Now, sir, if I could turn your attention over to Mr. O'Keefe's call report. And specifically, I'm going to ask you to direct your attention to what's been labeled as box number 134 and then 134 with the 1 in parentheses following that.
Okay.
And do you see those entries, sir?
Yes.
And what is the date and time associated with those entries in Mr. O'Keefe's records?
His records shows number 134 is 12:36, 9 seconds on the 29th, and then 134 with the 1 in the parentheses, 12:36 and 9 seconds as well. But call duration 0 seconds.
And as far as any indication on those calls, as far as whether they're answered, they're missed, they're rejected, or what are they listed as?
There's nothing. Also 133 is the same call, and that one says missed, and it's at the same timestamp of 12:36 and 9 seconds.
So the same call around the same time frame shows up in Mr. O'Keefe's report as missed and shows up in the defendant's report as answered, correct?
That is correct.
And that is around the time that the defendant is calling the victim repeatedly and leaving voicemails on Mr. O'Keefe's phone.
Yes, that's correct.
May I approach just to retrieve, Your Honor?
Yes.
Yes.
So she calls and leaves him a voicemail when she can't get a hold of him. Probably not talking real nice. That we're talking about here.
Sorry, that's what I'm understanding.
Now, Trooper Guarino, you conducted an analysis of both the defendant's phone and Mr. O'Keefe's phone, correct?
That's correct.
And from your analysis of that phone, were you able to determine approximately how many calls occurred from the defendant's phone to Mr. O'Keefe's phone from the time period shortly after 12:30 a.m. To the time period shortly after 6 a.m.?
There was over 50. I think it was 53 or 55.
And any of those calls from your review of those records indicate any sort of conversation as far as duration, as far as being labeled as answered, anything to that effect?
That Mr. O'Keefe actually picked up the phone and spoke to Ms. Reed?
Yes.
No.
Now, with regards to those phone calls from the defendant to Mr. O'Keefe, what, if anything, did you find from Mr. O'Keefe's phone in relation to voicemails left by the defendant?
There were 8 voicemails on Mr. O'Keefe's phone from the 29th till the phone was discovered. All from Ms. Reed, no one else.
May I approach, Your Honor?
Yes.
When you were this, sir, you recognize that?
Yes.
What do you recognize that to be?
It's the John O'Keefe voicemails from Karen Reed on his phone.
From that period that we were just speaking about on January 29th?
Yes, that's correct.
May I approach, Your Honor?
Yes.
I'm going to seek to introduce in the minutes the next exhibit. We have no objection.
Okay.
Now, sir, from your review of the defendant's phone, before we get to those, from your review of the defendant's phone, what, if anything, were you able to observe or ascertain that the defendant's phone did at approximately 12:36 a.m.?
So by looking at the timeline in the phone, we're able to see that Ms. Reed's phone auto-connected to John O'Keefe's Wi-Fi at his house at 12:36 a.m. You know this because it's a password protected access to the phone. So you would have to know the password to get into this Wi-Fi network.
And that would be the home at 1 Meadows Avenue, correct?
Yes, that's correct.
And Your Honor, with the court's permission, if we could publish each of the 8 voicemails to the jury.
Okay. Are we going to hear which time each one is?
Yes, Your Honor. And Trooper Guarino, again, similar to the other messages, just for point of reference, the earliest of the voicemails is the last in the list and the most recent is at the top of the list. Is that correct?
Yes.
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Ms. Gilman, if you could have the second message. Sorry, Ms. Gilman, if you could pause right there, please. My apologies, Your Honor, I just wanted the siren to go by.
Oh, that's fine.
Before Ms. Gilman presses play again, Trooper Guarino, what time is the second message?
12:42.
Ms. Gilman, if you could. Now, Trooper Guarino, with reference to the third message, what time is that received?
12:59.
And again, when I say received by Mr. O'Keefe's phone, is that correct?
That's the timestamp of the voicemail in his phone. Yes.
And Ms. Gilman, if you could, with reference to that third message.
John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
Now, the fourth message, Trooper Guarino, what time was that received by Mr. O'Keefe's phone?
1:02 a.m.
Ms. Gilman, if you could, when you're ready.
That was it.
So can we just turn the air conditioner off for just a second, please? So you just played it?
Yeah, Your Honor, there was no content. It was just like a 1 second long message.
And Trooper Guarino, with regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
37, 42, 59, 1:11 a.m. Excuse me.
And Ms. Gilman, if you could.
Yes, 1 in the morning, I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert.
And the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
Gilman, if you could.
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
Ms. Gilman, if you could. The last and eighth message, sir, what time was that received by Mr. O'Keefe's phone?
6:08 a.m.
Ms. Gilman, if you could. Gilman, if you could pause there for 1 second, I'm sorry. With respect to this message received on Mr. O'Keefe's phone at 6:08 a.m., from your knowledge of the investigation, where was the defendant, who, if anyone, was with her or around her at the time of this message at 6:08 a.m.?
Jen McCabe, Kerry Roberts. During the message, you can hear someone on the phone with 911.
Thank you, sir. Ms. Gilman, if you could.
Yes, I need someone to be very 12 years old, yes, now, they're making a tax notice now. Yeah. Okay, I know. Weird blanket. I don't see blanket very well. Yes, I need
Thank you, Ms. Gilman.
Can we turn the air conditioning back on? Thank you very much.
That must be some loud air conditioning they've got there in,
Yeah.
Now, Trooper Garino,
Yeah,
in
mate.
addition to the 53 phone calls that you've testified about, the defendant made to Mr. O'Keefe from that time frame following 12:30 a.m. to approximately just past 6 a.m. Did you note any other calls to a contact listed within the defendant's phone as mom?
Yes.
And when were those calls placed?
I believe there's one at 1:10-ish in the morning. I forget the exact timestamp. There's also one at around 4:40 in the morning, and then at 4:42, right around 4 in the morning. Two of them, the first two weren't answered, and then the third phone call was answered.
Now, with respect to Ms. Reed's phone from that same time period, what, if any, phone calls did you observe to a contact listed in the defendant's phone as dad?
It's the same number. So when I looked at it in one report, it showed as dad. And then when I looked at it in Cellbrite, it came up as mom. So I don't know how it's attributing. Maybe she has it listed twice. I never looked at her actual phone. So this is what the extraction is showing me.
Now, sir, you testified the other day that upon your review of the defendant's extraction reports, you were not able to determine there were no listed GPS locations for the defendant's phone.
Correct. Like routes or anything like that.
And that was because it was turned off in the phone. Is that correct?
That would lead me to believe, yes, that location services are turned off. So
Objection. Move to strike.
Yep, so no gas. What can you tell us about that?
well, if GPS coordinates and location services on, that's what would get us locations in the phone. So if they're not there, they could be turned off.
Objection. Move to strike.
I'll allow that.
Now, with respect to Mr. O'Keefe's phone, what, if any, analysis with respect to GPS and/or health data? Well, let me ask you this: is from your training experience and your casework with respect to forensic analysis of electronic devices, what is health data in a cell phone? How is that reported, and what, if anything, can that tell you?
Okay. So in an iPhone, you can have health data. To use that health data, the phone, if you don't have an iWatch paired to it, is basically just a high-tech pedometer. It's just every time you move the phone, it's going to track steps, and that's if you have it turned on. If you have the iWatch on, it'll get beats per minute, and you get a much more robust health data from it.
Now, with respect to the health data and with respect to the GPS location for Mr. O'Keefe's phone, initially, what, if any, sort of analysis did you do with respect to that?
So we checked his native locations. At 12:19, the phone is, well, I should say this, at 12:12 in his location shows that he's at the Waterfall Bar. The next set of locations shows he's at Dedham Street by Cedar Crest, and then Waze is activated for 34 Fairview. So, and then it shows me his entire route to 34 Fairview.
And what is Waze, sir?
Waze is similar to Apple Maps. It is the GPS program that, you know, punch in like a Garmin type thing.
If I could take you back just for a moment, just to the health data from the Cellbrite extraction that you did. Specifically, you looked at data from 12 a.m. to 1 a.m. on January 29, 2022. Is that correct?
Yes, that's correct.
And as far as the health data was concerned, there was some entries from 12:11 a.m. to 12:32 a.m. Is that correct?
Yes, that's correct.
And can you describe to the jury sort of what you observed and what, if any, significance those entries had to you as far as the health data was concerned?
Yeah, so the health data shows, like I said, the phone is basically a high-tech pedometer. If you're moving it around, it's going to think you're taking steps where you might not actually be walking. His health data showed while he's driving that he's traveling and taking steps.
Objection.
So I need a foundation.
Grino, over the course of this investigation, your analysis, you became aware of other witness statements, surveillance video, things of that nature as to Mr. O'Keefe's whereabouts from approximately 12 a.m. to at least 1 a.m. Is that correct?
Yes, that's correct.
And you're aware of around the time just past 6 a.m. When his...
So let's hear the question first.
Cool. That's my objection.
Go ahead, Mr. Allen.
You're aware of the time being just past 6 a.m. that you've already testified to as to when Mr. O'Keefe was discovered and 911 was called.
Yes, that's correct.
So, sir, with respect to, again, that time period starting at 12:11 a.m., what, if anything, did you observe with respect to the health data of Mr. O'Keefe as signified within the phone?
So it marks when he's taking steps, ascending, or I should say, yeah, ascending stairs, and distance traveled.
And so from that period of 12:11 to 12:32, there were essentially 4 time periods that you delineated. Is that correct?
Yes, that's correct.
And do you remember the precise times and sort of the distance traveled within those time frames?
I don't remember the precisely off the top of my head.
Your Honor, with the court's permission, may the trooper refer to his report just for those
Yes,
numbers?
do you have it with you, Trooper?
Yes, Your Honor. Thank you.
Well, John, what do you think about the voicemails? Do you think that is damning to the defense?
I don't think so.
And sir, if you could just list for the jury what you found.
Yes. So at 12:11 and 9 seconds in the morning to 12:21 and 5 seconds on the 29th, it shows that he's taking 170 steps, going 99.6 meters or 326 feet. At at 12:21 and 10 seconds to 12:24 and 22 seconds, it shows 80 steps and 87.74 meters or 287 feet. At 12:21, 14 seconds to 12:24 and 37 seconds, it stated ascending, descending 3 floors. And then at 12:31, 56 to 12:32, 16 in the morning, 36 steps, 25.46 meters or 85 feet.
Now, sir, with respect to what's listed as steps, does that indicate, from based on your training experience and familiarity with this sort of health data, what, if anything, does that tell you as to whether or not the person with the phone is physically taking steps?
That's not the case.
What is the case?
Like I said, the phone has internal measures.
No objection.
No, I'll allow.
The phone has internal measures in it. Like I said, it's basically a pedometer. So the movements of the phone, the distance traveled, it's going to register as steps. You don't have to physically be walking and moving the phone for it to register movements. Just waving it around and then could potentially cause it to think you're walking and moving.
You mentioned that from your review of Mr. O'Keefe's phone, you indicated there was a Waze search for 34 Fairview Road. Is that correct?
Yes, that's correct.
And if you could just explain to the jury sort of what is Waze and what kind of information are you looking at there?
Waze is a GPS program. So you put your address you're looking to go to. It's going to tell you the fastest route, where the police are, etc.
And when that Waze search was conducted, is there a precise time pursuant to your review of Mr. O'Keefe's phone associated with that Waze search?
Yes, it was at 12:20 in the morning.
And so from all of those steps and everything that you, if Mr. O'Keefe is searching for 34 Fairview Road, inferably, he's not at 34 Fairview Road. Is that correct?
That is correct.
Now, with respect to the location, can you describe to the jury, are you familiar with the term based on your training experience known as native locations?
Yes.
And can you explain to the jury what that is?
So native locations on an iPhone, the way it pulls GPS data, it uses satellite, Wi-Fi signal, Bluetooth, location services on apps. It takes all that data and uses it to get you the best location of where you are, unlike where you'd have like a handheld car-mounted Garmin GPS that's just using strictly satellite.
Now, from your review of that data, when that Waze search is conducted at approximately 12:20 a.m., where is Mr. O'Keefe physically located at that time?
The vehicle or whatever they're in is by 138 Dedham Street. They had already passed Cedar Crest Road.
And from review of that native location data, what time does the phone arrive in the area of 34 Fairview Road?
12:24 a.m.
Now, the next entry as far as the location data, when is that and where is it indicating that the phone is at that point?
That shows me it's there the entire night, right in between 32, 34 Fairview. So
And 32, 34 Fairview, that sort of intersection of those two residences, if you know, where is that in relation to where Mr. O'Keefe was found just after 6 a.m. in the morning?
I was only going by the photos that Sergeant Good had taken and from the Canton PD cruiser cam, but that area would be within 3 feet, give or take, of the area where the GPS signals all plot for the rest of the night.
Now, Trooper Garino, you testified the other day to a tool that you use called Axiom, is that correct?
Yes.
And with regard to the location data in the tool of Axiom, what, if anything, can you tell the jury as far as how that works and how accurate it is?
So like Cellbrite, Axiom will also show the native locations in an iPhone. They're able to display the range of accuracy in meters, and then also the speed of the phone in meters per second.
And were you able to ascertain from using the Axiom tool and the location data from Mr. O'Keefe's phone as far as its speed in meters per second at 12:25:36 a.m.?
I don't remember it off the top of my head.
Your Honor, with the court's permission, may the trooper refer to his
Thank you.
report for the numbers?
Go ahead.
It's a 0.6346 meters per second and a 16.75 meter lever of accuracy. So at about 54 feet measure of accuracy.
Now, sir, if you could, just based on your training experience and your use, familiarity with this Axiom tool, for the record, that's AXIOM, is that correct?
Yes, that is correct.
So as far as that degree of certainty or accuracy with regard to the measurement, can you speak a little bit about that and explain that to the jury, how that works and what that means?
Yeah. So, as I said, the iPhone tries to use multiple things to get you the best area of location where you're at. I can tell from personal experience that being at 34 Fairview, it's at the bottom, Fairview, where 34 is on Fairview, it's at the bottom of a hill, and it's also at the bottom of Cedar Crest where they sort of intersect. That area there has many hills. So the GPS signal can weaken due to natural landscape, buildings, weather, multiple factors.
And as far as the degree of accuracy, what, if anything, does that tell you in regard to the location of the phone in reference to that degree of accuracy?
So it plots a point where it believes you are, and then the degree of accuracy says you could be in this bubble, but if it's way outside or way far away, it's all going to show by how well the signal strength is to the satellite. So like I said, if it's a poor signal, it's going to blow out. It's going to show you could be in this giant circle. But as it gets better accuracy, it's going to shrink back down. It's going to say, nope, you're right about here.
And to that point, or to elucidate that point that you were just speaking on, we'll get to this more in depth in a second, but at some point in 2023, did you go to 34 Fairview Road to conduct some GPS mapping?
Yes, I did.
And when you were in that area of 34 Fairview Road, what, if anything, did you observe with reference to satellite connection, cell phone connection, things of that nature as far as the strength of the signal?
So on my way to work, I actually drive Fairview quite often, and being there in person with my phone, I'll go from 4 or 5 bars of service. When I'm there, it's 1 or 2. So that tells me that strength of signal there is not great.
Now, turning back to this location data from Mr. O'Keefe's phone, you mentioned that
Well, Albert did say his house was a dead zone.
Yeah.
It has a certain accuracy and it was traveling a certain speed, correct?
Yes.
Now, what, if any, speed is recorded in this location data between that 12:25 a.m. and 6:15:36 a.m.?
Your Honor, may I just
Yes,
read? Thank you.
yes.
So the state's saying that he could have been shaking his phone, arguing, moving his phone in his hand while they're driving down the road, and that would account for the
What time
steps.
frame exactly are you looking for?
What I'm asking is, what, if any, speed was recorded by the location data between that first 12:25:36 a.m. and 6:15:36 a.m.?
Oh, I'm sorry. I thought you were asking for before that. No, there's no real speed registered until the phone is found the next morning.
And so that would be at the 6:15:36 a.m. time frame, is that correct?
Yes, that's correct.
And what speed is recorded at that time at 6:15:36 in the morning?
It shows 0.24 meters per second for speed, and then with an accuracy rating of 7.58 meters, which is 24 feet.
Thanks. Now, sir, if I could turn your attention to May 8th, 2023, where did you go with relation to this investigation on that day?
I went to 34 Fairview.
And who, if anyone, went with you?
Trooper Proctor.
Now, what was the purpose of going to 34 Fairview Road on that date in May of 2020?
We wanted to take measurements of where Officer O'Keefe's body was found, and then basically a diagonal straight line to the door, how the distance that would be.
And what, if any, tools did you bring with you, and what, if anything, did you use in the course of this analysis on this day?
So I loaded in the GPS points into a program that the CERT team uses called StarTopo. It's a GPS mapping program that you can view through an app. So that way I was able to see exactly where I was via the app. We also used one of the big long tape measures that's in like the big thing that would get us, from where we believed his body was to the front door.
And from that, as far as the determination of where Mr. O'Keefe's body was located, what, if anything, did you use to determine that?
As I said before, the video, photos and video from Sergeant Good of KNPD and the KNPD cruiser cam video.
So the cruiser cam video that from Officer Sarah's cruiser, is that correct?
Yes, that's correct.
The one that shows where Mr. O'Keefe's body is when Officer Sarah arrives on scene, correct?
That is correct.
Now, with regard to those particular GPS points, what time frame did you start as far as your mapping was concerned?
We took the last, we mapped the entire route. So at the waterfall bar and then on from their drive on Dedham Street down to 34 Fairview.
And as far as these locations, how were they measured as far as what kind of measurements were you using in order to plot those points?
We loaded into Google Maps and just able to show it with a KMZ file to show exactly where he went.
And so what I'm asking is, as far as the GPS locations that you were recording, how were those measured as far as longitude, latitude? Is that how they were measured?
Yes, I'm sorry. Yeah, latitude and longitude.
And you started with Mr. O'Keefe at the Waterfall Bar in Canton. What time was that, if you know?
12 a.m. was the last point.
And then that time frame when Mr. O'Keefe's native locations are putting him in the area of 34 Fairview Roads, when was that first time frame?
The time he arrives?
Yes.
Yeah, about 12:24. I forget the seconds, but 12:24 a.m.
Now, eventually, when you had all of these points as far as the direction of travel, location data, all of those things, what, if anything, were you then able to do with those GPS locations?
I cross-referenced them with his health data and also mapped it out to see exactly where he would be.
Now, with respect to the data that you were able to recover, if you could describe to the jury sort of the path of travel, starting with the waterfall as far as where Mr. O'Keefe's phone was, where it traveled in it, and where you noted it at various time points along that sequence.
Okay. So, as I said, 12:12, it's at the waterfall bar. Then there's a 7-minute break in location data. When the phone comes back up with location data at 12:19, as I said, he's by Dedham Street and Cedar Crest Road. At 138 Dedham Street, right around there, 12:20 a.m., 34 Fairview is put into Waze. He then proceeds down Dedham Street, takes a left onto Oakdale Road. That goes to the end of Oakdale, takes a left onto Maplecroft. As he's going by Maplecroft and Pinecone Road, right around 12:22 and 14 seconds, was a data point listed that he's ascending, descending the stairs. So he's over a half mile away from 34 Fairview at this point. They go down Maplecroft, take a right onto Cedar Crest, all the way down Cedar Crest. They do not turn onto Fairview Road. It goes by Fairview, does a 3-point turn or turns around somehow, and then goes back to Fairview and takes a right, where it finally stops between 34 and 32 Fairview.
So at the time that health data is being recorded, and you cross-reference the GPS data with the health data from Mr. O'Keefe's phone, correct?
Yes, that's correct.
And so at the time that the phone has that recording of the health data of descending, and is it ascending or descending, or how does that read in the health data?
I have in my report, and that's what's copied from the thing. It's ascending/descending stairs.
And at that point in time, cross-referencing that health data with the GPS location, where physically is Mr. O'Keefe's phone at that particular time frame?
Maplecroft by Pinecone Road, right at that intersection.
And has Mr. O'Keefe's phone arrived or been in the area as far as the GPS, specifically of 34 Fairview Road?
At that time?
Yes.
No, not at all.
And so from the GPS locations that you observed of the defendant's phone, initially the phone passes by Fairview Road and then reverses direction to come back, correct?
Yes, that's correct.
And then as far as between 12:25 a.m. and 6:15 a.m., there's no movement of that phone, correct? What, if any, movement did you observe following 12:25 a.m. until the period of 6:15 a.m.?
None until it was found at 6:15.
Now, you mentioned that you took a tool and you did some measurements as well. Is that correct?
Yes.
And were you able to ascertain then some GPS locations for where Mr. O'Keefe's body was found?
Yes.
And what, if any, measurements, excuse me, the accuracy of those GPS measurements and latitude and longitude, what was the accuracy of that?
Can I read the exact? Okay. All right. So from 12:25 and 30 seconds to about 12:35 and 36 seconds, the GPS accuracy is tight on him for the first few seconds and then blows out and encompasses pretty much the neighborhood, 34 Fairview, 32, 31, and I'll read the exact. It's 12:25 and 30 seconds. It has a 33-meter degree of accuracy, which is about 100 feet. That area encompasses 32, 34, and 31 Fairview. 12:25, 31, it's 200-foot measure of accuracy that hits 31, 32, 34 Fairview, basically almost all the houses around. 32 seconds shrinks back down to 95-foot level of accuracy, hitting 32, 34 Fairview and the front yard of 31. At 33 seconds, it's 88 feet, again shrinking back in as the signal gets better, covering 32, 34 Fairview, 72 feet at 34 seconds, 59 feet at 35 seconds, and then 52 feet at 36 seconds. So, as I said, signal weakens, it blows out, and then as signal gets stronger, it shrinks back in. The GPS coordinates themselves are all still right where Mr. O'Keefe's body was found.
And so as far as, if I can take it back just for a second, the initial GPS coordinates that you marked as far as where Mr. O'Keefe's body was found, how accurate was that measurement as far as to itself where it was?
From what we had and then where we marked from, we believe we're in about 3 feet because standing there, even with the app, it's not perfect. I'm not getting a direct saying that I'm right on it. So we believe we're within about 3 feet of exactly where he was found.
And from that air distance of within 3 feet of where Mr. O'Keefe's body was found, how far was that, or how far did you measure that to be from the front door of 34 Fairview Road?
In a direct straight line to the front door, 72 feet. Not accounting the stairs.
Now, from your review of that data that you were talking about from that 12:35 and 12:25 and 30 seconds through 12:25 and 36 seconds when it fluctuates, what time period of that is, or what time period of any of the times that you observed is it possible that John O'Keefe was actually anywhere near 34 Fairview Road, the house?
Objection. Ask it differently.
Within those fluctuating circles of GPS data that you were talking about, what time period did those encompass the actual inside of the residence of 34 Fairview Road?
It's about 3 seconds where it actually encompasses the inside of Fairview. That fourth second, it's right on the edge of the corner of the house. And then the fifth and sixth second, they're just showing the front yard.
And that time period, as far as those GPS data from those circles, with reference to the following time periods after those, what, if any, based on your training experience, what, if any, opinions were you able to draw from sort of that date?
So he would have to go from the GPS point that's listed. It would take him, a second and a half to get to the house, and then a second and a half back where his body was found, where his phone was underneath him. He'd have to go about 48 feet a second when I did a velocity calculation, which is about 32 miles an hour, a second to the house, a second back. There was no GPS points ever showing inside the home, the backyard of the home. There's no lat and long listed. It's just the degree of accuracy from the GPS signal.
So the 72 feet from where Mr. O'Keefe's body was found to the front door of 34 Fairview Road, in order for him to be inside of 34 Fairview Road during any of those measured timeframes, he would have to travel 72 feet and 1.5
The objection sustained. The objection sustained.
Sir, again, if I could ask you from Mr. O'Keefe's health data, as far as his specific physical location at the time that it indicates ascending and descending, how far away from 34 Fairview Road was it when it registered that?
It's over a half mile away. So Maplecroft at Pinecone Road.
In your opinion, sir, at any point in time from the data that you reviewed, did Mr. O'Keefe enter 34 Fairview Road?
I'll sustain the objection.
Mayor Pro Tem?
Yes.
Well, we know that the state established the timeline the defense is talking about, a 12:20-ish arrival time to the residence is not right. They confirmed that the clock at the waterfall is correct, and you can see them leaving. So I think they're doing a pretty good job on identifying what these steps were, at least throwing it out there. I don't
Look
know.
up when you're finished.
Yeah.
Okay.
You recognize those, sir?
Yes.
And what do you recognize those to be?
These are the plotted points I did through Google Earth, the maps, and then through LexisNexis, the track system, the GPS range and coordinates.
And the LexisNexis track system, if you could explain just a bit to the jury as far as what that is and how it's used to create these documents before you.
It's similar to that Sartopo program I used. It's a desktop-based GPS program. You put the points in, and then it will map them out and create, like I said, a KMZ file for you, so you can load it into Google Earth.
Yeah, Pro Tem.
Yes.
Almost the teaching.
Okay.
Objection.
Thank you.
6:30.
May I return to the witness, Your Honor?
Yes.
With the court's permission, may I publish this, jury?
Yes.
Ms. Gilman, if you could take that down. May I have a moment, Your Honor?
Yes.
May I stand up?
In fact, Trooper, if you're more comfortable standing for some of your testimony, you certainly can.
Thank you, Howard.
Gilman, if you could enlarge that just a bit. Thank you. Now, Trooper, there should be a laser pointer up on the stand before you. If you could.
We got Dante with us this morning. Good morning, Dante. By Google Maps, the house is 50 to 60 feet from the
Again,
road.
if you could just explain to the jury sort of what we're looking at in this slide, and then using that laser.
I've got a few
pointer
comments
to
about them using the
direct the
GPS.
jury's attention to what, if anything, of significance you have in this particular slide.
So I took an overview of the town of Canton. So this here is the GPS route. And then down over, I can barely see. Let me just look on the map here. It's not much better. The waterfall bar is right up, I can't really tell honestly from this, but it's on Washington Street. That's it's down here. I'm sorry. That's why I included an overview of everything so you could see the
Yeah, it's about as
full
accurate as
range
your
from the time period with that GPS locations.
crime
When
scene
it's-
markings.
If I may,
It's
So
somewhere
when
over
it's-
here.
if possible, I don't know.
Keep your voice up.
I don't know if this is going to work any better, but if I could ask if we could turn the lights back on just so the witness can see
Sure.
what's before him and then.
We got Big Ron wishing everyone a good morning. He's got some wise advice. He says, please don't forget to like and share. To stick it to the algorithm. I agree with you, Big Ron. Everybody, give us a repost and a like on this, and let's stick it to the algorithm.
Indicate again what we're looking at in this.
Yep.
And let
So
folks like Turtle
when you
Boy
zoomed
do
in,
this
it
out
actually
on,
closed it up. But it's
viewers.
down over here is the waterfall bar. There's a couple of points there listed. And then right around here is when the GPS tracks go and their route, once Waze is activated, down to 34 Fairview. There is a zoomed in version of by Fairview.
And Ms. Gilman, if I could have the next slide.
So
Sir, what are we looking at in this slide?
Yep. So this is the track. This one shows the 12:22. 12:22 and 14 second GPS point where right here where the little arrow is. That's exactly where they were when the phone is registering the ascending, descending stairs, like listed in Cellbrite.
If you could, using that laser pointer to illustrate to the jury where that point is in relation to where 34 Fairview Road is.
Yes. So this is where they were with the ascending, descending stairs. They would continue down through this little piece here, take the right onto Cedar Crest. They continue down Cedar Crest, missing Fairview right here, and then turn back around and then come to the house.
And Ms. Gilman, if I could have the next slide. And Trooper, what are we looking at in this slide? And specifically, if you could explain to the jury as far as the blue circle with the attached to the
If you
Lexus.
could look this way, please.
Attached to the LexisNexis tracks, if you could explain to the jury what that is and what that signifies.
Yeah, so as I said, we loaded this in through LexisNexis and it gave us the GPS points for the route. The point is 348. I just want to double check. Yeah, point 348 is at 12:25 and 30 seconds. The blue circle is the estimated range, so how well the signal for the GPS is. And 34 Fairview is right pretty much by that L.
Gilman, if I could have the next slide.
Yeah, you know, pretty much by that. These graphics are
Yeah,
crap.
there we go.
Dante says, when he said the accuracy fluctuates, would that be similar to having a bad signal, then the signal getting worse as you enter a physical
That's correct.
structure?
This is 34 Fairview right here,
You're seeing
32,
it there.
and then again, this is where all the points are for the duration.
Dante, you're seeing that
As far as
circle.
the
That's the
blue
plus or
circle
minus
that's up on the
accuracy
screen, what
because
does
of
that
weak cell phone
represent
signal.
as far as this particular point in time for this GPS point 348 at 12:25 and 30 seconds?
Yes, this is as I said before, the range of accuracy due to satellite strength. So as I said, it blows out as it loses strength, and then will come back in as it gets
Well,
better
inside the house is
signal.
that range for the GPS. So how can you say you're in the house?
But remember, folks, this is the same GPS signal and strength that they use to mark evidence that could be inches from each other to determine where it's at. That's why when we
Same
saw,
area where the 348 is. This is part 351. Again, as you can see, strength of signal blows out and encompasses almost the whole neighborhood. All the houses around.
And Ms. Gilman, if I could have
when
the
they
next slide.
labeled where the evidence was, they used the GPS. That's why when we had the CERT guy on there, the lieutenant, where it was literally all the evidence was one dot. There was one dot near the
Yes, it
roadway
is.
in the front yard, giving no detail whatsoever. This is almost no different.
Same thing, just the degree of accuracy and the strength of the satellite signal to Officer O'Keefe's phone.
Ms. Gilman, if I could have the next slide. And again, sir, if you could explain to the jury what we're looking at in this slide and what time frame we're talking about.
Yep, this is point 349 at 32 seconds. Again, latitude and longitude, they're all right in the same area. And that's that.
Ms. Gilman, if I could have the next slide. Again, Trooper Guarino, is this the same GPS plotting point in the same time frame of 12:25?
James is saying
Yes, it is.
that this is the same action. You know what? The phone could be in the house. You guys are right. The state can't say otherwise. The defense can't say it either. It could be anywhere within that blue circle.
So again, the accuracy blew out as it lost signal, and now it's shrinking back in as accuracy gets better.
Gentlemen, if I could have the next slide. And sir, what GPS point or what time frame are we looking at in this particular slide?
It's 12:25 and 33 seconds. Again, same area, lat long, right in the yard of 34 Fairview.
And Mr. Gilman, if I could have the next slide. Trooper Guarino, is this the same GPS point of number 348 and 12:25 and 33 seconds?
That's correct.
And again, if you could explain to the jury as far as the accuracy and what we're looking at in this.
Yep. So I believe they actually wasn't that much of a drop off. Yeah. So it went from 88 feet to 72 feet. So the circle still doesn't look like it really shrank much.
That's after they beat the hell out of him and drug him outside.
And again, Trooper, what time frame and what GPS point are we looking at in this one?
This is 12:25 and 34 seconds. Again, same thing right there, the corner of 34 Fairview and 32 Fairview.
Gentlemen, if I could have the next slide, please.
Hope the jury has coffee so they don't fall asleep during this boring testimony.
You know, this is the same GPS point number 350, 12:25 and 34 seconds. Is that correct?
That's correct.
And again, using that laser pointer direct the jury's attention to what we're looking at in this.
Yep. So 34 Fairview's here. So as I said, this point here is the last one where it sort of cuts out the little corner of the house, but everything's still showing directly. This is where it's believed to be.
Mr. Gilman, if I could have the next slide. What GPS point and what time are we looking at in this one, sir?
This one's 35 seconds, 12:25, 35 seconds. Same thing. Again, GPS point's still saying it's right there where his body was. But again, it dropped from 72 feet of accuracy down to 59 feet. So it's going to show the outside only of the house.
So the signal strength is strengthening at that point, is that correct?
That is correct.
If I could have the next slide, Mr. Gilman. And again, sir, same GPS point of number 346 and same time at 12:25, 35, is that correct?
That's correct.
Mr. Gilman, if I could have the next slide. Mr. Guarino, with regard to this slide, what GPS point is being depicted and what time frame are we looking at?
This is GPS point number 345, and it's 12:25 and 36 seconds. Again, showing that the signal strength has, again, grown and gotten better.
Exactly, Dante. Mine's done the same thing.
What accuracy or what degree of accuracy in feet are we looking at?
This is within 52 feet.
Mr. Gilman, lastly, from this group, the next slide. And again, sir, this is the same as the previous slide, GPS point number 345, 12:25 and 36 seconds.
That's correct.
And again, if you could, using the laser pointer, just to illustrate to the jury what we're looking at.
Yep. As I said, there's any plotted points anywhere other than right in this area for the rest of the night. This is where it stays, and there's varying degrees of accuracy, but there's nothing ever showing it anywhere else in that neighborhood.
May I approach, John?
Yes.
James, I believe they're trying to account for every time the phone registered a ping or a location until he was dropped off in time he was found.
But he's got a point too, because I know on my Life 360, if I lose signal, it'll show me at the last time it registered. But when it picks up a signal, then it'll.
I just gave it back.
If you could take a look at that and look up when you're finished.
Yep.
Do you recognize that, sir?
Yes, this is a second map I created with the Cellbrite locations from their native locations. The previous one was from Axiom. So I used both programs to map it.
Let's get this is any better. The other one sucked.
As I said, Axiom showed movement and degree of accuracy where Cellbrite doesn't. It just gives you the native locations. I use 2 programs so I can corroborate what I'm seeing in one is the same as the other, because if not, then I need to find out why.
And as far as the information from one program to the other program, were they corroborative of each other?
Yes.
May I approach, Your Honor?
Yes.
I'm going to seek to introduce and admit the next exhibit. No objection.
One.
May I return to the witness, Your Honor?
Yes.
With the court's permission, may we publish this to the jury?
Yes, with the lights on still?
I think so.
You got to notice Aunt Bev's not talking about speak up or I'm going to turn the air conditioner off. She's just saying you better speak up because it's hot today, boy.
Now, starting with the first
Yeah.
page that you have before you, first of all, do you recognize what's up on the screen as the first page? Is that
She's like, I ain't trying
Yes,
to
sir.
have it.
And again, if you could, using the laser pointer you have before you, direct the jury's attention to what, if anything, of significance you observe in this first page of this next exhibit.
Yes. So again, this is from the Waze app. They're tracked from 34 to 34 Fairview down Cedar Crest again, returning back here. So that's just the bottom half. I just wanted to get a closer view of where the GPS plots were from Cellbrite.
And the next slide is going to. And again, sir, if you could explain to the jury what we're looking at in this.
So the purple dots are the GPS points and the route taken. As I said, goes up to, I believe that's 51 Cedar Crest, and then reverses back. And then this is the final point. It's right here. 34 Fairview is right here. There's a little yellow push pin on it.
And again, sir, I'm sorry, just from the timing of the plotting of the points, purple dots that you have there, if you could just, using the laser pointer, direct the jury's attention to the path that Mr. O'Keefe's phone takes in reference. If I could ask you first, if you could just illustrate to the jury this particular slide, where is 34 Fairview?
Right here.
And then if I could ask you with the laser pointer to direct the jury's attention to the path of Mr. O'Keefe's phone in sequence, sort of how it travels and arrives at that location.
Yep. As I shown, goes down Cedar Crest, misses Fairview, goes up to here by the house with the pool, turns around, comes back, takes a right onto Fairview, and then stops ultimately right in between 34 and 32 Fairview, where there's like a flagpole and a fire hydrant right there.
Can we if I could have the next slide? And Trooper Carino, direct your attention to this slide. What are we looking at?
Again, I cross-referenced it with the points. This is Pine Cone Road, and then Maplecroft intersects here. And this is the ascending, descending stairs point in his phone. Doing a Google Earth elevation check. There's about a 20-degree dip, and then it goes up. And then as you go down Cedar Crest, the hill is about a 50-foot elevation
Not that
change
yes,
again.
Waze is
So
a
it's pretty significant.
map app or
And so I'm
direction
sorry, sir,
assistant.
as far as
just to
the
be safe.
elevation change that
Very
you're talking
popular.
about, how is that measured and how and where is that in reference to what's depicted up here?
And
So-
James has the proper spelling.
Again, like I said, in this area here, there's about a 20-foot drop. And then as you go down Cedar Crest, that hill, it's about 50 feet. This spot here is the ascending, descending stairs. So as I said before, he doesn't have an iWatch on, so it's not collecting that great health data. It's still acting as a pedometer. So again, whatever movement he's doing is triggering something in the phone as he's ascending and descending these hills. Essentially, it could be tricking the phone into thinking it's stairs.
Ms. Gilman, if I could have the next slide. Is Trooper Carino, what are we looking at in this one?
This timestamp is 12:19, 32 seconds. That's when the phone initially starts creating the GPS points before Waze is activated with 34 Fairview searched. So this looks to be the time Waze is actually opened up.
And so from the purple dots that are depicted on the screen, as far as where is Mr. O'Keefe's phone at 12:19 a.m. in reference to 34 Fairview?
1219 is right here. 34 Fairview's down all the way here. Number, you can't really see, but it's right in the bottom corner.
And the next slide.
This is the same map, but just minus the tracks, graphic.
I'm sorry, Trooper, I lost track of what page we're on. Is there any other pages in that exhibit for you?
No, that's the last one.
May I approach this to retrieve your arm?
Yes.
Your arm, may we approach?
Okay.
So Waze is Dante says Waze is designed to associate your location to a road. Possible data from Waze could be misleading. Hey, you know what? It very well could be, but you've got the phone's internal GPS that's very similar. Doesn't both of those are consistent with each other? I would say. What do you think, John? You think this testimony is worth a damn, or is it just a bunch of mumbo jumbo to the jury?
I think it's a bunch of mumbo jumbo. I think with what he was just talking about with the tracks, with the error of margin, he cannot definitively say that he was never in the house. And let's just say there was an assault inside the house and somebody threw the phone out there. That would account for the speed of the phone. Yeah, I don't give that much weight. And Dante, on Waze, I actually like it better than I do Apple Maps. You can actually schedule, say if you need to be somewhere tomorrow at a certain time, you can plug it in and it takes in road conditions, construction and all that, and it will tell you what time you need to leave to arrive at that time. I like it pretty
We're
good.
going to take our morning break. You of course have to stick around.
I mean, it also does what Waze does is it's kind of a crowd source. Everyone else that's traveling down those roads and their speed and distances, how long it's taking them according to traffic. So it'll gear you to surface streets sometimes. It'll get you there the fastest way is what they say. So,
And the
okay,
thing I
so
like
we
about
think that the testimony this morning was some mumbo jumbo, kind of complicated. The graphics, the state didn't do themselves any favors with the graphics they put up. I'll assure you that. I think. But you're saying that it still leaves room for him entering the house, maybe even somebody throwing the phone outside to that point to explain the data we just saw.
yeah, I mean, like he said, I mean, it may register as steps, but if someone's got the phone in their hand and they sling it, well, there's your 32 feet in a second.
Okay.
You are muted.
Okay. And Dante says, maybe we have it wrong. What's he got to say here? Dante says, maybe we have it wrong. He enters, they argue, he leaves. Jen McCabe sees he left his phone and delivers it to
Huckman
style to the back of his head. Okay, you know what? That's a theory we haven't seen. I'd say that let's run with it. Big Ron and our friend James here, Paul Nias. I think I'm not sure how to pronounce the name you've got on YouTube, my friend, but he works nights and he is enjoying adult beverages right now, somewhere in the northern part of Nevada, in the mountainous area, I believe. So we're having coffee. James is having whiskey, and of course, our good friend, Big Ron, who is a purist when it comes to bourbons in particular, is interested to know what he's drinking. So, he's not going big this morning. He's going Kirkland brand 4-year Irish, although Kirkland brand's not bad stuff.
On a side note, Fox News is airing that shootout with the welfare check that we were talking about before trial started this morning.
I'm sure that's going to hit big news because that's what they're labeling that is a welfare check. They negate the 3 hours prior to that when it was a barricaded person in a standoff that's not responding to police. So the initial call was a domestic disturbance. But I've already had my battles on X with that this morning with folks once again, I'm apologist for police just because I don't just take the headline and run with it. I actually look into it. But the whole story on that is at 8 something in the morning, 8:10 or 8:15 in the morning, they receive a 911 dispatch to a disturbance with firearms where a mother and sister live with a brother, and the brother is uh, threatening to shoot them and kill himself. And they leave the house by the time the police get there because they're afraid of him. And police get there, he won't answer the door. He's not responding, so they kind of back off. And at 9:13, I think is what the time is. SWAT is called to the scene. Negotiators are called to the scene. They attempt to make contact. They do call outs by on the PA. Hey, sir, come outside, talk to us. We don't want to hurt you. And trying to make contact on his cell phone, and he refused contact. And it was at just about noon, I think 11:53 is when they decided to make entry. They don't know if he's alive or he's dead, but they decided to make entry into the home. Once they breach the door, he's inside with a couple of handguns, a knife, and some pepper spray and a bulletproof vest. He returns fire, strikes a couple of officers, injuring officers. They fire back at him. He's wounded, not dead, and goes to the hospital. But the story that hits X and the story that moves out across the internet and the news is police show up for welfare check, breach the door, and shoot the person they were supposed to be checking on. But that's not quite the whole story. But leave it to those to spread it.
Yep. And Big Ron says I'm quiet this morning. Ron, y'all have got me infected with the smoking bug. So I had forgotten also when I signed up for fiber optic, I got a $200 Visa gift card, and it actually came today. So I'm getting ready to purchase me a smoker here probably in the next few days for about $50 out of my pocket.
I tell you what, that's not a bad little smoking tip right there. Get it cheap.
Yeah, between the $200 gift card and the $25 gift card from Lowe's. Yeah.
Now, and for those of you that missed it last night, we did the first episode of a series. We're going to start the Smoke Show with Joe Lanu and the Night Crew. We've got Vet LT3, uh, Bruce Wayne, all my co-hosts. It started with Vet. Actually, it didn't start with Vet. Big Ron. Big Ron's been a smoker with pellet grills for some years, and he's actually quite good at it. Some of his products we've seen on, of course, haven't tasted any of it, but it sure looks good on the pictures I've seen. Man absolutely knows what he's doing, and he does it quite often. But a little conversation I had with Vet, about 3 weeks ago, I guess, where he just made a comment that he was about to smoke some steaks. Me being from Texas, of course, I'm interested. Hey, how are you going to smoke those steaks? He says, oh, I'm just doing it on the grill. It's like, well, that's not smoking, my friend. And that led into an explanation of a side mount smoker to Vet buying a very nice Oklahoma Joe's reverse smoke system, getting that set up. Anyway, long story short, we did our first series last night, went over briskets, bark, and smoke rings, and a reverse smoker versus a straight flow smoker. And we'll do it again next Wednesday. But we're gonna get into chicken, how to smoke some chicken, how to smoke some fowl. And at some point, we're going to get into some tri-tip for you guys on the West Coast on how to smoke that out as well. But it'll be something we'll do at least every Wednesday. If it has some popularity, may do it a little bit more. But go over some smoking tips for beginner smokers. And I would like to see some experienced smoking guys or gals to tune in and give us their tips. Everybody's got tips, and all of them are good. And if we share them, it just makes a better product out there for something's actually quite fun to do. But I say all that to say is John's got a fever. He's not going to get over it. There is no vaccination, or the disease he's got is going to be terminal. He's about to buy his first smoker, and it's going to be game on.
So Ron asked what kind. Ron is the Oklahoma Joe's Highland Offset Smoker and Grill, 900 square inches. So Home Depot has them on sale for $300. And like I said, with my cards, I might be in at about $50-$60 after tax. I don't think
That's a
bad.
deal, man. That's a huge deal. James says he wants to build his own smoker. He wants a reverse flow with an auger that can handle wet wood. So I'm thinking, is this going to be a hybrid between a pellet and a regular wood burning auger? Although I'm sure folks that are listening to this Karen Reed trial do not want to hear about smoking. That's probably a smoke show activity,
Yeah,
folks. So maybe we
sorry.
ought to keep it there. Let's go back to what the testimony we heard. We heard we heard the voice messages, which they can be damning to the defense, but really on the other side too. I mean, who hasn't been in a relationship where they haven't received a text message where somebody said they, or maybe it's just me, that they hate them, in that
Yeah, I mean,
in other nice comments over a voicemail or a text. I mean, I know it's happened to me, but of
oh
course
yeah.
that didn't make whoever sent it to me a murderer.
Well, and that's the thing. I mean, I think we've all had our moments, especially with the exes. Um, I mean, yeah, we don't always jive, but my kid's mom, but I wouldn't. I mean, I wouldn't ever go that far. Um, yeah, just because you have text messages or voicemails or something like that out of anger, we all have said things out of anger. But to the point of, um, I mean, it'd be different if you said if you had something saying, I'm going to kill you or whatever the case may be. But that's why I think we've always said, be careful what you say and what you text. I think we found that out in this trial a long time ago. But I don't think that makes, I don't think that uh, says she's guilty of this by no means.
Well, do you think it helps the state, or is it just a nothing burger?
I think it's nothing because they established way before that they had a rocky relationship. I mean that's been the get go. And when you put Brian Higgins on the stand, and then he testifies as to what all what they done with the text messages and all that, and the kiss here and there, and maybe whatever happened at his apartment or her apartment, wherever it was. I mean, you already know, and O'Keefe knew because he saw him on the camera kissing. So my point is the jury already knows that was a rocky relationship. I think that was just at the end of the day, it was just bad timing with everything going on. So I think they've already established that they didn't have the best relationship. What was
What
the
about
motive?
this? Do
What
you
was the motive? I mean, she has really has no motive.
Okay. Well, let's go to this. Do you think it actually helps the defense that she made so many phone calls trying to find him? If she knew he was dead, I guess you could go the other way with it. She's trying to create an alibi with that, but it could be legitimate. Let's say he didn't die. He was just out with another woman that night. Wouldn't you expect the same kind of phone calls and text messages from the scorned partner during this time period?
Well, absolutely. When they went to Aruba, I mean, there was that allegation, that he had been with another woman. I mean, clearly she's already a jealous girlfriend. And I'll go ahead and say it, she's a narcissist. I see that. But, so for the hearing the voicemail messages, I can see where she could automatically jump to that assumption because he's not answering his phone, he's not answering his text, that he's with somebody else. He's not with her. So she's out of control, so to speak. It's back to your question, does it help the defense? No, it don't help the defense. But I think in the juror's mind, that that's already been explained, so to speak, and I mean, they can still wash that away with a rocky relationship.
I would say it could lay in some juror's mind to say, yeah, that's what I would expect if this was going on. That it actually gives some validity that she didn't know he was dead. She was truly upset, thinking that he was with another woman and not responding to text messages or phone calls. So I say it could play to the defense's favor. I'm really curious to see how the defense does this on cross examination. Um, how are they going to attack one? Now, I will say that this weighs data. And of course, I know everybody in here is going to say, "Oh no, it's bullshit and it's a lie and it's contrived and it's a conspiracy by the CIA and the NAS to convict her." But these ways and this data they're presenting is really not uh, good for the defense. It bolsters the state's allegations that he never made it in the house. It bolsters the state's allegations In fact, both of those, even with the plus or minus, the epicenter on the one that has the very broad circle of plus or minus accuracy is still out by that flagpole, and the timeline seems to match up with the state's assertion.
Oh yeah, most definitely. Yeah, I just, I don't know. I think if anything that, I mean, I get they have to produce it, but like I said at the beginning of the today's trial, I think the jury's already made up their mind. Anything now, unless it's something like real damning, they've already made up their mind.
Well, I'm not so sure. You think you have your mind made up, and you sit there and you see something else, and people will hang on to different things. Just like if I gave a factual story and you're listening to it, there'd be pieces in there that you'd be like, okay, this little point right here seals the deal for me. If I'm saying it could be A or B, and I give you a set of circumstances or facts, there'll be something in there that you'll hang your hat on. We do talk about we want to weigh in the full totality of the circumstances, totality of the evidence before you make your decision, and we do want jurors to do that. But I think human nature is going to stick on one thing that, like for me, I've said it before that if I if I can't get past if I can't buy the fact that police tampered with evidence by planting evidence on that crime scene, then I've got to say she did it. I will say the state is not bringing enough to me to give me a lot of assurances that they were wired tight and that they weren't at least sloppy on that. But it really gets down to it had to be police interference. If she didn't do it, it has to be flat out police interference, criminal police interference of tampering with evidence and planting evidence on a crime scene. The problem the state has is they didn't document that crime scene very well. Even this guy today is talking about, well, we know within 3 feet. Well, 3 feet's a long ways when we're talking about a person's life. When absolutely that little thing he couldn't tell you the name of it, a cloth tape measure would have told them exactly. They could have marked exactly where his head was, exactly where his feet was, exactly where his belt loop was, or his belt buckle was, with that tape measure, and be able to go back to that location at any given time, at any point they ever needed to. But they couldn't do that because they didn't secure that crime scene or didn't document that crime scene and map it out very well, in my opinion. And I'll go back to this CERT team they're talking about. And he says, he's telling us, well, the signal's not good here. It's plus or minus. This plus or minus is, if you think about a regular roadway in front of that house, goes from the roadway to 2 houses, that this person could have been. It almost encompasses 75% of the Albert's front yard when they pull up to the front of the house, this blue circle. Now, he says it in that part. Well, it can't be that accurate. It's this or it's that. But then he goes to the search team that went out there that documented the crime scene that night in the snow, poorly, in my opinion, where they used the same technology, the same satellite technology, the same satellite strength to mark where his body was, where his cell phone was, where the fragments of glass were found, where the fragments of tail light they claim were found. But think of the accuracy. That means that his body, the tail light, everything that I just mentioned could be anywhere at any given point within 75% of the Albert's front yard and about 30% of the street. They could be there too, according to the way they documented that scene. So I will go back to say is that it's going to be it's real hard for me to trust the state's case, because even if they say it and they really really believe it, I don't know that they've documented well enough to be able to tell me or tell a juror exactly what that scene looked like and exactly what they found there. I think that the state is really screwed, and law enforcement in particular, has really screwed the pooch on this one, making it difficult for jurors to determine.
Yeah, and and I was thinking about this last night. I am very surprised that they do not have, or at least they didn't use it, the 3D laser scanner. I mean, I've seen agencies, like local agencies, that don't even have a lot of tax base, have 3D laser scanners. You come up on a crime scene, whether it be inside or outside, you set all that up and let it scan. That way you've got everything documented, like you said. You know where the body is, you know how it's positioned, you know which way it's facing. where tail light lenses are. I mean, the whole 9 yards, shoot, whatever. Um, I'm just surprised that if they do have it, why didn't they use it? And if they don't have it, why not? I mean, you're in charge of investigating incidents like this. I I thought about that last night.
Yeah, it's poor, and I'll even say that the graphics they're producing here in court are pretty bad. There's not a lot of professional. It's not clear what you're looking at. The big box there with the tracks box. That's kind of what I say out of the box with the Lexus Nexus system. Um, you could do better on detailing that. There are many other ways you could show the jury what this route was instead of what they did. I just don't know that there's a lot of professionalism, and it's kind of shame. It's odd to say that on a state police level. So
Yeah.
difficult, difficult for a jury. I would say it's difficult for a jury because you want to go. You want to trust your law enforcement. You don't want to have a crooked law enforcement serving in the area that you're in because if you're a jury, they're serving your area as well. Um, I just don't know. I just don't know about that. I would say that I'm still standing on at worst case scenario is a hung jury. Best case scenario is going to be for the defense is going to be an acquittal. But I think a hung jury is highly likely.
Yeah. Um, I'll hold that at number two. Number one, I'm gonna say not guilty.
So you're hanging on not guilty. So nothing that the state's showing you at this point could sway you.
Not at this point. No. I mean,
Even the GPS data there, because you're familiar with that type of
yeah.
data. Even that GPS data there doesn't sway you at all. You're saying that they could have
No.
thrown the phone into the yard, and that's how it got to where it's at. And they just remembered where it was at, so and they went out and put his body on top of it. Is that
Yeah, because I mean, they can't say how the phone got there. I mean, yeah, you've got a documentation of the phone traveling 30 some foot in a second or a second and a half. Um, I mean, yeah, you could throw it. I don't even see if she was going what 22 miles an hour and hit him. I don't see him moving that fast. Even if that was even feasible to knock him that far, I don't see it. I don't see it going that fast or
well? I
him going.
think you have to question the distance traveled. Um, I think you have to question it with the same accuracy of that big blue circle. That's how it would determine that. And with that big blue circle is saying is that that's the degree of accuracy that the phone is able to calculate with the GPS data um, as to where its location is on the earth. So it's like, it's somewhere in this circle. It could be in the center. It could be off to the left, right, top, center, 9 o'clock, 3 o'clock. It could be anywhere inside that circle. So to me, in 1 second, it would be very difficult for that phone to, with that type of accuracy with GPS data, very, very difficult for that phone to calculate exactly how far it was traveled. I think that's
Yeah.
mute.
Well, and then you've got the big circle where he even says, this is the I mean, it can go out this far. And when it first starts out, I mean, he could very well have been in that house. Who's to say that he wasn't on the outside of that perimeter? They're saying he was, closer to the middle of that perimeter. Well, you've already established that it's a weak cell signal, and I think it might have been Dante said that it's you've got a good cell signal and it locks you in at X, but then you lose that signal. It's still going to show you at X, but you may be back over at B. But when you get a new cell signal or a better cell signal, it updates and shows you at B. So yeah, I guess if you understand how phones and technology like that works, you debunk that right off the bat. But if you don't, then I guess you can take that to the bank.
Well, now I'm not going to use take to the bank with anything the state has put forward. The state is sloppy on this. Yeah, there's nothing I could really hang my hat on this. The whole thing's a problem for the state. which is good for the defense. The defense is not hard. I mean, the defense is really, guys, are only looking for reasonable doubt. That's it. They're not trying to prove who did it. They're not trying to solve the case. They're not trying to see an indictment of any other party. They're just trying to see that their client is not convicted by that jury by the evidence the state's put on. And I say all this now. Remember, our defense team is not dumb when it comes to technology. So we may have some.
Yeah, I think Alan's going to eat that up. I think he's going to debunk all that. I mean,
Well,
like the range.
I mean, if he's got, I think he will absolutely get up there and talk about the unreliability of it because of the poor and weak signal. I think he will capitalize on that. But he could have a ace up his sleeve. He could have some sort of expert opinion that's in his hat that he could bring out to refute some of this information. I think it's strong for this. I think that let me say this. I think the testimony this morning is not weak for the state. The problem is that it may be some good testimony on top of some real shit testimony, making that very difficult for the jury to swallow. Which goes, I guess, back to your point: is the jury's convinced already?
I don't know. I may be wrong. I've been wrong before. So. But yeah, it's supposed to. I looked a minute ago talking about the weather up there. It was already 86 degrees up there a few minutes ago. So the temperature is climbing.
Dante has switched to the Cool Gang stream. He's talking about us. I know he is. And if you're not, don't tell me you're not, Dante. I'm going to go with it. You're talking about us, that we're the Cool Gang. Which you're right. We are 100%. Yeah, it's supposed to be really hot. It's been real hot on the eastern seaboard. Folks aren't used to it up there. There's a lot of homes that don't have air conditioning at all. But evidently this courtroom does. It has a very industrial style air conditioner. It's very loud. But we haven't heard Bev threaten to turn that air conditioner off today. She's just been snapping that whip. Face the jury and speak up. She hasn't mentioned I'm going to have to turn off the air conditioner. She's like, I'm going to hold you in contempt and put you in jail because it's too hot today to be talking about turning off the air conditioner.
Yeah, it is 87. Supposed to get up to 95. Yeah, I don't think she's going to be threatening that today.
Hadn't heard it once. Out of old Aunt Bev. Now go back to the voir dire, as they say on the East Coast, to speak the truth. That was on Tuesday. She leveled in and gave the defense some wins on that. She is going to allow the animal expert to testify, but only on animal experts, which I don't disagree. This lady's expertise in an emergency room was some years ago. She went to the police academy in the 70s, and I didn't want to say anything during the show, but the police academy someone went to in the 70s is not what modern police work is today. There's so many things that's happened in law enforcement. Evolutions literally in law enforcement that have happened since the 70s. So I kind of agree with the judge's decision on that, that she can talk about the animal bites. That's her wheelhouse that you could consider her an expert in. I don't know that she has relative knowledge or that could be considered being an expert in modern either emergency room medicine or law enforcement techniques. So I think that's a win straight up for the defense. And I think the defense knew that was coming. Alan Jackson, I think, even kind of acknowledged that or capitulated to that on Thursday. The other one is it's a win for the defense, but it's a so-so as well. They're going to reduce the biomechanical engineer. She says they cannot testify about medical injuries or what could have caused a medical injury. She is citing some law or some criminal code of a procedure in Massachusetts that says that only medical doctors can testify as to what caused injuries or what injuries may have been caused by or opine, as she said, about these injuries. I believe we're going to see Alan Jackson come back and refute that because honestly, a doctorate in or a PhD in biomechanical engineering, that's literally what they do. They break down the mechanics in the uh, sequence of how injuries occur, what causes said injuries. This guy has actually testified in numerous cases. He talked about the one where the husband claimed the woman fell down the stairs, but it was a homicide case, murder case. He claimed that the woman fell down the stairs. They were able to prove that the injuries were inconsistent with a stair fall to the point that they obtained a conviction out of that. I mean, this guy's literally testified against that, and probably more so and with more authority than even maybe a local medical examiner. This guy's not a cheap guy.
Yeah, is that the Wolf guy? Last name Wolf, or is that the other guy?
It was the other guy. She had no issues with Wolf. Wolf can testify to the full
That's
scope
right.
that the defense wants. I can't remember the other gentleman's name, but he was the second person on the stand on Tuesday. If you were watching, that person is going to be restricted to mechanics, but not the biomechanics that I think they really wanted him to testify to. But I don't know I don't know that fight's over. That Alan Jackson, I think, has some good legs to stand on. He's accepted in federal court. I believe, he's even certified as as an expert witness in federal court to testify on exactly those things. Now, if there is a law in Massachusetts that says that, he may lose it. But I think I think it's an absolutely good objection, and it should go on the record that the defense objects to that.
Yeah, yeah. Be interesting too to see what order he calls them.
Vet says the animal expert is going to be damaging because that shows she was in the backyard or in the house one. I don't disagree with that. That jury's going to have to believe her. And that's the other thing too. An expert witness, the jury say, yeah, whatever. They're not a material witness. They weren't there to actually see it. They're only going off their expert opinion is literally what you're listening to. So I'll say that experts in trials have a mixed bag. It really depends on how well that expert is and how well that expert comes across. I'll say the last two from the ARCA group, they testify well. Those guys know what they're doing. I'm not so sure about Grandma. Grandma seems to might have some issues.
Grandma's smart though.
I'm not saying she's not smart. I just don't know that she'll come across as indisputable to a jury. But I may be wrong. She may come with her big guns. She's testified before. She knows what the game is, and she's happy now that the court's deemed her to be qualified as an expert in this trial. That she's going to get paid. She's happy about it.
Oh yeah. Now my understanding is she was flying back, so they're going to have to. I wonder when they're going to call her because they're going to have to fly her back out. I wonder when she'll take the stand.
Yeah, it's not a problem. That'll be coming out of Karen Reed's pocket as many times as she needs to fly, her hotel room, her rental car, or Uber as she gets here, and her food. And believe me, Dog Lady hopes they keep her up there 3 or 4 days. She's going to charge you per day she's on the stand. It's going to be expensive. Which is exactly why we talked about that on Tuesday. It's exactly why the judge was asking about who contacted who. Um, it gets a little hinky when experts like contact the attorney and try to insert themselves into the case because there is financial gain for these experts. They're not doing it for free. Oddly enough, the ARCA guys, I believe, are. I believe they volunteered their testimony, and this is, of course, I'm getting this from what Kingdom has said, that they volunteered their testimony, but they were literally hired and paid for by the Justice Department to look into this accident. Now, according to Kingdom, is that they've 100% said there's 0 chance, 100% 0 chance, no way that these injuries were sustained by this vehicle, and there's no way the vehicle could have done what it is the state asserts. I haven't heard that, but he says that's what they say. Now, they did testify in a grand jury, a federal grand jury, but the results of that grand jury are sealed and have not been released. And I'm not even sure what the scope of that grand jury is, what they were looking at, unless it's got to be some sort of a civil rights violation on the behalf of law enforcement is when the the feds would get involved as far as the Justice Department. So that's another curious portion about this that we don't know. And of course, the jury knows nothing of that, or it's not supposed to know about anything like that. It won't come up in this court. You won't hear these guys get up and testify that it was they were hired by the Justice Department one time. I believe that will be narrowed down in scope from the judge. But that is an interesting one, and that's unusual. Usually, these experts are paid, and there's a great incentive for for an expert to get on a stand and say what the person paying them is wanting them to say. Because obviously, if you're going to say something different, they're not going to pay you. They're not going to put you on the stand.
Yeah. I'm sorry. I was doing some research on Marie Russell. That's her name. She's got her LinkedIn is quite impressive.
Oh, I'm sure she's got a long history of doing stuff. That's taking us back to smoking. He says, not bringing it back to smoking, but he is. But I'm cleaning out the grill plate and the smoker box. No one tells you how much work it is to make sure it doesn't rust. Well, that's your problem, Vet. You're worrying about it rusting. I don't worry about the rust on it. Put a little heat, a little oil, scratch it a little bit, and then go back to cooking. But I know it's brand new. You want to keep that bad boy shiny. It is going to take you some work to do it. Now, over time, you should start to season those grills a little bit so they don't rust up.
So, what do we take out of the Celebrite data after these guys have already just finished up with the other stuff? Does that, you think the jury still keeps that in mind when they're trying to figure anything out? As
I
far
think
as the
so. I think they'll weigh the Celebrite data. The problem is the state is just not very clear on how they presented it. The state's case is muddy. It's not like the defense jumped in and stirred up the waters. If there was no examination on anybody that's testified on Celebrite data or cell phone data, in my opinion, the state's made it very complicated to follow. There is some questions about the Celebrite, and there's questions about the how long to die in the cold. After hearing it, I don't believe that how long to die in the cold was done at 2:27. I think in the morning. The explanation does make sense. That it doesn't. You would have to see a delete log, and since you don't see a delete log, then it wasn't deleted. And that's the problem. Is the state wasn't clear with that. You have to really read between the lines, and you have to really listen very, very diligently and try to pick up on what these folks are saying to understand that if you have a deletion, you have a search, and then that search is deleted. You should see it in three places on a phone, three different logs and databases that are kept internally on your phone. And they're saying that it's only in one location, which can be explained by the same tab being used to make multiple searches. And it will show what time that log shows what time the tab was opened, and it shows as the last search. I could have made 30 searches in there over a 24-hour period. But if that's when you go back to look at it, it'll show my last search at the time the tab was open, which is a bit misleading. But if that search had been deleted and the tab remained open, which is what the defense is asserting, then you would go to two other logs that will show where that event happened, that it was deleted. One deletes it or prepares it for delete. The other one it puts it in a location where it's not necessarily sometimes deleted, but it's okay to overwrite is what it means. Sometimes when you delete things, it doesn't really go away. It just puts it in a place that when you need space, you can overwrite this file. You can overwrite that file, and it does free it up as free space in your phone or your computer. So, I would say what the state is saying is if the assertion is correct that it wasn't in the two delete and overwrite log, then that search wasn't made at 2:27. But was that clear to the jury? I don't think so. It was clear as mud, I think, to everyone else, and I think they brought too many experts in to try to explain that, and the ones they did were talking over people's heads, in my opinion.
Yeah, I agree. It's like too much information.
Too complicated as well. DNA can get that way. You get these really smart guys up there. They use the big words and they get very complicated. They want to go in way too much detail on some of the forensic side of it. It kind of just gets people lost. Where and what juries will usually do, if it's too complicated, just all that goes out. That just never gets weighed in the decision. They're going to find something else to hang their hat on. Uh, they just won't try to go down that road. And then sometimes you'll have some really smart guys that sit on the jury. When they go back into deliberation, he'll break it down to them in simple terms and make them understand, okay, this is what they're trying to say here. And they'll start asking questions. Can we see the rewatch the testimony of this trial here or get the transcripts from this testimony from this person? We've all seen the jury asking questions. That's what they're doing. They're examining things. And the reason attorneys really like to know what the jury's asking for, it gives them an inside window into what's interesting to them. What piece of evidence are they hanging on, or what piece of evidence might be the linchpin to get the decision to go the way whichever side it's wanting. So I think the state's its own worst enemy right now.
Yeah. We shall see.
You know what? I'd like to hear from Dante, Vet, and all these other folks about the cell phone data testimony. I think Dante's heard it. I know. I think Vet's heard some of it. I think even Big Ron's heard some of it too. What's your assessment? Is it was it strong for the defense, or was it strong for the state, or did it make sense to you? Maybe that's a good question. Maybe you can post up a comment and we can take that conversation on.
While we're waiting on him, so K-Dog is monitoring from afar, but he posted about an hour ago. Turtle Boy asked Alan Jackson if he knows why state police / Westfield State phone expert Nicholas Garino didn't find Jennifer McCabe's 20 deleted phone calls or any Google searches when he extracted her phone, which would have made a grand jury less likely to indict Karen Reed. So he asked Jackson about it, and he said, "I've got a lot of ideas." So, but maybe that ship's already sailed, though, hadn't it? At this point.
Yeah, it's hard to tell. I don't know.
All right, so Ms. Gianetti, did
just
that
don't
give
know
you
about
enough
that.
time?
Oh, I had enough time. Yes.
Okay. All right, so Ms. McLaughlin, why don't I hear you just briefly? If you could frame this, or Mr. Lally, whoever wants to.
Oh, we got some more lawyer business.
Yeah, sure. The Commonwealth is moving to introduce a Google search the defendant conducted at 1:27 p.m. on January 29th, 2022. The Commonwealth would argue that the probative value of this Google search outweighs any prejudice to the defendant. The search in question is at 1:27 p.m. before the defendant had spoken to law enforcement. She conducted a search for DUI attorneys. The Commonwealth thinks that this is appropriate for the jury to hear, as it rebuts the Bowden defense that the defendant has laid out. Not that she did not intend to commit John O'Keefe. The defense has been that the defendant is essentially what's been represented in opening court was framed that she had no intent or opportunity to commit these crimes. Further, that she was not intoxicated at the time. So the Commonwealth feels that the probative value significantly outweighs the prejudicial value. It goes to her state of mind at the time that the search was conducted. Further, it also rebuts that there was any impropriety in the police investigation, or that, as the defendant has put it, that the police did not search any or investigate any other potential culprits. It also would go to the defendant's consciousness of guilt at that time. This statement is before she voluntarily gave an interview with law enforcement. It goes to her state of mind prior to that interview. And so for all those reasons, the Commonwealth would suggest that that Google search is appropriate, and it's not a typical case where it's an invocation of counsel where law enforcement had not engaged her, and it goes to her state of mind at that time prior to any police involvement, and further to rebut that there was any improprieties in the police investigation, or that they should have investigated anyone else.
All right, and I appreciate, Mr. Lally, you bringing this to our attention to give us time to look at it. Ms. McLaughlin, I appreciate that you provided a very strong limiting instruction proposal. I'll hear you, Ms. Tianetti.
Thank you. Your Honor, you had asked that that I produce proof of the phone call from Michael Proctor to my
Oh,
client.
I didn't say proof. No, I asked if that was coming into evidence.
Okay, well, I'd like this marked for identification for the purpose of this argument, if I could.
Sure.
Show counsel.
Okay. They're trying to get in a 127 search by the defendant.
Okay.
Yeah. They're throwing in some wild cards.
So let's have it marked for ID before I hear you any further. So Madam Court Reporter needs to mark it. All right, and if I may have that. Thank you very much. Just give me a minute, Ms. Gianetti.
Big Ron says the
All right, so
cell
this
phone
is
GPS
just that
was
a call
bullshit.
occurred, right?
That a call was made from Michael Proctor's personal cell phone number. You can see the last 4 digits there, to my client at 1:19 p.m. on January 29th.
Okay.
Approximately 8 minutes before she calls to investigate a potential DUI attorney.
Okay, so focus on the law for me and tell me why I should exclude this.
Of course, yes. With regard to the cases that the Commonwealth has cited, I think the court has seen, one of them is an unpublished opinion, the other is a homicide case. They couldn't be more distinguishable from this case. With regard to the unpublished opinion, that appears to have been a gun charge where the defendant in that case did a search for a 9mm handgun on his cell phone. He did not ask for Google or search in Google for a handgun attorney. He made a specific inculpatory search that the court ruled was relevant, and it was not outweighed by the danger of unfair prejudice. In this case, we have a person being contacted by the police and then doing what a citizen has every right to do, which is to look for an attorney for representation. There's zero probative value to that, other than she's presumed to be innocent and she's seeking an attorney to defend that presumption of innocence. That's it. There's zero probative value. But there's an extreme.
Did I miss the time? Is this AM or PM, the search?
Your Honor, the
I
instruction that the Commonwealth has
understood it to be AM, but maybe I'm wrong.
asked this court to instruct the jury whether her action in doing an internet search
Or maybe
for
it was
attorney
PM.
indicates feelings of guilt by a defendant. I can't even believe that argument.
So let's just focus on the law.
I'm trying to, Your Honor. I'm
All right.
flabbergasted.
So what I'm going to do then is I'm going to stop you. So on the balancing act that I have to do, I find that the probative value is outweighed by the prejudicial impact. All right. So I'm not going to allow it in, Mr. Lally, in your case in chief. Now, if you feel that through this witness or through any other witness, Mr. Lally, that it then is admissible, I just ask that you come to sidebar beforehand.
Absolutely, Your Honor.
Okay. All right. Let's bring Trooper Garino back in, please.
I believe that's a win for the defense. If
Yeah.
that search was in the
Yes, please.
PM after all this has gone on, of course she's looking for attorneys.
Oh,
Come
yeah.
on. Yeah, I agree.
And that's why I say maybe it is PM, because it was right after a phone call from Proctor. I don't see Proctor calling her at
Yeah,
1:20.
no, I do swear that the state said 1:27 a.m. because I got my attention, but maybe I misheard it. Maybe she
Trooper,
misspoke.
if you have a bad back and you need to stand, just stand at any time.
Thank you, Your Honor.
Okay.
Quit being a wuss and sit on the damn stand and answer the questions. Jeez. Big Ron says the search history he felt was trash. That they strung a bunch of words together to sound smart and disagrees with. They disagreed what she says. And I'll tell you, when they get wordy, expert witnesses, and they start talking that way, a lot of people feel just like Big Ron does. Like, yeah, you know what? Too complicated for me. This is not a difficult matter, so they move on to something else. Unless you got some nerd in there, like we got FT French sitting on that jury, then we go back into deliberations and they can actually talk about that. He starts breaking down stuff and makes it make sense to them. That could happen as well. That says the cell phone data about the search history made sense to him, but it's not the main thing that he would hang his hat on. Using my term, I like that. Also, the data that we heard today doesn't help the state at all wide range. I think what he's trying to say that the data they portray today it's not very specific. It's a very wide range with a plus or minus error factor that's rather large, and I agree with that. I agree with that as well. I don't know that it helps the state. I don't know that it hurts it either, though. Folks, while the jury gets seated, I'm going to step away for a quick cup of coffee. So you're going to miss my cheery voice and wise wisdom for just about 2 minutes.
Thank you. Be seated. Close back to
Mr. Lally?
Thank you, Your Honor. No further questions for this witness, Your Honor.
All right, Ms. Giannetti?
Thank you, Your Honor. Mr. Lally, you left your material here.
Thank you, sir.
Trooper Guarino, you've testified that you disagree in many respects with the findings of the defense expert, Rick Green, which he outlined in his affidavit submitted in connection with this case, correct?
Yes, that's correct.
I'd like to ask you some questions about your training and education and your qualifications in the area of computer forensics. You graduated from Westfield State University in 2003.
Yes, that's correct.
You majored in criminal justice and mass communications, correct?
Yes, I double majored.
Right. You chose not to major in computer science, correct?
Yes, that's correct.
2 years after graduating, you became a patrolman in Norwood, correct?
Yes, that's right.
The town of Norwood is right next to Canton, is it not?
Yes, it is.
You stayed as a patrolman in Norwood for 10 years with the Norwood Police Department, correct?
Minus a stint in the National Guard, but yes.
You then became a Massachusetts state trooper in 2015,
Yes, I did.
and you spent 4 years in the patrol division of the Mass State Police, correct?
Yes, I did.
And that was until 2019?
Correct.
And 2019 was the first time that you took a forensic computer course. Would you agree with that?
No, that's not true.
Would you agree with me that since then, your training has mainly consisted of online courses and webinars?
That is also not true.
Okay, well, you list, with regard to your training, some in-person trainings, sir, but you list 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, actually over 20 online courses, do you not?
Yes, that was during COVID.
Well, 2019 was not during COVID, was it?
2020 was
All right.
when I took most of them.
I got you, but you say 2019 to 2020 in terms of your online courses and webinars, correct?
There's quite a few, yes.
All right. And with regard to some of the courses that you were taking during that time period, would you agree with me that one of them was Introduction to Computer Networks?
So that course was through the NW3C.
I
They just
didn't
had
ask
it
you where it
multiple.
was from. I asked you whether one of the courses that you took was called Introduction to Computer Networks.
That's correct.
And another course that you took was Introduction to Cell Phone Investigations, correct?
Yes.
Introduction to Previewing, correct?
Yes.
You hold no degrees in the field of computer forensics, do you?
I hold certifications.
You hold no degrees in the field of computer forensics or computer science, correct?
Like college degree?
Correct.
Yeah, correct.
You have no publications in the field of computer forensics, do you?
No, not yet.
And you've never taught a course in computer forensics, have you?
No.
All right. Well, as a Norwood police officer for 10 years and a Massachusetts state trooper for 9 years, you would agree that you've written a lot of police reports over the years, have you not?
Yeah, you could say that.
Prior to becoming a Norwood police officer back in 2005, you attended a police academy, right?
Yes, I did.
And at the academy, one area of focus was the proper way to write a police report, was it not?
Amongst others.
You were taught that it's important to write police reports close in time to the events in question while they're still freshest in your memory, correct?
It's not necessarily the case.
Okay, so is it your testimony before this jury that it's preferable to wait months before you submit a police report on something that happened months ago, sir?
Well, it depends on the data that I'm using. If I can't get into a phone, then yeah, I have to wait months.
Okay. But once the information is received that you need to write a police report, would you agree with me that it's important to record it in a report as soon as you can?
No, I stand by my previous statement that as soon as the data is available that I can do it, I will. And if, things come up, then, I do it when it's able.
So I think you just answered my question. You said
Right.
as soon as the data is available and you've completed your investigation.
I never said I completed. I said if the data is available,
Well,
then
let's say you've completed your investigation, sir. Are you going to argue with me that it's preferable not to wait to record that data in a report?
Objection.
Ask it differently, Mr. Yannetti.
You were also taught that it's important to include all the important details in your police report, correct?
again, it depends on the report I'm writing.
Okay, so in other words, there are times when you're writing a police report when you intentionally leave out important details, Trooper. Is that your testimony before this jury?
Objection.
I'll allow that question. Is that what you do, Trooper?
No, ma'am,
Okay.
Your Honor.
So you would agree with me, going back to my question, that it is important to include all the important details in your report, is it not?
Again, it depends on the report that I'm writing. There's some data that goes in, there's some that doesn't. I can't have everything in. Again, for phone, I'm speaking to technically phone reports or cell phones, computers. I can't include everything. That's why we have the program that if I need to add something via Cellbrite or Axiom, I can create a report through that. If I did a handwritten report for everything, they'd be thousands of pages for the amount of data in these devices.
One purpose of writing a police report is to share information with your fellow investigators, is it not?
I suppose so.
Another purpose of writing a police report is to be fair to the people that you're investigating by explaining as best you can what happened, correct?
I don't understand that question.
Okay. The fact is you did write some early police reports in this case dated February 4th, 2022, just 6 days after John O'Keefe was found mortally wounded on Brian Albert's front lawn, correct?
That is correct.
When you wrote those police reports, you knew this was a homicide investigation, correct?
I was told that it was believed to be yes.
So that underscored the importance of being accurate and truthful, correct? Especially in a homicide investigation?
I write my reports, no matter what the investigation is, the same exact way.
And the purpose of one of your February 4th, 2022 reports was to explain how you came into possession of John O'Keefe's cell phone and to note the extraction that you did on the phone. Do you recall that report?
Yes, I do.
And before writing that particular report, you spoke with Trooper Michael Proctor, did you not?
I received the phone from him, but
I'm sorry?
I received the phone from him originally, yes.
And when you received the phone, the two of you did not remain mute, right? The two of you chatted,
I don't remember the exact conversation.
but there was a conversation, correct?
I'm sure there was.
And you recorded what Michael Proctor told you about that cell phone in your February 4th, 2022 report, did you not?
No, I didn't.
Michael Proctor told you that on Saturday, January 29th of 2022, he and Sergeant Buchanan had responded to 34 Fairview Road in Canton. Did he not?
Objection.
I'll allow that.
No, he didn't.
Well, you wrote in your very first sentence in that report the following, quote, on Saturday, January 29th, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk County District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Those were your words, were they not?
All right, so the objection sustained, you can ask it differently.
Did Michael Proctor tell you that he had received or retrieved John O'Keefe's cell phone from 34 Fairview Road in Canton?
Objection.
I'm going to allow that.
No, I didn't know where it was retrieved from.
You didn't know where it was retrieved from?
Correct.
All right. But you did include in your report that while Proctor and Buchanan were on scene, they retrieved the cell phone of John O'Keefe, correct?
At some point during the day, they did. I don't know where from. So there's multiple.
Yeah, I'm asking about your report, Trooper. You know I'm questioning you about your report.
No, I understand. I'm explaining. I don't know what scene
You don't get to
it's
explain, sir,
Oh.
most respectfully, until Mr. Lally questions you.
Objection.
Okay, so no comments. I think to speed things along, do you have your report with you?
I do, Your Honor.
I think it'll make it easier,
Or
Ms.
can you read the
Giannetti.
first two lines of that?
Let him grab it.
Go.
Can you read the first two lines to the jury, please?
Yep. On Saturday, January 29th, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk District Attorney's Office responded to the unattended death of John O'Keefe at 34 Fairview Road in Canton. Through his investigation, was found O'Keefe was a victim of a motor vehicle homicide. While on scene, Trooper Proctor secured O'Keefe's phone and brought it to the Norfolk DA's office for forensic analysis.
Okay. So you'd agree with me that you included that clause, while on scene, they secured his phone, did you not?
I did write that.
Okay. And that was back on February 4th of 2022, correct?
Yes, it was.
Within 6 days of John O'Keefe being found mortally wounded on Albert's lawn, correct?
Yes, sir.
And at that time, you knew that the crime scene was 34 Fairview Road, correct?
No.
Yet you put in your report while on scene, did you not?
Yes, I don't know what scene they recovered from. I know they went multiple places on the 29th. They didn't get back to me till 7:30 that night almost,
Okay.
when I first got the
Well,
phone.
you'd agree with me that the Canton Police Department wasn't the crime scene, correct?
I never said crime scene in my report. I wrote scene.
Okay. Well, Canton Police Department was not the scene of any crime, was it?
I don't know. I don't believe so.
You don't know if the Canton Police Department was the scene of a crime. Is
I
that
don't
what you-
think it was.
You don't think it was, okay. Now, in that report, you were trying to establish the chain of custody of that phone, right? Because you described where it was found, where it was taken, and who had possession of it, correct?
I said it never said where it was taken. I said the phone was recovered on scene by Trooper Proctor. Again, I don't know where it was recovered from. I did find out later it was at Canton PD.
Well, hold on a second. Again, we're focusing on your report.
I know, I'm reading it.
As opposed to details you want to fill in now, okay?
Okay.
With regard to, you just testified that you never said where it was taken, yet previously you said it was taken to you, was it not?
No, I said recovered from,
Wait a
what
minute.
the scene location.
Did Trooper Proctor take the phone to you and
Yes.
hand it to you?
Yes, he did.
Okay, so it was taken to you, correct?
That is correct.
All right. So you described in your report where it was found because you said while on scene, correct?
Correct.
And where it was taken to you, correct?
Yes, sir.
And who had possession of it, which was initially Trooper Proctor in terms of your observations, and then you, correct?
That is who brought me the phone to the DA's office. Yes.
And you would agree with me that chain of custody of a piece of evidence is an important detail in any criminal investigation, isn't it?
Yes.
Would you agree with me that someone reading your report or listening to it as the jury listened today would understand you to be saying that Michael Proctor seized John O'Keefe's cell phone at 34 Road in Canton?
Objection.
Sustained.
All right. I'd like to ask you some questions about the extraction that you discuss in that same February 4th, 2022 report, the very same report. In that report, after you name the tools that you use to extract data from the phone, you indicated that a copy of that cell phone extraction was placed on a state police server, or was it a DA's office server?
DA's office server.
Okay, on a server so that it could be accessed there, correct?
That is correct.
But that extraction you placed on the server did not include all the potential data on John O'Keefe's phone, did it?
How do you mean?
Well, didn't you indicate in your report that the extraction was not inclusive of all potential data contained within the device?
No, that's not true.
Well, the extraction that you did contained communications, iOS messages, phone calls, social media communications between John O'Keefe and Karen Reed, correct?
Yes, that's correct.
And it contained communications between John O'Keefe and Jennifer McCabe.
Yes, that's true.
It contained communications between John O'Keefe and Kerry Roberts.
I can't recall.
All right. But it did not include any communications between John O'Keefe and Julie Albert, did it?
Again, I can't recall.
And again, I'm talking about that initial extraction. That initial one didn't include any communications between John O'Keefe and Chris Albert, did it?
I only created one extraction of John O'Keefe's phone.
All right. That extraction report also did not include any location data, did it?
No, it did.
You didn't note any location data in that initial report, did you?
In the February 4th report?
Correct.
I didn't go through the data at that point.
All right.
This is just my extraction report saying that I got the phone, it was extracted and placed onto the server. And then I wrote, this report is not inclusive of all potential evidence, potential data contained within this evidence.
When was the first time that you reported on location data in this case?
I don't remember.
Wasn't until April of 2023, correct?
Well, there was a reason for that.
Well, I didn't ask you if there was a reason for it, sir. You understood my question, didn't you?
That's correct. My first report regarding was in January.
We're talking about John O'Keefe's phone now here.
Yeah.
You did not report on the location data on John O'Keefe's phone until April of 2023, correct?
I didn't look at the extraction initially.
And you also did not report on any Apple Health data until the spring of 2023, correct?
Again, I didn't look at the phone extraction. Trooper Proctor would have looked at it. I would have loaded it and given it to him.
Okay, so Trooper Proctor had access to the phone first, and then you took care of it, correct?
He had access to the extraction that I would load onto Cellbrite for him to look at, where you can't change the data. That is correct.
And you would agree with me that you didn't address John O'Keefe's health or location data in any formal report until that April 23 report, correct?
That is correct. I never went through it.
Right, and you submitted your report in April of 2023 after you became aware of an affidavit filed by the defense expert, Rick Green, in which Mr. Green extracted and analyzed John O'Keefe's location data and his movements according to Apple Health data. Isn't that correct?
Yes, that is correct.
Before Rick Green submitted that affidavit, no member of the state police homicide investigation team, including you, had ever looked at or at least reported on the location data for anyone present at 34 Fairview, correct?
For the devices that we had, sir?
For John O'Keefe's device, for Jennifer McCabe's device, etc.
I can't speak to that. I don't know.
All right, but you didn't, correct?
Again, I didn't look at the extractions until later.
Right. So you hadn't looked at John O'Keefe's location data in particular prior to Richard Green pointing out the location data in his affidavit, correct?
Again, I don't know. I wasn't asked to look for that data when I did look at it.
Report on it, correct?
Yes, there's no report until then.
Right. Same with Jennifer McCabe's location data. You didn't report on that either, correct?
I didn't look at Jen McCabe's phone.
All right. You didn't report on Brian Alberts or Colin Alberts or Brian Higgins' location data. Would you agree with that?
I didn't have any of their phone extractions to get that data, so I wouldn't be able to anyways.
But when you finally did check the location data, I want to ask you about your testimony on direct examination that you believe that at a certain point, with regard to John O'Keefe's phone, the accuracy of the GPS points was within 3 feet. Do you remember that testimony?
Yes, sir.
All right. Can you show me where in any of your reports you specify that the GPS points are accurate within 3 feet?
I don't know. I don't have it in front of me. In my reports or the Axiom report?
Yeah, no, any reports that you have in front of you or any that you reviewed, where is that?
What do you, that I wrote that?
Is it in writing anywhere, sir?
Yes, I wrote in my report that we believe we were within 3 feet of the latitude and longitude points that were mapped in Sartopo when we went to
Which report is
scene.
that?
That is the second report that I did, sir.
The May of 2023 report?
May 9th, 2023.
All right. Now, let me just have a moment.
Yep. It's page. It'll be page 4 or 5. It should be in the top there. Paragraph 9. Can read it if you'd like.
Hang on. Would you agree with me in paragraph 9, there is nothing that mentions that the accuracy is within 3 feet?
From the program?
No, I'm asking you about a report that you authored, that you just mentioned to this jury.
It's in paragraph 12. I'm sorry. It says, Trooper Proctor and I began to measure. I'm sorry. I'm sorry. I wrote, Trooper Proctor and I began measuring the approximate
I'm
location.
not asking you to read it.
Oh, okay.
You're mentioning paragraph 12 and
Yes, sir.
you're talking about one particular spot in that, correct?
Yes, that is the spot that we pointed on our
Now, with
location.
regard to John O'Keefe's phone, would you agree with me that it's important to properly handle and secure a cell phone that is seized in connection with a homicide investigation?
Yes.
Was it important in this investigation to properly handle and secure John O'Keefe's cell phone since he was the homicide victim?
I mean, it was. We locked it in a secure evidence lab.
All right. Well, you testified that the first time you reported on in your investigation or your evaluation of the location data, that was in your April 24th, 2023 report, correct?
Yes, sir.
And in that report, you revealed that you looked at his location data using Axiom software, correct?
Yes, sir.
And Axiom is a competitor of Celebrate?
Did you say that? Yeah.
And Axiom is relied on by law enforcement across the country?
I believe so.
And you relied on it here in terms of this issue of the location data, did you not?
I used multiple programs, but yes, I used Axiom as well.
And regarding the location data that you examined with regard to John O'Keefe's phone, you noticed, or you noted, I should say, that after a period of no speed having been registered for a period of time, John O'Keefe's cell phone started registering movement at 6:04 or 6:15 a.m.?
6:15 a.m.
6:15 a.m. And that's actually 6:15 and 36 seconds, correct?
I don't have it in front of me, but I believe that's correct.
Sounds right?
Yeah.
And at that point, his phone registered a speed of 0.0484 meters per second.
Just want to confirm.
Sure.
I'm back, folks. I'm
Is that
glad
the second report or the first report? I'm sorry. There it is. Yep.
I'm glad he's
0.0484.
addressing when benefit the
0.0484 meters
state
per
to have
second.
accuracy
Yes.
when it's
And
not
that's at
benefit the
6:15 and
state
36
to do not
seconds?
have accuracy when it comes to this data.
Yes, it is.
All right, so
Interesting.
now, as you were examining that data, sir, you certainly knew from this
Yeah,
investigation
I'd like to know when all this
by
is
that
over.
point
they do a
that
total
when the
revamp.
phone was moving according
training,
to that data at
equipment.
6:15 and 36 seconds on January 29th of 2022, John O'Keefe had already been found mortally wounded and incapacitated, correct?
From the voicemail message, that's how I was able to, I don't know the exact timeframes that he was found and transported, but I know 6:08 from Miss Reed's voicemail that the 911 call is made, and
Okay,
they're on scene.
I think we're talking over each other here,
Yeah.
because what I'm asking is, you knew that by 6:15 and 30 seconds in the morning on January 29th, John O'Keefe had already been incapacitated and mortally wounded. That was my question.
Oh, yes, sorry.
Okay.
I misunderstood.
So you knew from your investigation that meant it could not have been John O'Keefe moving with his phone at 6:15 and 36 seconds, correct?
That is correct.
It had to be somebody else, correct?
Yes.
Would you agree with me that once investigators took possession of John O'Keefe's phone, any movement of his phone after that would not help in your homicide investigation, would it?
I don't understand.
So in other words, John O'Keefe's been incapacitated.
Yes.
Somebody from law enforcement seizes his phone. Would it help your investigation or the investigation of the Norfolk Detectives Unit to track and record location data on that phone after 6:15 a.m.?
Well, it's there. I did look at it. It goes to Canton PD and then later comes to the office.
I didn't ask if it's there. I know it's there. I'm asking you, does that help you in your investigation of a potential, of a homicide, to track the phone and have that location data recorded on the phone after John O'Keefe could not have been the one moving with it?
No, not necessarily.
In fact, if the phone is manipulated in some way after investigators take possession of it, that could potentially harm an investigation, couldn't it?
Objection.
Sustained.
Well, to preserve the integrity of the data on the phone as it existed before the police took custody of the phone, there is a way to stop the phone from recording location data, again, after the police take custody of the phone, isn't there?
Yes, if you can, place it into airplane mode.
Yes, yeah, you mentioned on direct examination that it could be accomplished by putting the phone into airplane mode, correct?
That is correct, sir.
But when that phone was seized, no investigator put the plane into airplane mode that early morning because you know that location data was found on that phone, correct?
I don't know when it was placed in airplane mode,
But you know it wasn't by 6:15 a.m., correct?
that is correct.
All right. And there's also another way to prevent any signal from entering or exiting the phone. You'd agree with that?
Yes, there is.
During your direct examination, you mentioned the concept of a Faraday bag.
That is correct, sir.
A Faraday bag has special fabric that blocks electromagnetic signals entirely, does it not?
Yes, sir.
So putting the phone into a Faraday bag would be another way to stop the phone from recording location data while the phone's in police custody, correct?
Yes, sir.
And you'd agree with me that during that early morning hours, as of 6:15 a.m. and thereafter, no investigator in this case put that phone into a Faraday bag on January 29th, correct?
These guys
Not
didn't
to
have
my
paper
knowledge.
sacks for evidence, much less a Faraday
In
bag.
fact,
You said what I
after
was
John
thinking.
O'Keefe's cell phone started registering movement at 6:15 and 36 seconds in the morning on January 29th, it continued to record location data the rest of the morning until 11:56 and 1 second a.m. on January 29th, correct?
I don't know the exact end time, but I know it does have GPS data points throughout the day.
You know, they were real quick to put Karen Reed's phone into airplane mode, but they didn't do it with John O'Keefe's.
Yeah.
It just goes back again. The law enforcement here
So-
was super sloppy or just
You
incompetent.
would agree with me that for several hours after the police had the phone, it was not put in a Faraday bag and it was not put into airplane mode, correct?
That is correct.
All right. Now, with regard to the voicemails that you've previously testified to and that the jury has heard and they've been introduced into evidence, you had testified on direct examination that Karen Reed's phone connected to the Wi-Fi at 1 Meadows Ave at approximately 12:36 in the morning?
Yes, sir.
So you can testify based on that by 12:36 in the morning, Karen Reed was not at 34 Fairview, correct?
That's correct.
And that was the first of those voicemails that you testified to, correct? That was the I hate you voicemail?
Yes, that's 12:37, correct.
Okay. And that voicemail and every other voicemail that the jury heard was left after Karen had left 34 Fairview, correct?
Yes, sir.
And except for the one at, after 6 in the morning, the 4-minute one when she went back, we heard that one. But all the other ones were apparently left when she was at 1 Meadows, correct?
I can't speak to where she was, but
But she wasn't at 34 Fairview.
yes, that's correct. She wasn't at 34.
And you would agree with me, based on those voicemails and what you know about them and what we've just discussed, that no one at 34 Fairview, including Jennifer McCabe, could have witnessed Karen Reed outside that residence at 12:45 a.m., correct?
No, I don't believe so.
So you would agree with me? No one could have, including Jennifer McCabe, could have seen her at 12:45 at 34 Fairview?
As I said, she auto connects to the Wi-Fi at 12:36, so no, she wouldn't have been there.
All right. Now, we've talked about the findings of, or the fact that you reviewed the findings of Rick Green by reading the affidavit that he submitted, correct?
Yes, sir.
And you learned in that affidavit that Rick Green was able to track not only when John O'Keefe arrived at 34 Fairview, but also the route that he and Ms. Reed took to get there on January 29th, correct?
I don't recall his report fully, but
You learned that he was able to accomplish that by examining the data from the app Waze that you spoke of, correct?
yes, I did find that myself.
All right. And Waze is spelled W-A-Z-E, correct?
Yes.
All right. And you've previously testified it's a commonly used app for driving directions and navigation.
Yes, sir.
And regarding your analysis of the phone, you learned that there was Apple Health data from John O'Keefe's phone on January 29th of 2022, correct?
That is correct.
And Apple Health data can reveal a number of steps that a person has taken during a given time period, as well as whether that person is going up or down stairs, correct?
Yes.
And on John O'Keefe's phone, you learned that there was Apple Health data that tracked his steps from the time he's seen on surveillance video leaving the Waterfall Bar and Grill and moving forward after that, correct?
I don't know anything about the Waterfall Bar video. I just have the timestamp from the phone showing it at around 12:12 at the waterfall.
All right, and it actually was between 12:11 and 9 seconds, and then the ending period of that first time period was 12:21 and 5 seconds. And then you.
Oh, yes, from the health. Thank you. Yes, yeah.
Okay, from the Apple Health. And the data showed that he took a total of 170 steps between that time period, correct?
That's what the phone registered, yes.
All right. And regarding those 170 steps, isn't it true that this data from Apple Health signifies that 170 steps took place at some point during that 10-minute approximate time period?
No.
So is it your understanding that those 170 steps all took place at 12:11?
No. Again, like I said, the phone is a high-tech pedometer. It doesn't mean that steps were taken. It means the phone was manipulated in a way that it believed it was moving and taking steps.
Oh, I see your objection.
Yeah.
Okay, so
Sorry.
Yeah, let's assume there were steps for the purpose of this discussion.
Yeah.
Okay, and they could have been steps, correct?
It could be
They
either.
could have been, yes,
Okay,
but
all right. So let's assume
no way to prove.
let's assume that for now.
Okay.
Assuming there were 170
No way to
steps
prove
taken,
your assertion, my friend.
that could have meant that John O'Keefe took 170 steps beginning at 12:11 within that time period, correct?
It's saying again, the time frame that it gave me is 12:11 to 12:21.
Right, yeah. So in other words, if he could have started walking at 12:11, correct?
Yes.
All right. But he also could have taken that 170 steps closer in time to 12:21, correct?
Well, at that point, he's in the car.
I'm not asking about where he was.
Could not
or
have
your
been.
testimony.
No.
I'm just asking about with what the data shows. If
And
it
I would
shows
say no.
If it shows 170 steps between 12:11 and 12:21, then strictly based on the data, you don't know where those 170 steps took place within that 10 minutes, correct?
To a degree, yes.
Okay. And it's possible it could have been toward the beginning, toward the end, or maybe fairly evenly spaced, right? You just know that there were 170 steps that were taken in that 10-minute time frame, correct?
Again, that's assuming that they are steps.
Right. And again, I'm asking you from the data itself.
Again, the phone says it's steps, doesn't mean they are.
All right. Well, the Apple Health data also showed a total of 80 steps between 12:21 and 12:24.
Correct.
As part of your investigation of this case, were you aware that there was a 12:23 text message from Ryan Nagel to Julie Nagel in which Ryan texted his sister Julie he had arrived at 34 Fairview?
Objection.
Sustained, you can ask it differently.
In any case, you would agree with me that 12:23 is between 12:21 and 12:24, correct?
That is correct.
And that is the 12:21 to 12:24 time frame where the Apple Health data showed that the user of John O'Keefe's phone took 80 steps, correct?
Yes.
All right. Now, John O'Keefe's Apple Health data also showed that he climbed up or down 3 flights of stairs between 12:21 and 12:24, correct?
Yes.
And that's the same period in which the data reflects 80 steps, correct?
It's off by about 12 seconds. It's 12:22, 22. That's right, 12:24 and 22 seconds was the ending for the stamps, but 12:24 and 37 seconds.
Okay, but approximately.
Yeah. Approximately, yes.
All right. And regarding going up and down those 3 floors, Apple does not provide data precise enough to determine when within that range the 3 floors were transversed, correct?
No. There was a second point at 12:22 and 14 seconds that had specifically on stairs.
Okay. And you would agree with me that, and again, assuming that they were stairs as Apple Health data reflects, those stairs could have been ascended or descended toward the beginning, toward the end, or throughout that 3-minute time period, correct?
That's when the phone was up in the air.
In this case, no, because there's a set point that's in the Cellbrite report that shows it's 12:22 and 14 seconds.
All right. Finally, his Apple Health data also showed a total of 36 steps between 12:31:56 and 12:32:16, correct?
Yes, that is correct.
All right. So I would like to direct your attention to your May 9th, 2023 report, which was the second report that you wrote that we've already referenced.
Yes, sir.
Specifically paragraph 15.
Okay.
You wrote that O'Keefe's health data in Celebrite shows him ascending, descending 3 flights of stairs at 12:22 and 14 seconds. Did I read that accurately?
Yes, sir.
And the native locations in Celebrite and the cached locations in Axiom both show O'Keefe's phone location by the intersection of Oakdale Road and Pinecone Road, which is in front of 36 Oakdale, and which is approximately a little over a half mile from 34 Fairview. Did I read that essentially correct?
Yes, sir.
All right. Do you stand by the statement that he ascended and descended 3 flights of stairs precisely at 12:22 and 14 seconds?
I'm going by what Cellbrite has given me from that time point, and that's what I used.
Isn't it true that what the Apple Health data actually state is that John O'Keefe's phone went up and down 3 flights of stairs sometime within the time period that began at 12:22:14 and ended at 12:24:37?
I can't speak to it. I don't know. This is what, again, I'm looking at the report. This is what the information that is parsed out of the phone is giving me.
Right. I'm just asking about the data itself. It gives you that time period and tells you 3 flights of stairs, correct?
Yes, that is correct.
All right. Assuming that those 3 flights of stairs were ascended or descended closer in time to 12:22:14, which was within that time period, that would still give him time to arrive at 34 Fairview within a couple minutes later, would it not?
I'm sorry, the time.
Yeah, so we have a time period that you've agreed with, which is 12/24/14, ending at 12/24/37, right? A little over a couple of minutes, like 2 minutes and 23 seconds.
Yeah, about that.
All right. So the 3 flights of stairs, again, just according to the data, could have been ascended or descended at the start of that time period, correct?
No. I'm confused what you're trying to say. So you're saying that he's at the house already at
I'm not asking
12:22?
about the house. I'm asking about the data.
No, I know, but I'm asking about when you're saying he arrives in that data range.
No, I'm
confused.
I'm strictly asking you just to look at the data.
Yeah.
And you agree with me, whenever there's a time period and Apple Health returns either steps or stairs, you can't pinpoint just from the data when they occurred within that time period, correct?
Objection. Your Honor, maybe helpful if counsel could refer to which data he's talking about and not just keep
I
saying.
did. I'm
All I'm
talking
hearing
about
is
the Apple Health data. I thought that was
Do you know
clear.
which data Ms. Giannetti's referring to specifically?
I'm slightly confused. I know you said that time frame that I wrote in my report for that 12:21 to 12:24. And then, as I stated before, Celebrate shows a specific time point of 12:22 and 14 seconds when the stairs are ascended, descended. So that's why I'm confused.
But we're going to get to that, but
Okay.
I'm not asking you about that. I'm asking you about the fact that there's a time period and you can't place where within that time period, just based on that data itself.
Yeah, that's what's recorded and shown to me. So again, that's what it's shown. I
Okay.
can't say otherwise.
Your conclusion was that John O'Keefe could not have been at 34 Fairview Road at 12:22 and 14 seconds because Waze put him on Oakdale Road about a half mile away, correct?
12, yes, correct.
All right. And that caused you to disregard the Apple Health data or to attribute it not to steps or to stairs because he was a half mile away between that 12:22 and 12:24 time period, correct?
Yes, I attribute it to movement.
All right. So I want you to assume for a moment, Trooper, that John O'Keefe's phone location actually showed him on Oakdale Road 3 minutes earlier at 12:19 a.m. Okay, if you have that in mind?
You okay?
All right. With that assumption, would you agree with me that the Apple Health data about him taking 80 steps and climbing up or down 3 floors at 34 Fairview Road would make more sense?
Objection.
Sustained.
May we approach, Your Honor?
Sure.
I see where he's going with this. I'm writing all this down. I see where he's going with this.
Where's he going?
He's basically pointing out that, well, he's what's the word I'm looking for? He's not thinking about the Apple data. He's going back and relying on the Waze data. That he wasn't there at that point in time. Like there's a mile and a half difference. So he couldn't have been at 2 places at one time. So if I'm understanding him correctly, his report is going back and forth, or the reports are going back and forth. There's a discrepancy between his report and the other reports.
Yeah, I think the discrepancy is the accuracy of the data. And that's what I was saying earlier. It's like the state is wanting to say that the data is when the data is accurate or when they need the data to be accurate to put their case up, then the data is accurate. But when it's on the defense side, they lay in on, well, the data is not that accurate.
Right. Yeah.
Which is, quite honestly, it's kind of bullshit the way they're doing that. It is or it isn't. You know what I mean?
Sir, are you aware that apps on an iPhone may pull data from 3 different clocks when they're timestamping location data?
You mean like Mac absolute time or Apple
I'm
Cocoa
asking
time?
you. Are you aware?
Multiple timestamps that are in an iPhone, correct?
That's not my question. My question was, are you aware that an app on an iPhone may pull data by choosing from 3 different clocks when it timestamps location data.
Yes.
What are those 3 separate clocks?
Depends on the program. It could be the Mac Absolute time. It could be the Unix Epoch time. And sorry, there's like 2 others. I don't remember them all off the top of my head.
With regard to John O'Keefe's actual iPhone, did you research what clocks were available for apps to pull data from?
No, I didn't.
Are you aware that those 3 clocks can vary in time?
Yes.
Sometimes for a matter of seconds.
What do you mean? So
In other words, the 3 clocks could be seconds apart, correct?
I would have to see the data.
And you would agree with me that sometimes the clocks could be off by 3 minutes, correct?
No, again, I would have to see the data.
May I approach?
Yes. Mr. Lally, did you get a chance to look at that?
I got a feeling he's about to explain to him how that be off.
Okay, Trooper, I'm going to place this before you and ask you to review it, directing your attention specifically to what is marked process 3434.
Okay. Okay.
Do you see the process 3434 highlighted in blue on what I've placed before you?
Yes, sir.
And with regard to the right side of that exhibit, do you also see process 3434 with more information on the right side?
Yes.
And do you see the 3 different clocks that are listed on that printout?
I do.
What are those 3 different clocks?
Sorry, it's a bit blurry. Monotonic date time, baseband date time, and then display date time.
And looking at that, and by the way, do you recognize that as being information that was available from John O'Keefe's phone from the extraction?
Yes.
I would offer that as an exhibit, Your Honor.
Any objection, Mr. Lally?
No, Your Honor.
What are we going to call that, Ms. Giannetti? How are we going to refer to that?
It could be called, a printout regarding 3434.
Okay.
Or printout from John O'Keefe's phone.
Thank you.
Thank you. Now you have exhibit 640 in front of you, sir. Looking at 640, is it clear to you that those 3 clocks were not in sync regarding that one process number?
Yes.
In fact, the monotonic clock regarding this particular Waze artifact from John O'Keefe's phone says 2:22 a.m., while the baseband and display clocks have timestamps 3 minutes earlier, correct?
Yes.
So if there's a 3-minute difference between the clocks, well, strike that. Do you know, with regard to that 2:22 a.m. location data on Waze, do you know which clock Waze was using for that? Or the iPhone was using with Waze?
I don't. Didn't look through Axiom. I was using Cellbrite for that.
Okay. But certainly that would have been available to you had you looked at it, correct?
Well, but the artifact you show me is from the power log. It has nothing to do with the GPS, so it's not correct.
You could have looked at that exhibit, right?
Yes,
The information in that exhibit to see the 3 different clocks, sir?
Yes, but I can explain why this is incorrect.
All right, maybe Mr. Lally will ask you.
Sounds
All right?
good.
But you would agree with me if
Well
there's a
played.
3-minute difference between the clocks and you don't know which clock was used to put John O'Keefe's phone on Oakdale Road at 2:22 a.m., that could explain, let me just have a moment. It's not 2:22.
No, I know what you meant.
Thank you, Mr. Jackson. Thank you. I'm sure everybody else did. With regard to the 3-minute discrepancy between the clocks, and you've said you don't know which clock Waze was using to put John O'Keefe's phone on Oakdale Road at 12:22 a.m. That could explain the discrepancy between the Apple Health data and the Waze data, could it not?
No.
But as you sit here today, you don't know whether Waze was relying on the baseband, display, or monotonic clock, correct?
Again, that's not, can't be used for that.
Now, you're aware that Jennifer McCabe signed a consent form on February 2nd of 2022 for her cell phone to be imaged?
Yes.
And a full forensic extraction was performed on that phone sometime shortly after February 2nd of 2022?
I don't remember the exact date. I didn't download her phone.
But in any case, you generated a Celebrite full file system extraction report on May 31st of 2022, correct?
Yes.
And you were aware that that Celebrite report was the one that was turned over to the defense in this case, correct?
That is correct.
But you'd agree with me that that extraction report didn't contain anything close to the full file system, despite the name on it, correct?
It did.
Well, that report was filtered to return only Jen McCabe's communications with Karen Reed, Kerry Roberts, John O'Keefe, and Kaylee Furbish, correct?
That is not correct.
Did Michael Proctor instruct you to pull only those communications?
Objection.
You didn't seek to obtain any of Jennifer McCabe's communications with her sister, Nicole Albert, did you?
I didn't go through, like I said, didn't go through Jen McCabe's info.
And you didn't seek to obtain any of her communications with her daughter, Allie Albert, did you? I'm sorry, Allie McCabe.
Objection. May we approach?
Sure.
You know where he's going with that, John?
No, I'm trying to figure it out. But go ahead.
Yeah, he's showing where they did full extractions on other people's phones, but Jennifer McCabe, they didn't. They only extracted the things basically she wanted them to see, but they don't have a full extraction on her phone.
Yeah, I mean, I
Yanetti's doing a good job, I think.
I got that, but I wonder why.
Why? What? They didn't do the full extraction, or why he's bringing it up?
Why they didn't do the full extraction.
Because they didn't want to reveal everything that was on her phone. She gave a consent
But I mean,
for an extraction, and she made. And you know, in all fairness, she could have given just an consent to take certain things off of a phone instead of a full dump. In other words, they can't go through the extraction that the McCabe gave that they got from McCabe's phone, like they're going through the extractions they did for. I'm drawing a blank. Karen Reed and O'Keefe's phone. Everything that was on that phone was dumped, so they have every bit of that, but they don't have that for McCabe.
Yeah, I get that. What my thought process is, if I'm trying to set her up, I mean, why wouldn't you? I mean, because then that's going to look more suspicious as to why you didn't do it. But
Yeah, but brother, that's not the only thing that's.
I know.
Yes.
You agree with me that
That's the only hurdle they had to get over. They're doing okay.
the full forensic image of Jennifer McCabe's phone was not shared with the defense until it was requested by us in October of 2022, sir?
That is not true.
When you wrote your report on April 24th of 2023, in response to an affidavit provided by Rick Green, the defense forensic computer expert, it was in that report that you finally disclosed for the first time the existence of 3 Google searches by Jennifer McCabe, correct?
Objection.
All right, so ask that differently.
Prior to April 24th of 2023, you had not reported in any formal manner with anything that was shared with the defense about the existence of 3 Google searches by Jennifer McCabe, correct?
I never looked at Jennifer McCabe's phone.
And so was there anybody else from your unit or anybody else that you worked on that provided that material to us?
Not that I know of.
All right. Page 2, if I may just have a moment. Your Honor, we don't have a printout, but I have it on a.
So don't
can I approach with that?
approach the witness with that? Okay, show it to Mr. Lally first.
So I'm gonna see if I can
Yeah.
place this before you without destroying the
I got it.
computer.
Yep.
Sorry, sir. You take a moment to familiarize yourself with that. Do you understand, or can you tell the jury what that is?
Yep, this is you could put in a PDF. This isn't one I gave to you. This is a PDF version of the UFED reader report that I gave. So I gave the portable Cellbrite version to you. This is a copy of it, and I will not testify that anything in this is correct because this could have been filtered.
But your name is on there, is it not, sir?
Yes, it is.
All right, and what's the date?
May 31st, 2022.
Thank you.
Yeah.
Okay. You'd agree with me with regard to that April 24th of 2023 report, on page 2, you state, quote, "In my initial Celebrate UFED reader report," and then you put version 7.53.0.29, "that was created on May 4th of 2022, the search history for Jennifer McCabe's phone had 2 Google searches in Safari, correct?"
Yes.
And you list out how long TI die in CIKD at 6:23:51 and Hoslong to die in cold at 6:24:37, correct?
That is correct.
And by the way, with regard to the timing of those 2 particular searches, you are aware, are you not, that Jennifer McCabe placed a call to Brian Albert at 6:23 and 0 seconds?
I don't have it in front of me. I don't.
Can I approach you on?
Yes.
Thanks.
All right, sir, I placed before you a document. Could you familiarize yourself with that and then tell the jury if you recognize what it depicts?
Have a call log that says 20888 with no name at 6:23. That's incomplete because there should be 3 other records accounting for this call.
Okay, but that record itself reflects a call from Jennifer McCabe's phone at 6:23 and 0 seconds?
I don't know. There's no number on here, so I can't tell. It just says it's a call log with 1 call that's not answered at 6:23 in the morning with, doesn't say who it's from or who it's going to.
Okay.
It also is incomplete because there should be 2 other records with this. This is from the call history stored data wall, marked as deleted.
It's marked as deleted. Does it give a duration?
It just says duration 0 seconds.
Okay, and does it reflect that it was unanswered?
It does.
Okay. May I have that mark for identification, please?
Okay. Thank you.
Did you investigate whether a call was placed from Jennifer McCabe to Brian Albert at 6:23 in the morning and 0 seconds?
I didn't look at any specific calls that morning. I created a Cellbrite report. That's about it.
Did you ask either Ian Whiffen or Jessica Hyde to look into that issue?
Objection.
Sustained.
Within.
You would agree with me that that call and the record of that deletion of that call is nowhere in your April 24th report, correct?
I believe it's in my May 9th report.
All right, but I asked you about your April 24th report, sir?
I didn't address anything regarding phone calls in my April 24th report.
All right, now going back to when you began your examination around May 4th of 2022, you were looking for information on Did you look on Jennifer McCabe's phone back in May 4th of 2022?
Did I physically open the phone or did it
Did you review the data at all?
from, I'm confused, for on the cell phone itself or from the report?
Either way.
No, well, her phone was returned to her and then we had the extraction. I did not utilize the extraction at all.
You never included the two searches that we discussed, the, how long TI die in CIKD and how long to die in cold, in the full file system extraction that was turned over to the defense, did you?
They were included.
Well, page 6 of your April 24th, 2023 report goes on to state that when you switch to a new version of Celebrite, and
Sorry, that
dropped out.
Yeah, it was the phone call, the power log.
Page 6 of your April 24th, 2023 report says that when you switch to a new version of Celebrite Physical Analyzer, which was version 7.61.0.12, you found an artifact from the browser state DB wall file for a Google search of Hoslong to die in cold at 2:27 and 40 seconds, correct?
Yes.
May I approach?
Yes.
Trooper, I'm placing before you what has been marked as Exhibit 99. Do you recognize that?
Yes.
And what is that?
It's the searches that were done at 6:23 regarding the misspelled how long to die in the cold.
Okay, and it's actually Hoslong to die in cold,
Yes.
right? HOS?
Yep, that was,
That was marked by Celebrite as deleted, was it not?
yes.
All right. And your April 24th, 2023 report goes on to mention 2 deleted calls to Jen McCabe's sister, Nicole, who was saved as Coco in her phone, correct?
I'd have to see it, but I believe so.
Okay. May I approach?
Yes.
Thank you.
Showing you what's been marked Y for identification. If you'd familiarize yourself with that and look up at me when you're done.
Okay.
Does that show the 2 deleted calls to Jen McCabe's sister, Nicole, who was saved as Coco in her phone?
I don't know who it's coming from, but it does say it's going to Coco and then again, coming from wall files, correct?
All right. And your report doesn't mention it, but what was the duration of those 2 calls according to that log?
On this sheet here, it says 9 seconds for the first one and then 7 seconds for the other.
All right. And those calls, both of them, which actually had durations, were marked answered by Celebrite, correct?
Yes.
May I offer that, Your Honor?
Do you need
An
both?
objection?
I believe it's already in, but
I'm sorry?
I believe it's already,
Why for identification?
no, I understand. I believe Ms. McCabe's phone calls and all of that is already marked as an exhibit months ago.
Your Honor, I don't think there's any harm in marking this, and I want to display it.
All right, I'll let you display it if it's already in evidence. I just don't want duplicates.
I understand.
So what I'll do is I'll let you display it, and then, Mr. Lally, at some point you find where this is and we will mark this like A to whatever
Okay.
the identity.
That makes sense.
Dante says the pedometer
Thank you.
data is not
Mr.
GPS
Bishop,
related.
display what was-
34 is a dead zone, so it's likely the pedometer data was at 34.
And Trooper, with regard to what is displayed on the screen now, is that consistent with what I had just handed to you?
And he
Yes,
is
it
not
is.
aware of a lot of stuff. That is correct.
With regard to the first entry there, you had stated that it doesn't say You said it doesn't say who was making the call. Was that your testimony?
Yes, just says right here,
Yep.
2. I'm guessing that's the last 4 of the number, since the rest is blurred, and then, yeah, that's it.
Okay, and you know that 0204 last 4 digits, that is to somebody who was listed as Coco in the phone, correct?
I don't know any of these phone numbers or people.
But you previously testified these 2 calls were somebody who was named Coco in the phone.
Oh, yeah, from the sheet you gave me that shows it.
Okay. And the time of the first call was 6:07:42, is that right?
That's correct.
And you testified that that's the one that had the duration of 9 seconds?
Yes.
Listed as answered
Correct.
and deleted, correct?
Yes and no, and I can explain if you'd like.
It's listed as deleted, is it not?
There's a reason why.
Is it listed as deleted?
It is, but there's a reason why.
With regard to the second call, that appears to be to the same number, or at least the same last 4 digits.
Yes.
And in the sheet in front of you, that's also to Coco, correct?
Yes,
And that has a timestamp of 6:08 and 17 seconds, correct?
that is correct.
That also has a duration, and that's of 7 seconds,
Yes.
also listed as answered,
Yes.
and also marked deleted, correct?
Yes, and there's a reason.
And are you aware that Ms. McCabe made other calls that morning, which were in fact marked unanswered by Celebrate?
Again, I'd have to see what you're referring to.
So as you testified to here today, you have no memory as to whether or not she made a number of other calls that were marked deleted, sir?
There are a number of calls that morning. I have not memorized all of them.
And again, Your Honor, if I may approach and show something that's on a computer screen.
Thank you. Got it.
Okay. I've placed before you what appears to be a PDF document on a computer screen. If you familiarize yourself with it and look up at me when you're done.
Okay.
What does that appear to be, sir?
An incomplete PDF of the call logs from whoever's call log this is.
Okay. And do you see in that PDF that there were a number of calls that were marked unanswered by Celebrate?
Again, I can't testify to any of this because I can't confirm that where this data came from. There's no source file. This is it's incomplete. So I do see what you're talking about in that column, but I don't know what any of this data is from or who made this.
Is your name on it?
At the very top, it would show my name no matter what because I created the UFED and the extraction. I did not create this PDF.
So the answer to my question is your name is on that document, correct?
It is, but I didn't create it.
Right. And with regard to the calls that were marked unanswered, would you agree with me that Celebrate had them with durations of 0 seconds?
Objection.
Can you agree with that? Can you answer that question? If you can, please answer it.
With the data given here, I can't because, like I said, I don't know where they got this from, Your Honor.
So who created that document?
I don't know.
So are you testifying that nobody in law enforcement created that document, or no forensic expert for the Commonwealth created that document?
I created the extraction and made a UFED reader report, which is basically a portable Celebrate version that I use at the office. I gave that to defense. I don't know who created this PDF version of data with specific things. I did not.
Was it Michael Proctor?
No.
Well, I mean,
As I
how do
said,
you
I
know?
was the only one that created any Celebrate related reports in this case.
Yeah.
Well, I'd like to ask you some questions about my client's cell phone, sir.
Okay.
On Tuesday, when Mr. Lally was questioning you, he had you point out and read some text messages that were on her phone between John O'Keefe and her, correct?
Those messages were taken from John O'Keefe's phone.
Okay. Would you agree with me when he was pointing out those text messages to you, he skipped about 40 pages of messages at one point?
I don't know. I believe their text messages went back all the way to 2020 or something ridiculous
Right.
in his phone.
He started reading them and he skipped ahead about 40 pages, did he not?
I have no idea.
I remember
Michael
that.
Proctor seized my client's phone on January 29th of 2022, did he not?
He did.
And you would agree with me that certainly as of 6 days later, your February 4th report, you had not yet been able to access the content of the phone, correct?
That's not true.
At some point, you were able to access the content of the phone, correct?
Yes, on January 31st.
Of 2022,
Yes.
all right? You later became aware that Michael Proctor was searching through my client's phone in August of 22, correct?
The actual device itself or the extraction report?
Either one, sir.
I have, I'm sorry, Miss Reed's phone?
Yeah.
Oh, yeah, we didn't.
Hey, John O'Keefe's phone?
Yes, that's why I was
I
confused. Sorry.
apologize. I'm not trying to confuse
Yeah.
you. With regard to my client's phone, which is where we started.
Yeah.
You're aware that Michael Proctor was searching through her phone in August of 2022.
Of the extraction report created, correct.
Looking for nudes.
Were you made aware that on January 1st of 2023, the defense requested a full forensic image of Karen Reed's phone, which was in your possession?
I don't know the date, but a request was made for the phone extraction, yes.
And have you seen a forensic image or celebrate a report of the forensic image from Karen Reed's phone?
The redacted version that I received back from the AG's office, yes.
Okay. And would you please tell the jurors how many phone calls were deleted from Karen Reed's phone from January 29th of 2022?
None.
And if you'd please tell the jurors, other than to John O'Keefe, to whom did Ms. Reed place phone calls between 12 a.m. and 4:30 a.m. on January 29th?
Her parents twice. There 2 or 3 times there's calls to her parents, and that's it.
And how many Google searches did she do from 12 a.m. until 5 a.m.?
I don't believe there were any.
And how many Google searches were deleted by Ms. Reed at any point on January 29th of 2022?
I can't speak to that because we got a redacted version of the report, so I don't know what was taken out by the AG's office. I don't know what files they went in to remove, so I only have what I was given.
But leaving that aside, sir, with regard to all of the data that was provided to you, how many Google searches did you see or find that Karen Reed deleted from January 29th of 2022?
A few.
During what time period?
The afternoon, but again, there was artifacts that I found that weren't date and time stamped, and there were some that were with corresponding timestamps, but I can't say for sure when that was done.
Okay. But you saw no deleted calls, correct?
No, not that I know of.
All right. I may have a moment.
Yes.
Sorry.
No further questions. Thank you.
Okay.
Yes. Okay, thank you.
I think you did a pretty good job for cross-examination.
Yep.
Mr. Moreno, you were asked about qualifications.
Poked a bunch of holes
as
in
far
there.
as certifications that you received in prior trainings, correct?
Yes.
What are some of the areas that you received certifications in?
Cell phone report creation, extraction, cell phone repair, the Berlin Motor Vehicle Forensics, advanced database. The class is called CASA, but it's a Cellbrite made class that goes deeper into the database searching.
It must have been a very short class
SQLite,
on
programming to
cell phone
write
reports
code
and
to do your own
material
searches,
display, their material.
things of that nature.
Now, at any point in time, did Trooper Proctor ever tell you that he retrieved Mr. O'Keefe's cell phone directly from 34 Fairview Road?
No, he didn't.
Is it your understanding, or subsequently did you learn that Kerry Roberts actually recovered the phone from under Mr. O'Keefe's body, from the grass under his body at 34 Fairview Road when he was placed onto a scoop stretcher?
I don't know who recovered the phone that morning, but I know.
I'll allow it.
I don't know.
Your answer is you don't know who recovered it?
No, I just know that it was found underneath his body and then taken to Canton PD.
Now, with regard to that, as far as the location data post 6:15 a.m., what, if anything, did you observe in reference to that?
There was some intermittent native locations that showed at the Canton PD. It's there for a handful of different points, and then it shows it back at our office when I put it into the digital evidence lab, powered on to plug in.
You received the phone from Trooper Proctor. Was that either in airplane mode or Faraday back?
I don't remember offhand.
But there were no locations or GPS locations that you observed from the phone from that approximately 11 something a.m. until you retrieved it or received it, excuse me, at 7:30 p.m. on the 29th?
There's, like I said, there was only the handful that showed it at Canton PD, and then when it's back at the office that night. And then if it wasn't in airplane mode, there would have been something I would have done. So I don't remember if Proctor did it before he gave it to me or if I did it after.
Now, the other troopers in your unit, in the detective unit with the Norfolk DA's office, are they as well versed on cell phone extractions and cell phone data as you are?
No.
And so again, how many people within your specific unit actually perform data extractions or forensic analysis of cell phone?
Myself, Trooper Connor Keefe, and everyone has been trained in how to use Cellbrite and to do these extractions. They all just sort of dump them on my desk and say, do this phone for me. So.
Now, as far as what you provide to one of the investigating troopers, such as Trooper Proctor, can you explain to the jury sort of that process of how what if any differences there are between what you're looking at as far as the device when you're extracting the information and what you provide to the trooper?
So when I plug into Graykey or Cellbrite or whatever tool I'm using to extract the data, it creates that zip file, and then I open it up in Cellbrite or Axiom. The guys are only trained in Cellbrite, so that's what I open the extractions initially in for them. If there's something that we find that they don't understand and that I want to look more into, I'll load into Axiom as well. But that's normally how it would go.
Now, is there any way from the version or the extraction that you provide to the trooper, is there any way for that or any trooper to change or manipulate that data from what is initially contained on the phone?
Well, in essence, you could, but you'd have to go in. So once I create like that UFED reader, which is the portable case, you would have to go into the folders and then delete stuff, which would change all of the data. And then when I would load it up later, it probably wouldn't work right. But that's why we save the encrypted extraction onto the server. So if anything ever messes up, we can go back and reload it, and I can create whatever reports I need with it.
And so from your review of the data in the phones in this case, what, if anything, did you observe in regard to any manipulation of data or deletion of data or removal of data from what you observed?
From the encrypted files that we have, none. And then we didn't have passcodes for the phones for John O'Keefe's until the 31st. And then again for Miss Reed's until, like I said, August, once the program was able to open it.
Now, you were asked some questions about Mr. Green's affidavit. Following your review of Mr. Green's affidavit, what, if any, steps did you take in relation to what was indicated in there?
So as I said, I didn't really go through the phones much when we first got them. I don't know everything about the cases the investigators do. So I got his report and I went through it and basically just went step by step. So he says, this happened. I went to confirm it. If it didn't, then I need to find out why he was either incorrect or slightly off and either just completely wrong or just misinterpreted the data. And that was it.
And in addition to yourself going through some of the data, who, if anyone, did you contact to assist or to also, in addition, go through the data specifically as it related to the searches for Mr. Case?
So initially, when I first found it, I spoke with Chris Vance of Magnet Forensics. He's their head technical guy for Axiom. He's like their forensic specialist. So he was at the cybercrime conference. I brought him.
I'm going to allow this.
I brought the extraction there and I said, hey, this is what I'm seeing. This is what it parsed out. Why are we seeing it marked this way? And he goes, well, first off, you have to look exactly where it's coming from. The browser state.
So I'll strike that last part, what he told you.
Okay. Just reviewing the data, we saw that it came from the browser state DB file and .wall file, I should say, at the end. So it set off a lot of red flags. And then from there, we contacted Cellbrite and ultimately Jessica Hyde.
And ultimately, Mr. Whiffen as well, is that correct?
Yes, he came in after Cellbrite. I had reached out to them and they escalated it up, and he reached out to us to help us.
Now, with respect to the health data that you were asked about, again, if you could explain to the jury when something in there in the health data says steps, what exactly does steps mean?
As I said before, the phone is seeing movement. Doesn't necessarily mean you're taking steps. If you have the iWatch paired to it, you're going to get a greater level of accuracy, and I would be more apt to believe that steps are being taken because it's going to also bring your heart rate. So if you're taking a large amount of steps, it's going to correspond.
Now, you were asked a lot of questions on cross-examination about just the health data and just the health data. Why is it that you would look beyond just the health?
Well, you have the GPS points as well as the health data. We're trying to look at everything together as a whole. You take one artifact and say, well, this means this, but you could have 5 others that disclaim it. So that's why we look at all of this stuff.
Now, from that same information, as far as the GPS data, that indicated that Mr. O'Keefe's phone arrived at 34 Fairview Road at 12:25 a.m., correct?
Yes.
Now, as far as the clocks or the 3 different clocks that was presented to you that's now been marked for identification, you indicated that those were not accurate. Is that correct?
Well, the file that it's coming from is not accurate. So it came from a power log file that's the database it pulled from. So that it's telling you the power of the phone. So when I looked at that, that also shows the battery level. And that's how I was able to show that, or see, I should say, that John O'Keefe's phone never turned off. It dropped down to about 17% battery level. From being under his body, it was actually saved it from dying overnight. Then it also shows the timestamps of when it gets plugged in and as it goes up. That has 3 different timestamps. That's what that is from. That is not when Waze has started. That is not when the address is put in. That is strictly for the power log. There's nothing to do with anything else.
And so, again, just sort of to that point, what, if any, connection to those timestamps in the the document marked for identification Mr. Unetti showed you, what, if any, relationship does that have to the timestamps contained within either the Waze or the GPS native locations or anything else that you were testifying about before?
It's literally showing that Waze has been opened and that it's pulling power from the phone, and that is it. That is nothing else.
Now, with regard to, you were asked some questions about Ms. McCabe signing a consent for extraction on February 2nd, 2022, correct?
Yes.
And Ms. Kerry Roberts, she did the same on the same date. Is that also correct?
Yes, I believe so.
Now, the entirety of those extractions from both Ms. McCabe's phone and Ms. Roberts' phones, those were both provided well in advance of the dates the council was indicating, correct?
That is correct.
Ironic how O'Keefe's body kept the phone from dying overnight, but the phone couldn't keep O'Keefe from dying
Celebrite
overnight.
extraction in regard to Mr. Green's affidavit. Celebrite has periodically updates the versions of their software, correct?
That is correct.
And if you could you speak a bit about sort of the update in those versions and how that pertains to this case and specifically Ms. McCabe's searches.
So the initial report that I created with version 7.53 did not have that item to be able to be taken out. I was told by Cellbrite that 7.55 was the version that was enabled. Mr. Green used version 7.61. So that's why it presented itself then.
Can I just stop you there for 1 second? The version that Mr. Green used, was that available at the time that you did the initial extraction?
No, it wasn't available for like a year later. It was like 10 upgrades later.
And the jury's eyes glaze over.
So again, he did the extraction. He looked at it, finds this artifact that's parsed out. And then I had to go back in and scramble to say, well, why didn't I see it the first time when that report, why didn't it pull? So I reloaded the 7.53 version. It's not there. And then when I loaded into 7.61, it is. So There's just issue with the software at the time.
But trust me, it's
So,
accurate.
sir,
You
with
can trust
regard
me on
to
that.
those
Yeah.
Google searches, what, if any, opinion do you have?
Dante
as to
hits the
when those
nail on the
Google
head. If they
searches were
put half the effort
When
in
Ms.
proving
McCabe told us
Aaron
that
Reed
it happened at
guilty as they do
6:23,
to clean up
6:24,
Jim McCabe,
and then there was a
Jen
third
McCabe,
one later at
they might be getting
10:35 that,
somewhere. But
again, if she reopened that browser window, it's going to reload the search, and then that was it. Those are the 3 times that I saw in the phone extraction that were real searches.
And why is it that it's your opinion that they occurred at 6:23 and 6:24 in the morning and not 2:27?
this is horrible for a jury.
Well,
They're
it's
just like
physically
"Yeah, I don't give a
impossible to
shit.
search
What
2
time's
things at
lunch?"
once. Her phone, she's searching the daughter's basketball at 2:27, and then she's searching It's Raining Men and a few other things on her phone, listening to music. And I think then she goes to bed a few hours later. So I was told as the defendant asked her to search for those terms, that's when we believed that they were done.
Now, as far as all files are write-ahead log, having things listed as deleted, if you could just speak a little bit more
It must
about
be
that, as
embarrassing
far
that
as
she
why
got
would
caught
something
on
be
national
listed
television
in
by
the
law
file?
enforcement
How does
and in
that-
a court of law.
Again, the user has no
Searching
input
for
on
the
how a
song,
wall
It's
file is
Raining Men.
deleted. It's an
Embarrassing.
automated thing that the database does to clean up. It auto deletes after either programs are closed, it reaches a max data allotment for that page. That is it.
And that would include any sort of call log history that was contained in the write-ahead log or the wall file as well.
That is correct.
And so what, if any, opinion do you have as to those phone calls that you were showing in relation to the contact listed in Ms. McCabe's phone as Coco, as far as whether or not they were user deleted?
Well, again, what the defense showed me was limited thing. I know should be 2 other locations that phone call was listed from looking at it myself. So I don't know why they gave me just the 2 deleted things, but there should be other spots in the database where that phone call was there. So I don't believe that it was user initiated. It was phone initiated.
And that's in reference to the write-ahead log.
So your phone just calls people?
Sort of first in, first out as far as data that comes in. Is that correct?
That's correct.
Now, again, as far as your unit was concerned, you were the only one who created any cell bite reports in relation to any of the phones. In this case, with the exception of the defendant's phone that was created by the Attorney General's office following their extraction of privileged material, correct?
Objection.
So objection is sustained as to the form. This seems a good place to stop. So jurors, we'll take the luncheon break. There is a chance that we may be able to go a full day tomorrow. So just think about that at lunch. If there's any emergency that would prevent you from being able to go a full day.
Sir, it's closing it up, looks like on the chairs, all right, well, all right.
Yeah, so Mac apps.
So there's a chance they could go a full day tomorrow. I'd hate for them to get this over with.
You are muted.
Yeah.
Looks like folks, we're at lunch.
I think the pain is setting in.
It's got to be setting in for the jury. They're listening to a bunch of dry testimony about data and wall files and deleted text messages and accuracy of data. This is just not. It's not good for the state, to be quite honest with you, because your jury starts to drone out and probably pay more attention to the ceiling fan than they do the actual testimony there. But Dante actually hits the nail on the head. They're spending a lot of time trying to clean up Jennifer McCabe, or their honestly lack of good memorialization of the crime scene, the lack of good investigation. They're spending more time trying to clean up their incompetence than they are actually proving the defendant's guilt, is what the state should be doing in this case. And I think it's going to backfire. I think at the end of the day, like this testimony you're hearing right here, when the jury goes back, it's just going to be a blur. They're not going to remember that. They're going to, whatever other things that keyed on that was interesting to them or struck them as super important will be stuck in their minds. And that's what's going to help make the decision on this. And I'll say again, It's either a hung jury or acquittal. I don't see a conviction in this with the way the state's case has gone and the way the investigation went.
No, I agree on that.
Well,
Hmm.
we're good there then.
So, I'm sorry. Is he done or the trooper?
I think he's going to come back after lunch.
Oh,
I
okay.
think they've still got some more to do on cleanup.
I'm confused as to why they're not keeping their Celebrite software updated.
Well, it costs money, and what he explained there was the update that revealed the search. The detail of the search was it didn't come out until a year later, but they have to pay for those updates each year. Well, I say that the enforcement agencies can buy packages what gives them so many updates, but it's not always 100%. And the other thing about it is that this doesn't just pull out of the data, so it's just so easy user friendly. You got to be able to decipher it. You've got to be able to analyze it and the good foresee your nah, hang on, I think two of us are doing this at the same time.
You were rubber banding, son.
Yeah, sorry. Um, I I forgot what was that. Sorry. How am I now? Can you hear me now?
Yeah, I got you.
Uh, and I'm curious. Or I mean, it's been guaranteed.
I'm not sure if you can hear, but see, looks like the stream has stopped and you're rubber banding.
Well, I'm trying to get that sorted out to put a
Yeah.
screen up for the stream. Yeah, it's having some issues there. But now, is that better?
Uh,
No.
no. And the banner at the bottom of Court TV is stopped. And you know what? It might be on my end because my stream on YouTube is not. You go ahead. It may be on my end, Joe. I'm going to drop out and come back.
How about now? Hope folks can hear me. I don't see any issues on mine, but there could be. You know what's weird is I'm not able to put up a background, which is odd. Yeah, I think I'm having some internet issues here. Untactical text is saying I'm still rubber banding a bit. I may be having some internet hiccups here, folks. It is kind of freezing up for me. Give me a second. I'm going to be silent while I try to work on this. All right, folks. Hope you can hear me better now. I don't see an issue with my internet. We're rubber banding. We may be just having some atmospheric issues, sunspots, solar flare. Our good friend Smokey has said that expect some solar flares between now and the end of July. I will assume that that's it. Let me see if I can get something else. Our good friend Untactical Texan says that is better. I'm going to put John back on the stage. We might be back in action, folks. There is John on the stage. Let me get this BS off there. There we go. Okay, so this morning's testimony. Sorry about all the hiccups there, folks. We'll get back into a bit of a lunchtime recap here. But going off this morning's testimony, we've got our Celebrite expert, the state of Massachusetts state police expert. These are not the subcontractors that we've heard from. The person that did the initial extraction out of the phone. The guy seems to be pretty straight on his information when he's on a direct examination. Didn't hold up so well, I think, on cross-examination. And I'll give you an example. When he talks to the state about this pedometer that's on the telephone, on the guy's cell phone, O'Keefe's, he says that, oh, well, it shows these steps. It shows elevating stairs here and there, but he didn't do that. That is incorrect. Didn't give another alternative. Didn't say, you know what, it's possible that he did it, but it's also possible that he didn't do it, which is the actual truth. They can't say either way whether they are truly steps or they're not steps. So it's kind of inconclusive. The data is there. The data dumps on the phone. They can see that. And the phone doesn't say, yes, he recorded these steps, but don't worry, they're not really steps. The phone data doesn't say that. That's his interpretation of it. And he's using that, and he wasn't very good to explain this either, even with the defense. But he's using the fact that he's got the Waze data and the timestamps and the locations on the Waze, and he's making the assumption that he's in the vehicle, so therefore he could not be making steps. He could not be going up and down stairs during this time period. That's what this guy's kind of saying, but he wasn't very clear about it. And then we go to the defense, and of course, the defense, rightly so, says that it says it took steps. No, it doesn't. Well, yeah, actually, technically it does. The phone actually, that's what the data actually says. Now, you may interpret that a different way, but the data actually says he took steps and he went up and down stairs. And the guy was, what I say law enforcement are horrible about doing when they're testifying, when the defense starts cross-examining, they clam up and they start guarding their evidence, they start guarding their case, and they defend it. When they shouldn't, they should just tell the truth. That's literally what they're there to do. Another example is the time frame when the first stamps, I think it was 12:11 in some seconds to 12:21 in some seconds. Yannetti was saying that, well, it shows that this is the window, but it doesn't mean that it started at that time and ended this other time. These steps could have taken in any range in between that time frame. No. Well, yeah, that's exactly what it's saying. No. He finally relented and capitulated that, yeah, well, it could have, but it didn't, is what he's saying. So I don't think he comes across real well. If you're sitting on the jury and you're leaning on the defense side, which I think there's probably some in there that are doing that, leaning to the defense side, that's going to put him as an adversarial, untrustworthy testimony in your mind. Is that guy? This guy's just cut, just like I said, he's just cutting for the state, no matter whether it's right or wrong. He just wants to win. So I think the guy didn't come across as well as he thought he did when on cross-examination. And then, of course, back on a redirect, Lolly he's back to cleaning up the state's. Well, let's talk about the McCabe house long to die in the cold search at 227 and why that couldn't be. Why didn't you find that the first time? And had to go back with a different. They're having to go back and clean up too much stuff. But the other thing that I want to bring up, John, and then I'm going to pitch it to you, is that I don't like the way when he talks about the evidence that would be exploratory as far as like data, GPS signal was, so we got a very large plus signal there. When it comes to John, he's well, we got but he was 3 feet. But he can't explain how he did that. Once you use GPS, the last long that's that plus just look from the circle there, it could be plus or minus 30, 40 feet, literally. You said Google Maps, the part of the house appears to be 32, 40 feet from the roadway. You look at the circle, the roadway to the house, so that we're looking at 40 feet of plus minus. So you use the Latin long to say that's really 30 feet.
Joe, you were rubber banding after you said you was going to shoot it back to me.
Well, let me shoot it back to you then. Go ahead. How about that? You got me now?
Off and on.
All right, folks, I'm experiencing some internet issues here. I'm really concerned that if I go down, we're going to lose the feed.
Yeah, that's that update Spectrum did.
Go ahead and if you take it, John, let me work on my internet.
All right. So, reading through the comments here.
Am I back?
Yeah, go ahead and try it now.
How about now?
Yeah, I got you now. I'm sorry, it was locking up on my end too.
Okay. All right, maybe I fixed it. What I was saying is that I'm just kind of start over in the second phase of what I was saying. The other thing, the issue that I have is when they talked about the plus or minus 3 feet, where John O'Keefe's body's lying. The guy goes into detail talking to me. It makes me laugh. He pulls out a cloth 100-foot tape measure. They have that. They only use it to measure from when he says, I believe we located the location of John O'Keefe's body within 3 feet. And he's saying that he used the Latin long off of the data that the search team came out and used, which is also, once again, we've established this area. Albert said, oddly enough, he said, my house is a dead zone, talking about cell phone service and most likely GPS service from what we're seeing with Waze and we're seeing with the actual cell phone data, the GPS on board the actual cell phone of John O'Keefe's cell phone. We know that you go back to that blue circle that they showed, that the roadway to the doorway, as Dante says on Google, is somewhere between 40 and 50 feet from the roadway. So it's not a short distance from the roadway to the front door. When you look at that, the accuracy circle that's showing off of the onboard GPS from John O'Keefe's phone, it shows that circle. He could be inside the corner of the house, or he could be at the roadway. He could be anywhere in that circle, is what that circle means. Now, it makes an assessment and a guess. The phone does that the center is it, but it can be, like I say, it can be plus or minus. But he comes and he says, well, we use the Latin long from John's GPS to say that we were within about 3 feet of where his body was at, because nobody marked it when they removed his body. Nobody had the forethought to say where his body was found might be important from where his head to his feet were. We see it in old movies, the chalk outline. That's a real thing. Y'all know why they do that? So they can come back later and see where the body was at, because that's sometimes important. But he doesn't do that. And he says that we think we were pretty close. within plus or minus 3 feet, and then we measured that to the doorway, and he's trying to exclude the fact that John O'Keefe could have never been inside the house according to the cell phone data. But the fallacy to his argument is that you're plus or minus 30 or 40 feet. You've got 40 feet from the street to the doorway. He literally could have been in the house according to the cell phone data there. And there's no accuracy whatsoever on how this crime scene was laid out. If they had to go back out there and recreate this tomorrow, you couldn't trust that crime scene. You would literally have these guys. Well, it seems like this was over here. Let me see that picture. Where this at? Try to scope the picture out and try to put the piece of plastic or the glass or even John O'Keefe's body wherever it was at. I have not seen one picture of John O'Keefe's body on scene. Now, he did have a pulse when he got there. Life-saving measures are going to be paramount. But you got to remember, we've got body-worn cameras. We've got dash cameras in a car. The arriving officer on the scene should have enough wherewithal to either just turn his car towards the crime scene and actually get a record of the crime scene. But we haven't done that. And it bothers me all the way through, especially on the state trooper side, that the times when they come into something for the first time, they don't record it. It seems like there's some time period that passes. And I'll go to Karen Reed's vehicle. When they first make contact with it at the house, first time they lay their eyes on it, they don't take a picture, but they just want us to take their word on what it looked like, that it was damaged. Of course, you got the Dighton police officer that comes up and says, it was cracked, a little piece missing, but it wasn't completely demolished, which is what we're led to believe with all the pieces that are left on the ground. So, and that's where I'm going to throw it back to you, John. The guy's testimony, I think, is a nothing burger. I think at the end of the day, the jury's just going to kind of dissect that out because it's too confusing and you got to go down too many rabbit holes and connect too many dots and draw and pull strings between points to try to really figure out what the guy was really saying. And I think the state's blundered this on cross because they've spent all the time just trying to clean it up and trying to make all the BS that he said make sense so that an average person can understand it.
Yeah, and I can't help but wonder if the jury hasn't decided a long time ago just the preservation of the scene. How can and you find all these discrepancies and these no, we didn't do this, no, we didn't do that. To your point, I mean, like the fire hydrant's not going to move. At least have a starting point and mark this stuff down. And as a juror, I wonder if they're not saying, well, yeah, when we first started this, we're relying on you to tell us the facts. Now it's shown incompetency, if nothing else. It's like, well, can we believe what they're saying? And then as time goes on, you've got all this other stuff. But yeah, back to the GPS and what he was, he draws that circle and says, well, he can be anywhere in this. I remember a missing person case we had down near a lake that's near me. We triangulated, this was years ago. So they did that triangulation in between, like 3 cell towers. They said, okay, well, they're in this area right here. Hell, it was within, and it was mostly wooded. There was a little bit of water included, but it was mostly wooded. But it was like, can you narrow it down anymore? No, we cannot narrow it down anymore. Same thing goes here. You got a general idea, but it can be anywhere in there. And then back to Dante's point, yeah, you look at that map that they produced as evidence. How can you say that he wasn't in the house? I mean, it clearly, that was, that circle was encompassing at least, at the beginning, 3/4 of the house. And then, clearly his body got put out there somehow. So that, to me, that explains, when you get further along in the timeline, how that circle, minimized. I mean, you got outside of a house that's supposed to be a dead zone, number one, and then you got it more pinpointed into where his body was actually found. So, I mean, there's just reasonable doubt written all over that, and I think that's what a lot of people in the public don't understand how that technology works. You can't. I mean, I know they narrowed it down more now today, but at the time this happened, I mean, that's what you've got. So how can you definitively say, no, he wasn't in the house, or yeah, he was in the house? I mean, it was encompassing it. I just think he done a real bad job in explaining that.
Yeah, I think they did a poor investigation, and a poor investigation is difficult to explain or to testify to on the stand because it doesn't hold up under scrutiny because some obvious things are unanswered questions in there. You speak about using cell phone data to do location. I was we were looking for 3 murder suspects, and they were in an apartment. Well, we had them pinged a phone, uh, found them to be located in an apartment complex in Grand Prairie. And the first ping was plus or minus, I think, 20 feet, 25 feet. Well, 25 feet in an apartment complex, not very big apartments, could be one of 4 apartments. Because it's a top, upstairs and downstairs, and four apartments in a building, top floor, 2 floors, top and a bottom. So I'm looking at it. I'm like, well, I know they're in this building. I don't know which apartment it is. So we kind of wait a bit. And a lot of times you can, depending on how the cell phone signal gets, because that was they're doing exactly what you talked about, John. They're using cell phone towers, three cell phone towers, and they triangulate the signal and the signal strength, and that will give them the location. And I'm literally sitting in my truck. Investigators are out, which is kind of watching to see if these guys leave. Because they're not, it's not a place they live. They're visiting there. We find out later, but it's not like we can find out they're on the lease somewhere. Or this is their home. They're not. They're visiting a friend at this location. Been there about an hour, and I keep hitting Verizon. Was the cell phone company? I keep hitting Verizon up. Hit me a ping again and see if the location improved. I'm looking if I can get within 5 feet. That would at least narrow it down to 2 apartments, an upstairs and a downstairs. I don't know if it's the left or right, upstairs or downstairs apartment. And never did. I think the best we got was somewhere just over 10 feet, 12 feet or something like that. But it was never enough to say that they couldn't be in the apartment next door. And we were kind of limited on exactly what they looked like. Had some limited descriptions on it, but they actually walked out of the apartment, got into a car, and drove out. Now, we did notice the car. I put a vehicle on it, but I wasn't 100% sure that was them. And I was on the phone trying to get the phone pinged again to see if that phone was moving. And I had Grand Prairie officers that were ready to knock it down. And it was less than a minute after they pulled out of the parking lot, the guy in the apartment come down and says, "Hey, yeah, I think y'all are looking for those guys." I said, "No, absolutely, we are." But to let you know the accuracy of that and where you really can't be sure of it is that I knew they were in that building, this apartment building, but I couldn't I couldn't have said with any certainty which apartment they were in. And that was with 20 and 10, 15, and 12 feet a plus or minus error margin. What we're looking at here on the Reed case, it is 40, maybe 50 feet in a circle. So that's a huge area. When you're talking about documenting a crime scene, and go back again, you see it in movies, the chalk outline of a body. We don't do it that way anymore, but the head and toes and where the extremities are at, those areas are marked. So when the body's removed, you can come back and replace that. You know exactly where the body was found because the body's not going to stay there, especially if someone has signs of life. You're going to get them out of there pretty quick to try to save their life. But you still mark at least the head and the feet where in the orientation of the body was. But once again, just another example, either incompetence or criminality. I just don't know which one it is, but I think it's definitely one of those, and I think it's going to hurt the state's case.
Oh yeah, most definitely. I don't know, and like I think I said earlier, I'd be wondering if they don't go back and change some policies and procedures, or at least make people follow the policies and procedures they have on the books today. So, because clearly this is putting the agency in a bad light.
But this can't be the first time these policies, they're so egregious, honestly. This can't be the first time that they're challenged. If it is, that's actually a sad statement for the court system in that state. And I think I said this before that when you have police that are this bad and DAs that are this bad, that they just kind of run roughshod over the defendant, courts in that state are responsible because courts should be holding them to bear that a DA should look at a case and say, "Hell no, I'm not taking that to this district court. I'm not taking it to this judge because I'll get my ass handed to me." I know in the jurisdiction that I worked in, the jurisdictions actually that I worked in here in Texas, um, I can't think of a judge that I could try to get some bullshit across in the first place. But I damn sure didn't have any DA that was going to allow me to try to get some bullshit across. I mean, you had to come straight. It had to be reasonable. Um, you had to prove your case. That's what the state's supposed to do. It's the burden on the state. It's not the advantage to the state. It's a burden on the state. But I'm not really seeing that there. And I would actually go a little further and say that this case should be an indictment on the local court system there, that they have not held law enforcement and the DA to a little stiffer standard than they have to bring. This is not the first time. I guess is my point. We know there's other cases that this kind of stuff has gone through. Maybe when you didn't have a defendant that was a professor with the cash that she's got. And by the way, folks, um, you're seeing what money can buy as far as defense. When you talk about when Renetti gets up and he starts speaking about all these data points and stuff like that, he didn't listen to a podcast last night to come on and step up and talk about that. That's hours. That's hours of going through the details of talking to experts and trying to understand the data well enough so that he can do a good cross examination. When we talk about Alan Jackson, he's very good on cross examination. The things that he's done, that is hours. That is hours of reading and detailing and laying out and coming up with your strategy on how you're going to do that. And all those hours cost money because they're charging her by the hour. So if you think that your middle class guy on a DWI or your middle class guy that's getting charged with an assaultive crime is getting the same play, you're absolutely wrong. You're not going to have a defendant or a public defender or even a paid attorney that's going to put the time and effort that these guys are putting into to bring themselves up to speed to be able to provide one, find loopholes in the state's case with the technical data, and two, be able to put on a cross examination the way they've done and as artfully as they've done. Um, and that's a shame for the citizens of Massachusetts, in my opinion.
Yeah. How do you think the 3 seconds to 3 minutes time difference on apps using different clocks, how much do you think that weighed in on the jury, if any?
I think the jury's about asleep by that time point. But although that was an interesting point about the 3 times, because they're right. There's I think there's 4 clocks actually inside the phone. But the phone needs a good time to be able to determine location, because the way a GPS works, it gets datum from satellites. It can do it with 2, but it's better with 3. But essentially, the satellite knows where it's at, and it knows how much time it takes. It knows its time, the mean time, and it literally does the phone does a calculation by how long it takes for the satellite signal to reach the phone, and the location of the satellite, and the time of the satellite and the time on the phone. It does a calculation, and that's how it's able to actually give the actual location of where you're at. So when you have poor satellite service, you may only be hitting with 3. You get down pretty accurate. 4 makes it even better. But if you can only have 2 satellites, sometimes there's only 1 satellite. That's when your cone of error is going to be quite large, because it's only 1 satellite. Kind of half. I know what hemisphere you're in. I kind of maybe know what even state you're in, but I'm not really sure after that where you're at. With 2 of them, I can narrow it down a little bit more. With 3, I can lock it in. With 4, I can start getting some pretty accuracy where I know exactly where you're standing. But they never had any of that in this case. But I think the time difference is huge. But I think it went over the jury's head. I think they were literally glazed over and ready for lunch at that point. This testimony's been pretty boring.
It'll be interesting also to see how many cases are brought up for appeal that the Massachusetts State Police has investigated. I'm just a nerd that way. I'm gonna try to keep up with that because they've, and like you said, it all goes back to money. How many people have not had the money for the defense that Karen has had um, to prove all this? Prove to help prove her innocence. And like we said, I think about a week ago, how many people just throw their hands up and say, "Yeah, we'll take a plea." Um, I don't know. It'll just be interesting to see if that
Well, I
happens.
don't I don't know that to get an appeal, you got to look at the fairness to have new evidence. New evidence is the only thing that would be heard on an appellate level. Otherwise, you're going to have to see some sort of infraction before you get an overturn. So I think it's a case by case basis. I don't think it's going to be a general blanket. There's some bad techniques going on here at the Massachusetts State Police, so therefore every case comes into focus. But it's going to be up to unfortunately, to the people that are, if they feel like they're wrong or they're wrongly incarcerated, it's going to be up to their attorneys to take this information that's out here in the hemisphere the stratosphere for all to see and try to patch together a case on it. So I don't know that you will see a wave of appeals or some protest on cases or claims of improper evidence handling or anything else that you can think of is coming out of this case. I don't know that you're going to see that coming out as a just direct effect of this, but there could be some ripples down the road.
Yeah, I mean that's true. I just I just wonder how many attorneys like they've seen a lack of evidence or whatever the case may be as it pertains to how they've handled previous cases. Because I think Kingdom said the other week, this ain't the first time they've done this or the first one. Then how many are going to have to sit on their hands and say, well, we don't really have a way to do this for whatever reason. I don't know.
It'll cost money. For every appeal, it will cost. There's some foundations out there that do some great things. In our show with the guy Laura, retired Marine that drove from West Texas to California, and they took his $87,000 from him, even though he had bank receipts and they're showing each one's withdrawal. If he didn't have the foundation, I think it was the Freedom Foundation, that stepped up and paid for attorneys, then he'd have lost that. There'd been no hope for him. And that's the sad part about our system is that you got to have money to fight the state because the state, by God, has money. I'm gonna be off just for a second. I'm doing some more internet stuff. I brought me up on the laptop, so we shouldn't lose the feed. But I'm gonna try to reboot the one that I'm in. So I'm gonna be silent for just a minute.
All right.
Okay, do you have me back?
I got you.
Well, I might have pulled that off. In fact, I'm pretty proud of myself. That was ingenious, if I do say so myself. Let's see. I'm going back and look at the questions. Dante had a few things going on. He did make a good point. He says why Brian Higgins and Albert never told everyone to burn their phones is beyond him. I've got a theory on that, Dante, is that they may not be covering up a murder. They could be covering up just some dirty stuff as far as cheating on wives and some other things that are going on. Oh, that reminds me. Let's go back to the voicemails where she's calling him a pervert. She's saying,
Yeah,
John,
what
you're a
was that
pervert.
about?
Well, I don't know. Somebody had made a comment. Of course, this is complete conjecture. What I'm saying here is there's no evidence to it whatsoever. It's just complete imagination is all I'm saying. But somebody had brought up this party could have been a swingers party. And maybe that's where there was some sort of a rub that this could be a little group of swingers out there. And when she said pervert, that just brought back to my fore. Well, I mean, I can't remember who it was that said that. I don't know if it was somebody on the show or maybe somebody like even Dante. Dante and Veteran, you guys kind of caught most of these shows. If y'all can remember who it was that brought that up, it was about a week ago that it was brought up. And I laughed it off then. It's like, well, y'all can't. You have no evidence to that. But then again, she's calling him a pervert for going to this party and absolutely wasn't happy about it. But that actually has nothing to do with the real case. But I tell you what, let's dial it back to this. So after hearing the voicemails, would we say that, and this is for everybody, a question for everybody, would we say that is the behavior that you would expect out of a scorned partner. If their partner is at a party all night, not answering the phone, not responding back to text messages, and you've already got some suspicion that they're messing around with someone else, maybe someone else that's at this party, w- would you expect to get that exact type of voicemails, or would you say the text messages and voicemails are over the top and it seems to be um, something that is leading towards guilt?
No, I still say, like I said a while ago, I mean, clear she's already demonstrated, uh, and don't get me wrong, I think she's innocent here, but she's already demonstrated how controlling she was. And with him not answering the phone, and if she had a an inkling or knowledge that that's what was going to happen, that maybe that's the reason she didn't go to the party. She wasn't, that wasn't her thing, but it was his. I mean, they're already on the rocks. But when he's not answering his phone and answering his text, where's her mind going to go? Well, he's occupied doing something or doing somebody else. So I can see her flipping her handle off on that. I can definitely understand that, but I still don't think it goes to the point where she done something that like they've accused her of doing. I don't see that.
Yeah, I think the voicemails could go either way, but I'm not shocked that that's what if there was no homicide that night and you just pull those voicemails up under the circumstances and situation that they were in, I'm not surprised that she said those things. I don't think that it's incriminating, I guess is what I'm trying to say.
Yeah,
I'm
I don't
I
either.
guess you could say it is, or you could look at it from a different angle, but I think in of itself, we've all been in relationships where things aren't going well and things will be said. But, Vet says the, voicemail is a big nothing burger. I've had arguments with my wife in person that were heated, but, she wouldn't kill me, I don't think. Well, not yet, Vet, not yet. You better keep smoking that meat the way you do, that might, save your life.
That's his saving grace right there.
Of course, his next comment is, "That's a joke," but I'm not gonna post that because I want everybody to know that's a joke. I'm gonna help, tighten up a case right now. Actually, I'm lying. There we go. There, it's a joke. By folks, you don't know, veteran LT3's wife is a very sweet lady. She's a saint. She puts up with him. That's all you need to know. A true saint. So, but that's pretty much what was covered this morning on this morning's break. Um, I can't think of another subject to dive into other than we're just going to keep regurgitating it. We for those of you who missed it, there was um, prior to the jury coming in this morning, the judge did give the decisions on the voir dire or the voir dire, as they say in the Northeast. From Tuesday, they are going to allow the dog bite or the animal bite expert to testify, but her scope is strictly inside the scope of dog bites or animal bites. Can't talk about police procedures. Can't talk about ER medical procedures and things like that the defense was going to that said they would like to talk about with her. Um, the ARCA folks, the guys that the Justice Department hired that are accident reconstruction experts and biomechanical engineers that study uh, kinetic or impact injuries to humans. They're going to allow them in, but one of the persons, Wolf, is coming in as the defense wants. The other guy, and I forget his name, the second one that testified, if you watched on Tuesday, they are going to narrow his scope. He will not be able to testify to any injuries, as they say. She said that, and according to Massachusetts state law, that only medical doctors can um, opine or give opinions as to what caused an injury. Um, so that's the outcome of the voir dire on Tuesday. So those decisions are made. I do expect to see the defense kind of push back on this biomechanical engineer not being able to speak about injuries because that's like literally what they do. Maybe even more so than a medical examiner when it comes to injuries, not just maybe the cause of death, but determining what are the facts and the details and the mechanics behind human injuries when it comes to like impacts, falls. I wouldn't even say I wouldn't be comfortable maybe with the guy with a gunshot wound, but I think when it comes to impact strikes, falls, blunt force trauma, I think these guys can most likely or rightly can testify, and I think they're certified in other states and in the federal court system to do just that. So I do expect the defense to push back on that. She said she would hear it, but we won't hear that until next week. And then we had very dry testimony after that about cell phones, Celebrite data, Waze, plus or minus accuracy data, whether a phone call was made, whether the phone dialed itself, whether it was actually done. Headboards and pre-write boards inside your phone, these data logs. We had that testimony, which was, like I say, it's hard to stay awake during some of that. Somewhat interesting for about 5 minutes, but after a while, it gets like, yeah, I'm kind of tired of that. But we've got one more day left on the prosecution according to schedule. Judge did say tell the jury before lunch that, hey, think about doing a full day tomorrow. So I'm hoping we're going to see the medical examiner. Although if that medical examiner doesn't get on the stand today, I don't know that you can get the medical examiner done in one day. I think between the long the state's going to keep the medical examiner up there to go through the detail and process of the autopsy and the opinion of the medical examiner, and then for the defense to get up and begin to cross-examine on that, we've got a fan, so I'm going to get us back in there. But to get a cross-examination, I just don't know if they're going to be able to do that in one day, but we'll see. Really hoping the medical examiner comes up pretty quick. It's going to be more interesting than what we're dealing with right now. Okay, folks, there it is, the fan. That is an indicator that the camera's live in the courtroom, and they'll be moving in some jurors and getting us started back again. And I do hope that we're about the end of this trooper's testimony, especially on the redirect, because like we said earlier, the only thing the damn state's doing is trying to clean up their crappy case, and it just like okay, all right. I'm kind of over that. Can you imagine being a juror, having to sit through and listen to that? You know, at least we have our cell phones and we can talk to each other and we can go back and forth. They just have to sit there and suck that up. Poor guys. It's almost inhumane to make somebody listen to that for hours on end. I tell you what, while we wait, I'm going to do something that Kingdom wants to do. His little video here on the Michael Proctor Day 1. We won't miss anything. I'll bring us back if the ceiling fan goes to live, but let's listen to Michael Proctor's Day 1, Kingdom radio style.
Welcome to Michael Proctor on Kingdom Radio.
Appears to be a picture of a toy Santa Claus. I never received a gift. I never asked for a gift. My wife never received a gift. She never asked for a gift.
On Santa's naughty list.
Wasn't sharing anything specific on cases with my family or anyone. She's a whack job. Cunt. C-U-N-T. States, okay, that's fucked up. She hot at least? Yes, she's a babe. No ass. Is that chick a smoke? Nut bag, as Chief would say. She's got a leaky balloon knot. Leaks poo. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him. Sergeant Mechanic liked it.
Like what?
I'm going through his retarded client's phone, sir.
Did the warrant say anything about looking for nudes?
Objection.
Did it
say
something
for nudes?
No, Your Honor.
No, it didn't.
That would be an abuse. Hey, McFly!
You indicated 15th, correct?
What do you think you're doing? Hey, I'm talking to you, McFly, you Irish bug. Hello? Hello? Anybody home? Hey, think, McFly. Think.
You indicated 15th, correct? You indicated 15th, correct?
I respond, said the Alberts beat the shit out of O'Keefe, left him for dead, and the very least it's suspicious. That's another animal we won't be able to prove. She's gross. Trooper DeChico, oh, fuck her, bitch. I text my wife, waiting to lock this whack job up.
Fucking must into my shoes. No crew's gonna be looking for him.
That's another animal we won't be able to prove. I called earlier. Mom was puking in the background. This is your livelihood, and the very least, it's suspicious.
I hate that man. I truly hate him. Correct?
Correct.
You didn't say I dislike him, disagree with him. You said I hate him. Correct?
Correct, sir.
That's a visceral response to someone who's just doing a job. Most important early in the investigation, because that's when the most things are up in the air. There's the cloud, the fog of not knowing exactly what the truth is. In other words, Trooper Proctor, you don't get to pick a suspect and then try to find evidence to support your choice.
Correct.
But in this case, it's exactly what you did, isn't it?
Rookie move, not going into a meeting with the ME and getting that homicide determination. Dear God, WTF, what the hell is inconclusive about the whole thing? Of course, it's undetermined. She was a whack job. Yeah, but there'll be some serious charges brought on the girl.
Okay, you got 10 feet, closing. 10 feet, easy. Hold it straight, get against the line.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m.
So in this video footage, I could tell you that the video is triggered by motion to record.
She said when this is all over, she wants to get you a thank you gift. And I respond, get Elizabeth one. Elizabeth's my wife. If you like women who shit themselves, Christ, it was on BWC, which is body worn camera.
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged. But not completely damaged. But not completely damaged.
Follow the Karen Reed murder trial on Kingdom Radio.
There you have it, folks. The Kingdom Radio recap of the Trooper Proctor testimony, which I think B said it best. This is like the crazy train going off the rails. That was some unbelievable testimony that you're just not going to hear. You shouldn't hear, actually. You shouldn't hear that from a state police officer or any police officer on the stand speaking about a defendant and behaving the way that he did. And that's just some of the kind of the cruel and biased things that he said. There's actually some ways that he conducted that investigation that, in my opinion, they lack the professionalism that one would expect from a police officer. And I still say, and I think this is where a lot of people are at, is that is going to be a hard thing for the jury to get over. They're going to have to get past him to get to a guilty verdict. But really, it's one obstacle. Once you get past, you settle in your minds like, okay, Proctor's just an asshole, but he didn't do anything to set this lady up. Okay, you get past that. Then the next step is you got to get past the Jen McCabe thing. Well, now you got to figure out how to get past that. I think there are too many hurdles that one has to get through in their mind to come to a beyond a reasonable doubt that Karen Reed killed John O'Keefe. Is kind of my opinion. We sure got we got a long ceiling fan going on today. They should be back in court and at least some audio going on by now. You still with us, John? John may have stepped away for some lunch, so his blood sugar didn't fall too low.
Oh, I'm
Start
sorry.
talking crazy.
I'm back.
No worries, my friend.
Yeah, I think they're They should have been back. I think, yeah, 145.
It's no telling what happened. They could have caught a juror talking to Turtle Boy on the outside or something, and they're in the process of kicking them out. It's not like
Yeah.
that hasn't happened. Not the Turtle Boy portion, but they did dismiss a juror for trying to do their own investigation.
As long as this is going on with all the evidence, I wouldn't be surprised if they don't deliberate, come back with a verdict within a day, 2 at the most.
Whoa, are you laying down odds on how long the deliberation is going to take? That's bold, my friend.
Yeah,
That is
I
bold.
don't see it. I don't see it taking that long. I really don't.
Yeah, in all the cases that I was involved with that went to a jury, I don't think we went more than a day. I never had to come back the next day. Some of them were quick. I've had some that really surprised me. I mean, it was long because they'll go out and they kind of cleared in the courthouse that I was in. There was a portion where they have to walk out into the public hallway to get to the deliberation room, which was literally an old bank vault. By the way, it was really cool deliberation room. It had a big bank vault door on it. But so they kind of cleared out that side, so they go to the bathroom, get something to drink, water, and then they would get them into the jury room, and then they would open up that area again. So you kind of see there, and when the jury goes out, they're going to do the bathroom, they're going to do the water, and get something to drink, stretch their legs, but the deliberations don't start for a few minutes. They had gone back and they had just enough time to get themselves a drink, use the bathroom, go into the jury room and say guilty, and then that was it. It was so quick. I was really surprised. In fact, I was downstairs getting myself a cup of coffee at the time, thinking I had some time to do it, and I couldn't even get the cup of coffee. I had to run back upstairs to hear the verdict for a guilty.
Yeah, I just don't hate keep beating a dead horse, but I think they've already made up their mind.
Well, now if you say that, what if all of them haven't made up their mind? What if there's two people in there that are leaning your direction, which is a not guilty?
Well,
Uh,
I guess that's when one or two of the others just say, well, let's go back over it right quick. Start at the beginning, da da da. We got this, and I don't know. Maybe I'm hanging my hat on the dog bite, and
Well, I think you're hanging your hat on evidence that's not in that or facts that are not in evidence. To be honest with you.
well, no, I get that, but I'm just saying, well, even up at this point, when you've got some eyes raising at how some of this was done and things aren't adding up. I mean, you got to remember, you got to have reasonable doubt. If you've got just a little bit of a reasonable doubt, how can you convict her? Set the dog aside.
No, I don't disagree with you. I just don't know that, like some of the stuff that we hear on the news media and stuff that we talk about, the jury doesn't hear that. I think they're going to stick. I think you go back to the crime scene. If you really want to know if she did that, then you unscrew the puzzle of how those taillight pieces got there. Either they got there because she struck him, and that's how they got there, like the state asserts they did, or the state planted them there because there is no in between. So in my mind, that's where it comes back to. If you could settle that in your mind, either they got there because the vehicle struck John O'Keefe, she's guilty. They got there by some other means, she's not guilty, and that's why I've gone back to that. If I think if I were the juror, when I get that in my head where I'm beyond a reasonable doubt one way or another on that, then I'm ready to. Then that's my ground. That's the hill I would die on. Whether it be a hung jury or an acquittal or whether it be convict. Or it could be go the other way. It could be a hung jury for conviction. I would hold out. If I settle that in my mind that the police did not plant that evidence there and that it got there because he was struck by that vehicle, I think I would hold my ground all the way to the end on a guilty verdict, even if everyone else in the room didn't. I would hang the jury, so to speak. But to go back
Right.
to your deliberation time, if it's a hung jury, and I really believe that's probably, I don't know that in that entire jury's reached a reasonable doubt, but I would say that at least one person on that jury is definitely will hang this jury. And you could see a deliberation that could go 4 or 5 days because they can't stop until the judge says, okay, now I declare it a mistrial because you're at an impasse.
Yeah, and I mean, so let's go on what evidence you have. And I know what you're going to say, or have an idea what you're going to say. I'd be curious to know how far from, say, the edge of the road to the fire hydrant, what that distance is. I know here in North Carolina they have a 15-foot right away from the center line. I don't know if that's a state maintained road, but anyway, my point is how feasible is it for 3-4 pieces of tail light to all be found within that little small diameter of a circle right beside the fire hydrant, or right there at the fire hydrant? That would have meant that she had to drive off the road, and all those pieces fell there, but then there was other pieces found elsewhere in the yard. I mean, I
Yeah,
don't see that.
you know what? You bring up a good point because that does bother me too. There were no pieces that I've seen or that I've seen documented that were found in the roadway, and I would think that you would have a splash zone or a debris zone that wouldn't be so linear. Now, the state tried to say that with I've had 24 hours of training, trooper accident investigator. But that we all know that's not 100% correct. We've seen things break. We've seen things collide. We've all seen traffic accidents. You don't see in a collision that all the debris from the front end of our tail light or the headlight or our tail light after impact is strewn in a straight line going somewhere else. Now it may fly in further directions, but it's always something near the vehicle in the roadway.
Yeah.
Good example is if you had a rear end collision, you run into the vehicle in front of you, and all the debris flew off to your hard right and landed in the median. No debris in the street. Highly unlikely, in my opinion. So I agree with you. I think the debris field's a problem as well.
And you're talking about the passenger side tail light. And unless I've got something backwards, that would have meant that she had to. I mean, she would have had this. Well, still, she would have gone way off the road, and it's already got packed full of snow. I don't know. I don't buy that.
Well, the state didn't say that she went off the road, just said that she slight turns ass in towards the yard, strikes him, and then leaves, but knocks him 30 feet, which is a whole nother problem. But Ed says he thinks that once the defense experts testify, it'll be the final thing that turns anyone in the jury that's on the fence. A lot of
All right,
confidence.
so jurors, when we were doing scheduling, and I know scheduling has
Uh-oh.
changed a lot in this case, but my
Here we
main
go.
goal is to get this case to you folks by next week, when we all want the case to you by next week. So originally on the 21st, we were either going to do a whole day, and then we couldn't do a whole day, and there was all of this back and forth, and it was a half a day, and it was because I had something scheduled in this courthouse that was not going to be continued through forces that we weren't aware of. It is going to be continued tomorrow. So in light of that, I would like us, and we will be doing a whole day. I understand that for one of you, that you planned on an earlier start to the weekend or a vacation day or something from the afternoon on. But really, all I'm asking of you is to go from, instead of a 1 o'clock stop, to a 4 o'clock stop. And where I guess 14 of you are able to do that, we're going to do that. So tomorrow will be a full day. Okay, I don't know who I'm inconveniencing, but I apologize for that. Because when I said emergency, an early start for the weekend was not an emergency. All right, could we call the witness back, please?
I didn't feel the compassion in that.
Yeah, I didn't.
All right, folks out there that are watching, listening. We're back in court, and also Big Ron, co-host for the Night Court Show, is also back. I just want everybody to know that stop talking about him, and definitely don't put anything in the text string. He will be able to see it.
It was all good, Ron. I promise.
Oh no, it was horrible. I let it, and even lied a little bit.
All right, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
So with reference to this case, this investigation, who, if anyone besides you, created any Cellbrite reports or extractions from any of the phones involved in this case?
Other than the AG's office, it was just myself.
And now you had mentioned that there was some deleted material from the defendant's phone from the afternoon of January 29th, 2022. Is that correct?
Yes, that's correct.
And what was that was deleted?
There was some search items that were not there in the phone, but found cookies related to said searches and websites visited.
So as far as search terms or web history, were those the areas that were deleted?
Yes, that's correct.
I have nothing further.
Oh, okay.
Nothing further. Thank you.
Okay. So we brought you back for that, Trooper. Thank you very much.
There's a freaking miracle.
All
This
right.
guy is going to get off the stand. He's boring. Maybe it'll get interesting here. Good news.
Your next
Good news.
witness, Mr. Lally.
Yes, Your Honor, the Commonwealth called Dr. Renee Stonebridge to the stand.
Okay.
Are we talking about a medical examiner? Stonebridge, one of those? Do you have a list?
Got it right here. Hold on.
If you could please watch us snap face the clip and wave your right hand.
Do you solemnly swear that
Nice
the
hats.
testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
So once you sit, I'm going to tell you that you have to keep your voice up. We want to keep our air conditioning on. So just if you'd speak loudly into the microphone, that would be great.
I swear to God, if she's got a doctorate in cell phone technology, I'm not sure if
Go
I
ahead, Mr. Lally.
Good
can
afternoon.
much more.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Yes, my name is Renee Stonebridge, last name Stonebridge, Stonebridge.
And what do you do for work?
I am employed through the Chief Medical Examiner's Office at Boston as Director of Cardiac and Neuropathology and Medical Examiner.
Now, if I could ask you just a few questions.
Very
about,
good,
sort
folks.
of
We have
your
an
educational
ME.
Work history background, if that's all right.
Yes.
Starting with your bachelor's degree, where did you go and what, if any, area did you receive a degree in?
So I went to SUNY at Stony Brook in New York. I was a double major in biology and Germanic languages and literature. I graduated with a bachelor's of science degree. After that, I went to the American University of Antigua for medical school, and I graduated with honors, magna cum laude. After that, I did a 4-year combined anatomic and clinical pathology residency program at NYU Winthrop Hospital in Long Island, New York. After that, I did a 1-year forensic pathology fellowship at the Boston office of the Chief Medical Examiner. And after that, I did a 2-year neuropathology fellowship program through Brown University at Rhode Island Hospital.
Yeah, I found her.
And
She's
doctor,
one
are
of the
you
two.
board certified?
Yes, I am board certified in anatomic pathology, clinical pathology, forensic pathology, and neuropathology.
They only need one to
Just
testify.
explain to the jury a little bit about what does board certified mean?
Board certification means that every medical specialty has their own board. So for example, the American Board of Pathology dictates whether or not you can be board certified based on certain criteria. So you have to meet certain criteria, meaning that you have to complete a certain number of surgical specimens, a certain number of autopsies. And then once you meet that criteria, you can take an exam, which if you pass, leads to your board certification.
Now, if I could ask you just a couple, and your board certification is up to date at this point, is that correct?
Yes.
In each of those areas that you just spoke of?
Yes.
Now, if I could ask you some general terms as far as if you could define them for the jury. First of all, what is pathology in a general sense?
Pathology is essentially the study of any sort of disease or abnormal state of the body tissues. So anything that can go wrong in the body and any of the body systems is essentially the study of pathology.
And now starting with anatomic pathology, what is anatomic pathology more specifically?
Anatomic pathology consists of the study of surgical specimens. So for example, if someone goes to the hospital to have a tumor removed, that specimen will go to pathology. The pathologist will look at it, cut it,
look at specimens under the microscope, order any ancillary tests if necessary, and then make a diagnosis, which is then conveyed to the clinician. Anatomic pathology also consists of cytopathology, which is looking at individual cells, and then it also consists of autopsy pathology.
And as far as clinical pathology, what does that mean?
Clinical pathology is anything that is lab related in pathology. So if you have to get blood drawn and then the results come back, that is clinical pathology. If there's any sort of blood work that needs to be done, for example, if you're going to have a surgery and they have to cross-match and type you in case of a blood transfusion, that's considered clinical pathology. Also microbiology, so anything infectious. So essentially anything that goes through a lab is clinical pathology.
And what is forensic pathology?
Forensic pathology is the study of autopsies in a medical legal sense. It doesn't necessarily mean that it's always going to be something that is legal. Sometimes it may be just a person who has not seen a doctor in many years, dies at home. There's no physician that is willing to sign a death certificate. So we work on those types of cases, plus anything that is non-natural.
Now, neuropathology, what is that?
Neuropathology is the study of the brain, spinal cord, eyes, muscles, and nerves.
And if you could, just again, in general terms, as far as casework is concerned, related to your work as a director of the neuropathology, can you explain to the jury sort of what it is that you do with respect to neuropathology?
Yes, so my job primarily entails me to be a consultant for the medical examiners. So the medical examiners have a certain set of criteria that they follow in order to determine whether or not a brain needs to be saved for a neuropathologic analysis. So upon following that criteria, if the brain is saved, it gets put into formalin, which essentially fixes the brain so it firms it up, so it makes it easier to analyze. So after the brain has been fixed, I usually let them fix about 2 weeks. Sometimes it could be a little more, a little less, depending on circumstances. I will then look at the brain, take photographs of it from all sides, and then cut the brain, take photographs, document any sort of abnormalities. And then if I feel the need to take sections to look at under the microscope, then I will take those sections. They will be processed through histology. I will look at the slides. Sometimes you may have to add in additional testing, for example, immunohistochemistry, to see if there's anything in particular that you cannot maybe diagnose solely on looking at the histology. And then once that is done, I will issue a report to the medical examiner, and then they use it in terms of determining their cause and manner of death, if necessary.
Now, as far as that formalin process, as far as the solution is concerned, is there a typical time period that the brain would have to be in that solution prior to you examining it or cutting it or any of those other things?
Usually about 2 weeks, give or take maybe a few days here and there, but I usually try to let them fix at least 10 days minimum.
And again, in general terms, with respect to the types of cases that are referred to you, what types of cases are typically referred to you?
So part of the criteria that we use is that If there is any cases that have blunt head trauma that may be suspicious or homicidal in nature, those will typically come to me as well. Some of the other cases may be just a difficult neuropathologic entity that a non-neuropath trained medical examiner may not be able to really diagnose. And then sometimes there's cases that are just surprise cases where the medical examiner opens up the head and they see something interesting or abnormal and they decide to save that case for me to look at further.
Now, with respect to the cases that you do see, at some point did you become involved in analysis or testing of a brain belonging to John O'Keefe?
Yes.
And who was the doctor that was the medical examiner that made that referral in this case?
It was Dr. Irini Scordi-Bello.
And with respect to your analysis here, obviously you looked at the brain. What, if any, other sources of information did you review or did you look at in ultimately formulating your opinion in this case?
So at the time when I was able to cut the brain of Mr. O'Keefe, I had information that was relayed to us from our intake department. So when a case gets called into the medical examiner, it gets taken by the intake department and they're given kind of just a rough summary of the case. I also had the police report, I had the EMS report, I had the medical records from when Mr. O'Keefe was in the hospital. I also had medical records from the primary care physician. I had autopsy photos, and I also had, I believe just refer to my notes here because I had a lot of notes. I also had the inventory and tracking sheets, which are notes created by the medical examiner, and the neuropath request itself.
Now, are you familiar with some terms in relation to injuries that you would observe as far as from a neuropathological perspective, as far as injuries being acute, subacute, or remote?
Yes.
And can you explain to the jury sort of what those are and what those mean?
So it depends on circumstances. Acute generally is something that happened within a very short time frame. So when I refer to something as being acute, I usually refer to that as something that's occurring from the time of an injury to maybe a day or so afterwards. As I said, it's variable dependent on circumstances. Subacute is something that has not happened within the last few minutes, few hours, maybe even a day, and maybe something that is now in the process of healing. And then chronic is usually something that has happened a while ago in the past. You may see some sort of evidence of some type of injury in a chronic state. You may also not see any evidence because it may have completely healed by that point.
And so from your analysis in this case, how did you characterize in your opinion, from everything that you reviewed as far as the injuries you observed in Mr. O'Keefe's brain?
The injuries I observed were acute injuries, meaning that they probably occurred minutes to hours.
Now, if I could turn your attention to your findings as far as when you conducted your analysis and your testing in this particular case, what, if anything, did you find as far as injuries to Mr. O'Keefe's brain?
So when I look at the brain, what I do is I look at all surfaces from all sides. And one of the things that I look for is anything grossly obvious, meaning anything I can look at the brain and see that there's something there that shouldn't be there. So one of the first things I noticed was a subarachnoid hemorrhage. And subarachnoid hemorrhage is something that occurs when you have bleeding within the leptomeninges. The leptomeninges are a very thin membrane that encase the brain and the spinal cord. And there should not be blood freely floating within the leptomeninges. So if you have a subarachnoid hemorrhage, most of the time, the causes are either a ruptured aneurysm, which is something I would see upon cutting the brain, or some type of trauma. So that was the first finding.
Can I stop you there just for a second? Of those taking notes and for our court reporter, could you spell the type of hemorrhage and the membrane?
Yes. Subarachnoid is SUBARACHNOID. And leptomeninges, LEPTOMENINGES.
Thank you very much.
You're welcome.
Now, with regard to anything related to the aneurysm that you indicated that you would have seen, what, if anything, did you see during the course of your review or testing or analysis of Mr. O'Keefe's brain?
So aneurysms are typically seen in the cerebral vessels that sit around the base of the brain. So there's something called the circle of Willis, which is the main arterial supply. It sits around the base of the brain, and it's kind of shaped like a circle that has vessels that come off that extend to other areas of the brain. So typically, if there is an aneurysm that is ruptured, it's going to be located somewhere in one of those vessels. So upon observing those vessels, I did not see any evidence of any aneurysm or any sort of natural disease state that might have led to a rupture in one of these vessels. Also, sometimes these vessels, since they do go deep into the brain, you may only see the rupture upon cutting the brain. And I did not see any evidence of any rupture of any of these vessels anywhere in the brain.
Now, as far as the subarachnoid hemorrhage that you observed, where was that located within the brain, and if you could?
So the subarachnoid hemorrhage was on the frontal poles, which is essentially right here in the front of the brain. So the frontal lobes obviously sit in the front, and then the poles are the very frontmost portion of the brain. So it was on the frontal poles. It was also on the left temporal pole. So the temporal region is right here in the temporal region. And because of the way that the temporal lobe is shaped, it kind of has a little loop right in the front. So it has a pole as well. So it was on the left temporal pole. And then it was also in the left lateral fissure. So you have a frontal pole here. You have the temporal lobe right here. And then the lateral fissure goes kind of in between the temporal and the frontal lobes. So you have the hemorrhage here, and then hemorrhage right there. So it's kind of all concentrated almost in one area. But then there was also hemorrhage of the posterior surface of the right temporal as well. So on this side.
Now, doctor, I'm probably going to butcher this horribly, but just as far as the bilateral unci, are you familiar with that?
Yes. So the unci are the medial portion of the temporal lobes. So the brain is essentially oriented in a way that each hemisphere, the right and left hemisphere, are the same. The unci are the most inner portion of the temporal lobes. So the unci sit just next to the brainstem. So if you have anything that causes herniation of these unci, they start to push inwards onto the brainstem. So say this is the brainstem, here the unci, they start to push in. And because the brain is within the skull is hard, you have no room for any sort of expansion of the brain. If there is herniation, it will start to push in that area because the brainstem turns into the spinal cord and goes out of the skull through the foramen magnum. So you have this hole about this big or so at the base of the skull where the brainstem turns to the spinal cord, then comes out. So that's one of the only areas in which the brain can actually move because it's encased in the hard skull. So if you have herniation, it'll start to push and then push downwards.
Could I ask you to spell
UNCI.
And with reference to this bilateral unci area, what, if any, herniation did you observe?
So when the unci herniate, it can be subtle. Sometimes if it's herniated enough, you may see hemorrhages in the brainstem. And this happens because this tissue is now pushing on the brainstem and it's essentially being compressed. So there was herniation noted, and then there was hemorrhage within the brainstem.
Now, if I could ask you, doctor, just to be familiar with the term or medical term known as a contusion.
Yes.
And can you explain just in general terms to the jury what you understand that term to mean?
So a contusion is essentially a bruise. It's blood that's coming out from a blood vessel. It's a blood vessel that has been broken in some way, and now there's blood coming out.
And are you also familiar with another term, part of that term, known as a punctate contusion?
Yes, so punctate is essentially just a way to describe the size of a contusion. When I say punctate, I mean something that's very, very tiny. It almost just like a dot.
And with respect to punctate contusion, what, if anything, did you observe in Mr. O'Keefe's brain, and where was it located?
So there were punctate contusions in the frontal and temporal cortices. So frontal, once again, is the front portion right here. Temporal is kind of right behind it in this area. And the cortex is the gray matter of the brain. So it's a thin strip that kind of just goes around the brain. And then the white matter is underneath all that. So in traumatic injuries, you can see punctate contusions or even larger contusions in the cortex. It usually indicates that the brain has been pushed against something, which is now causing these little blood vessels to rupture, hence seeing the contusions, because the blood is no longer contained in the blood vessels.
Now, doctor, with regard to the subarachnoid hemorrhage, is there anything that you're able to do as far as measuring that?
It's hard to measure because it's usually pretty vague. It's not usually something that is a well circumscribed, meaning I could say it starts here and ends here. A lot of times it's subarachnoid hemorrhage because it's sitting in this space that it's not supposed to be in. It can spread, so it may be thicker in one area, thinner in another. So you may have some that may appear just as a very faint hemorrhage, and then some that might be very thick, which you can physically measure. So I usually just give an area where it is and say it's here, it's there, because it's almost like measuring something that has blurred edges. You can't really get a completely accurate measurement.
And what, if anything, were you able to observe or measure with regard to the subarachnoid hemorrhage in the area of the left prefrontal lobe?
So it appeared thicker in that area, meaning that as opposed to it looking just like a faint red color that should not be that color, it was actually thick enough that it was obscuring the underlying brain parenchyma.
If I could turn your attention, doctor, just back for a moment to the punctate contusions that you were testifying about before. As far as your observations of those, was that one or more than one, or how many did you observe?
So there were multiple. There were multiple contusions to the point where it's not something that you can count. I mean, you could count it, but it would probably take a very long time. If it had been something like one or two, three, four, maybe a handful, it would probably be something I would say there are 3 here, 4 there, but there were so many that it didn't serve a purpose to count.
And the number of those, what, if any, significance did that have in regard to your analysis, your observations, or your opinion?
So given that there's multiple, it means that there's enough pressure in the brain that there were many surfaces that were pressing on the bony prominences of the skull, which was leading to a lot of blood vessels rupturing, causing these contusions.
Now, I think you've talked a little bit, but just in general terms, if you could describe for the jury, what is a hemorrhage?
So a hemorrhage is essentially blood that's coming out from a vessel. So it's like a bruise. Hemorrhage, bruise, contusion, they're fairly similar. Some people use them interchangeably, but it's essentially blood that's no longer contained in a blood vessel.
When something is termed medically, based on your training experience, as a diffuse hemorrhage, what does that mean?
So diffuse means it's over a very large area. It's not something that's just a tiny little area. You could say, okay, I'm looking at this person's, let's say, liver, and there's a 2 by 2 centimeter hemorrhage sitting right there in the right lobe of the liver. Diffuse would mean there's hemorrhage throughout nearly the entirety of the liver.
Now, with regard to, you made a note as far as there being a diffuse hemorrhage within the pons, P-O-N-S, is that correct?
Yes.
you explain to the jury sort of what that means and where is that located within the brain?
So the pons is part of the brainstem. So the brainstem starts right in the middle of the brain, and you have the midbrain, the pons, the medulla, and then it turns into the spinal cord. So the pons is kind of in the middle of the brainstem. And when you have hemorrhage in the pons, in this circumstance, it was because there was the herniation of those oci, which began moving closer and closer towards the pons, pressing on it, causing hemorrhage, because now the tissue is compressed, the blood is not going to be able to flow in and out freely, therefore hemorrhage.
Now, with regard to the totality of what you reviewed in this case in regard to Mr. O'Keefe, you gave form any opinions to a reasonable degree of medical certainty in regard to the injuries that you observed to Mr. O'Keefe's brain.
I was able to determine that these are acute traumatic injuries. I know that based on what I observed and in combination with the autopsy findings, that this is due to some type of trauma.
If I could ask, as far as you have certain findings as far as the intraventricular hemorrhage and occipital horns of the lateral ventricles, correct?
Yes.
If you could please explain to the jury what exactly does that mean?
Yes. So the ventricles are almost like a tunnel system of the brain in which the cerebrospinal fluid flows through. So the cerebrospinal fluid serves as a fluid that nourishes the brain. It provides a flow of nutrients, oxygen, things like that. And it starts in the frontal portion of the brain, and then it goes backwards towards the occipital, which is the back. And it also flows downward through the brainstem and then into the spinal cord as well. So the occipital horns of the lateral ventricles are in the back of the head, and having hemorrhage in those areas, in any area of the ventricular system, is usually indicative of some type of trauma. So there should not be blood freely flowing within the ventricular system.
Now, Dr. Stonebridge, with regard to your findings, you mentioned that your findings were that the injuries were acute and that the injuries were the result of trauma, correct?
Yes.
What, if anything, can you say or can you opine as to the mechanism for those acute traumatic injuries?
It was something that required some type of force, given that there were skull fractures. I can't say what type of force or how much force, but it was definitely something that caused some type of force, which led to the skull fractures and then the subsequent brain findings.
And the brain findings in particular that you made, were those consistent with the fall?
They can be, yes.
Can they also be consistent with being struck by a vehicle and then going to the ground?
Yes, they can be.
Thank you, doctor. I have no further questions, Your Honor.
You're welcome.
Cross-examination?
No questions, thank you.
You're welcome.
Doctor, thank you very much. You are all set.
Thank you.
Mindful to step down. Thank you.
All right, Mr. Lally, your next witness.
Yes, Your Honor, the Commonwealth called Dr. Irene Scorti-Bello to the stand.
Okay.
And Your Honor, as she's coming in, may we approach briefly?
Sure.
What do you think there, Magistrate Joe? Joe must be eating. So I'm
Well,
curious.
John, what did you think about that?
Well, I was getting ready to say, I'm curious. So if I understood it correctly, like it wasn't just what they're alluding, it wasn't just like one strike. It was like multiple. she was talking about multiple injuries to the brain, like he may have been assaulted, hit with a fist, hit with something else. I don't know. I'm not a doctor. I don't know how all that works.
What
But
was interesting, what we haven't heard is there was damage to the liver. Now, the liver's a particular organ that can be damaged with kicks and punches. So I'll give you that as well. But I don't think she ruled out the fact that it could be a vehicle strike. You got to remember, you've got the strike of the vehicle, and then you got the body striking something else. As it's, they say he flew 30 feet in the air. I believe that
excuse me.
definitely had some serious head trauma.
Well, and I don't know if you remember or not, but in one of the photos, I think it was taken at the hospital, you could see the bruising around his back. I thought that was curious as to how the bruising was, and like you said, being kicked, punched. I don't know.
But the autopsy report doesn't say. It doesn't note those as injuries. That could be lividity that we're
Madam
looking
Court
at.
Reporter, what was previously marked SS for identification is now the next exhibit in evidence.
So that was a subordinate. I won't say subordinate, but that was a medical examiner that
Thank you.
does particularly, I guess, brain injuries, but doesn't determine the cause of death. She just gives her finding to, as she explained, I think to this lady, who will be testifying as to the exact cause of death and her opinion as to how the injuries were caused.
So are you looking for my instruction now, Mr. Lally?
Yes, please, Your Honor.
All right. So jurors, I gave you a similar instruction before about photographs. So the Commonwealth intends to introduce into evidence through the next witness certain photographs showing Mr. O'Keefe post-mortem. You'll have those photographs with you in connection with this case. I understand that some of them will be shown up on the screen, and that's why I want to sort of give you a warning that will happen. When they come to you as exhibits, they'll be placed in an envelope. You can
They probably won't show.
look at them briefly.
Yeah.
They'll be covered, is what I'm saying to you. So the photographs are not pleasant. They can be described as graphic. And I instruct you that your verdict must not in any way be influenced by the fact that these photographs will be unpleasant, perhaps sad and graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for Mr. O'Keefe, which might be occasioned by the photographs. So please consider those photographs only as they draw your attention to a clinical, medical status or to the nature of Mr. O'Keefe's injury or to the nature of the incident itself. Okay? All right. Now your next witness, please, Mr. Lally.
While they get them situated, Big Ron is reporting that legendary actor Donald Sutherland has passed away at age 88. Donald Sutherland is no longer with us, folks.
I never knew his name. I mean, I knew the face, so I looked it up. And that was.
It's Kiefer Sutherland's father.
Yeah.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Good afternoon, Doctor.
Good afternoon.
All right, Mr. Lally, whenever you're ready.
Good afternoon, Doctor.
Good afternoon.
Could you please state your name and spell your last name for the jury?
My name is Irene Scorribello. My last name is spelled SCORDI-BELLO.
And how are you employed, ma'am?
I am employed as a medical examiner.
And for whom are you employed?
I'm employed by the Office of the Chief Medical Examiner for the Commonwealth of Massachusetts.
And how long has it been that you've been medical examiner for the Office of the Chief Medical Examiner in Massachusetts?
I have been with OCME in Massachusetts since December of 2016.
Now, ma'am, if I could take you back and just ask you a few questions regarding your educational background, work history a little bit prior to working at the OCME in Massachusetts. If I could start with your undergraduate work as far as where did you go and what, if anything, did you receive a degree?
I completed a bachelor's degree in microbiology at the University of California.
And after receiving that degree, where did you go from there?
I went on to the University of Miami, where I completed my doctorate degree in immunology. And following that, I moved up to New York City, where I went to medical school. I completed 4 years of medical school at the Mount Sinai School of Medicine. And following medical school, I completed 3 years of pathology residency at the Mount Sinai Hospital.
And then following your residency at Mount Sinai, where did you go from there?
And from there, I went downtown in New York City, and I completed a 1-year fellowship in forensic pathology at the Office of the Chief Medical Examiner for the City of New York.
And following that 1-year fellowship there, where did you go from there?
I worked in New York City until 2016 when I moved here to Massachusetts.
Now, are you board certified?
Yes, I am.
What are you board certified in?
I'm board certified in anatomic pathology and forensic pathology.
And if you could explain to the jury just briefly, what does it mean to be board certified and sort of what is entailed in that process?
Board certification is actually a voluntary process that a physician decides to go through. It involves completing an accredited program in the specialty of choice. In my case, it was pathology and forensic pathology, and then completing a number of requirements as well as taking and successfully passing exams, and then being able to say that you're board certified.
And is that certification at this time, is that up to date?
Yes.
Now, with regard to the time that you've been working as a forensic pathologist, are there any organizations that you belong to in relation to your work in that field?
Yes, I am a member of the National Association of Medical Examiners.
And that's an acronym as far as name.
Name.
Is that correct?
Yes.
Now, with respect to that time frame as well, what, if any, experience do you have in regard to teaching the areas related to your field?
I have always been interested in teaching. I started teaching as a pathology resident, teaching other residents and medical students. And during my time in New York City, I enjoyed teaching medical students and residents. We had a very active education program in New York City. So I've always been involved with teaching both pathology and forensic pathology.
Now, to those terms themselves, if I could ask you briefly just to describe to the jury as far as pathology in general sense, what is pathology?
Pathology is a specialty of medicine, and pathology looks at disease processes and as well as trauma and the effect they have on the human body.
And what is forensic pathology?
Forensic pathology looks at disease processes and injuries in the human body and tries to determine the cause of death in deceased individuals.
And as far as anatomic pathology, what exactly is that?
Anatomic pathology, as opposed to clinical pathology, is has to do with any organ that is in the body, versus clinical pathology that deals with fluids and blood analysis and things like that. So anatomic pathology, a lot of anatomic pathologists are surgical pathologists. That's another term that you will hear. These are pathologists in the hospital that look at tissues under the microscope, and they come to a diagnosis, whether something is benign or malignant. And forensic pathology takes anatomic pathology to another step, to another level, by looking at the whole body and trying to determine the cause of death instead of organ specific. Instead of just looking at one organ, forensic pathology looks at the whole body.
Now, you're also familiar through your work and training experience in regard to forensic pathology with the term called autopsy?
Yes.
And is that something that typically you would do in the case of sort of your investigation and your analysis in regard to pathological analysis when it came to a body or a patient that comes in?
Yes, an autopsy is a procedure that we do to determine the cause and manner of death.
And so, doctor, with respect to an autopsy, may be a term that's pretty well understood, but if you could explain in general terms, as far as when a body or a patient comes in to the OCME, as far as what is an autopsy, what is involved in it, and sort of what does that consist of?
Yes. When a case, a death is first reported to the medical examiner's office, we make a determination as to whether that death falls under our jurisdiction. Cases that fall under the jurisdiction of the medical examiner include all violent deaths, all deaths that are due to not natural causes, all accidents, intoxications, deaths of babies and children, and deaths in individuals that were not under the care of a physician when the death occurred. So once a case is accepted and it falls under our jurisdiction, it is given a numerical number, and then the body is transported from either the location of the death or the hospital to our facility. Our facilities. We have 3 facilities in the state of Massachusetts. Once the body comes to our facility, then there are a number of steps that are taken. The body is processed. What that means is that their pictures are taken, a weight is taken, a height is taken. Everything is input into our computer system, and then a determination is made as to whether an autopsy is required in order for us to determine the cause and manner of death. If the answer is yes, then we proceed with the autopsy.
Now, as far as an autopsy is concerned, there are 2 sort of primary components of that, as far as an external examination and an internal examination. Is that correct?
Yes.
And can you describe to the jury, again, in general terms, sort of what the process is in reference to both external and internal?
Yes. So the autopsy or the postmortem examination has 2 main parts. The first one is the external exam, and it is basically what it sounds like. We do a very thorough exam of the outside of the body. We document physical characteristics, eye color, hair color. We document any scars or tattoos that may be on the body. We take pictures, we make notes, we look for any signs of disease and any signs of injury. All that is, as I mentioned, documented. And once we're, during the external examination, sometimes we will take evidence. We will collect hair and nails from the body if we think that that is necessary or warranted. And once the external examination is done, then we proceed to the internal examination. That involves making surgical type cuts on the body, what's known as the Y incision that goes from shoulder to shoulder and down the middle of the body, and the organs of the neck, the chest, the abdomen are examined thoroughly, again, looking for and documenting signs of disease or signs of injury. We do the same thing with the head. The head is open, the brain is removed, and we document any disease or injury.
Now, turning your attention to January 31st, 2022, did you have occasion to perform an autopsy in regard to a patient or a body of John O'Keefe?
I did.
And do you recall which of, you mentioned there were 3 different offices of the chief medical examiner within the state of Massachusetts, correct?
Yes, it was in the Cape Cod office.
Is that the office that you typically work out of?
No, that's not the office I typically work out of. My permanent position is in the Westfield office in Western Massachusetts. I was covering the office that day because we were short-staffed.
And in the reference to the autopsy that you performed with regard to Mr. O'Keefe, was that in conformity with what you were speaking about just before, generally as far as how you conduct autopsies?
Yes.
Now, during the
B has
course
been
of
paying
the
attention in
autopsy
class.
that you
She's
performed
waiting
in
on the
reference
hands
to
and fists,
Mr. O'Keefe,
what they look like, and
during
any
the
obvious
course of the
defensive
external
wounds.
examination, what, if anything, did you note in reference to that external examination of Mr. O'Keefe?
First, I noted that there was evidence of medical intervention. Mr. O'Keefe's body was transported to our facility from the hospital, and he had evidence of attempted resuscitation. After I documented that, I proceeded to document some injuries that I saw on Mr. O'Keefe's body.
And before we turn to that, if I could just ask you a couple more general questions. You've made some mention earlier in your testimony as far as the cause and manner of death in general. That's two things that you're trying to determine during any sort of forensic pathological examination, correct?
Yes.
And what I'm going to ask you first is just in reference to manner of death. Can you describe for the jury sort of what are the different types of manner in death, and how are they sort of classified from a perspective from your office?
Okay. Yes. So the manner of death are the circumstances that led to the cause of death. The cause of death being the disease or the injury that initiated the sequence that led to the fatal events. So the manner of death is circumstance dependent. There are 5 general manners of death, or 5 umbrellas. The first one is natural. When we determine manner of death to be natural, it means that the death was caused exclusively by natural disease. That would be heart disease, liver disease, cancer, aging, Alzheimer's, dementia, etc. The second manner of death is accident. That means that the cause of death was due to an injury or due to an intoxication, either a physical injury or a chemical injury. But the circumstances show little or no evidence that intoxication or that injury was intentional. So most motor vehicle accidents, most drug overdoses, most elderly falls are classified as accidents. The fatal outcome was not intentional. Homicide is a manner of death when there is injury inflicted by another person, but there is evidence that there was intent to cause fear, harm, or death to the other individual. And suicide is due to either an injury or an intoxication. And again, the circumstances and the evidence suggest or point strongly to the fact that that was a self-inflicted, intentional act on behalf of the person with the intent to cause harm to themselves or cause death to themselves. So most hangings, intentional overdoses by prescription medications are classified as suicides. And then we have, one more manner that we call undetermined. Some jurisdictions, they call it could not be determined. That means that evidence pointing towards one set of circumstances or one manner is no more compelling than evidence pointing towards another manner of death. So if we don't have enough information to know whether something, or to be able to determine the circumstances, then we are left with an undetermined manner of death.
Now, am I correct in stating that the cause of death is something that's more like a medical determination? Is that correct?
Yes, the cause.
So watch the leading questions, Mr. Elliott. Sustain.
How would you characterize the determination that you make in regard to a cause of death?
The cause of death is based on my findings at the time of autopsy, along with any medical information that I may have on that deceased individual.
Now, as far as the manner of death, how are you making that determination?
The manner of death, as I mentioned, is circumstance dependent. I make that determination based on investigative information that is provided to me by law enforcement, by the people who did the investigation.
And what, if any, legal determination are you making as far as when you classify something as either of those 5 categories in a manner of death?
I am not making a legal determination. I'm making a medical determination.
And so as far as the medical determination is manner of death, specifically when I'm talking about something that could be ruled or listed as manner of death as accident, is that, what if any determination are you making as far as that is concerned?
I'm making the determination that the information that I have either shows no evidence or very little evidence that the injury that led to the cause of death was intentional. So I don't have any information to suggest that that was an intentional act.
And am I correct in saying that routinely people charged with, say, motor vehicle homicides, it gets classified as a manner of death as accident, correct?
Objection. Sustained.
May I approach, Your Honor?
Yes.
Doctor, I'm showing you the documents. Ask you to review it, look up when we finish.
Yes,
And do you recognize that document, Doctor?
I do.
And what do you recognize that to be?
This is a copy of the death certificate for Mr. John O'Keefe.
That's signed by yourself, is that correct?
Correct.
And as far as the listing related to cause of death, what did you list as cause of death on Mr. O'Keefe with regard to his death certificate?
Cause of death was blunt impact injuries of head and hypothermia.
And with reference to manner of death, what, if anything, did you list on Mr. O'Keefe's death certificate in relation to manner of death?
I listed could not be determined.
And as far as that listing for could not be determined, if you could explain to the jury why it was that you have that listed as a manner of death with relation to Mr. O'Keefe.
Again, the cause of death is something that I can determine by the autopsy. I did the autopsy on Mr. O'Keefe and determined that he had injuries to his head as well as signs of hypothermia. So the combination of those two was the cause of death. The manner of death has to do with the circumstances under which Mr. O'Keefe sustained those injuries. And I did not have enough information to be able to determine whether those injuries were accidental or not. And so my manner of death was undetermined or could not be determined.
And just from the spectrum that you had just talked about, sort of 5 different manners of
Very.
death, fair to say that you did not determine that this was either suicides or natural causes, correct?
Correct.
And so as far as your determination of manner of death being could not be determined, which of the two were you sort of in between?
The 2 manners of death that remain are accident and homicide.
Your Honor, may I approach?
Yes.
I want to seek to introduce in a minute the next exhibit.
Objection.
So the ME's not weighing in on whether this was a vehicle strike or not
Right.
on manner of death.
And I know now's not the time, but I got a question.
Now, Dr. Scortibello, you had made reference
He says,
to
here we go.
cause
Here
of
we
death
go.
being a blunt force injury. Is that
You're
correct?
right, B. Here we go.
At least one of the contributing causes. If you could explain to the jury sort of what you understand that to mean as far as what is a blunt force injury.
Blunt force injuries are caused by any blunt object. That is a very big category of objects. A microphone could be a blunt object. This bottle if heavy enough, could be a blunt object. The ground can be a blunt object. So anything that doesn't have a sharp edge or a razor edge, not a knife, not a scalpel, is a blunt object. Blunt impact injuries are categorized into contusions, which are bruises, abrasions, which are scratches, fractures, which are a break in the bone, and lacerations, which are tears in the skin. So when we say blunt impact injuries, we could be referring to any of those or a combination of those 4 types. And all those are the result of impact of the body with a blunt object.
Now, we'll get more into specifics in a moment, just in general terms, as far as from your external examination of Mr. O'Keefe's body, whereabouts sort of geographically on the body did you observe these blunt force injuries?
The majority of the blunt force injuries were to the face and the head, as well as to the upper extremities, the arms.
Now, starting with Mr. O'Keefe's head, what was it specifically, or where was it that you observed blunt force injuries to Mr. O'Keefe's head?
Okay. I observed a number of different injuries on Mr. O'Keefe's head, starting with his eyes. He had hemorrhage or bleeding on the upper eyelids of both eyes, as well as swelling of the eyes. He had a small laceration, a small tear in the skin on the right eyelid, again associated with the bleeding. He had some abrasions. Abrasions are superficial scratches on the skin on the left side of his nose, I believe. And when I looked at the back of Mr. O'Keefe's head, he had a laceration. It's a tear in the skin that was surrounded, or it was associated with an abrasion, a scrape.
Now, in terms of the extremities, and I'll start with upper extremities as far as his arms, what, if anything, did you observe in regard to blunt impact injuries to his arms?
He had, on the right upper extremity, he had a number of somewhat linear, somewhat patterned abrasions, scrapes, varying sizes, ranging from small 2 to 3 millimeters to, I believe, 5 or 6 centimeters, both on the upper arm and part of his forearm. He had some contusions or some bruising on the dorsal aspect of the right hand that I measured and documented. He had he had a very small abrasion, I believe, on the lower extremities near the right knee, but I would have to look at my notes to be absolutely sure.
You can go ahead and look at your notes anytime you need to, doctor.
I can go into my notes?
Yes.
Okay.
So she's not calling the injuries on the arms lacerations. She's very particular about they were abrasions, which would be consistent with someone bouncing across the pavement or being struck with a vehicle.
But when you look at the
puncture
photos,
wounds.
yeah, that's what I was getting ready to say. When you look at the photos, it looks like a puncture wound and then the abrasion.
Yeah, they do look somewhat suspicious. I'll give you that.
And I know she hasn't testified yet, but
So as far as his extremities, I noted a 3 centimeter superficial abrasion to his right medial upper arm. That would be the medial aspect, would be the inner aspect of the right arm. I noted the abrasions on his posterior right arm and forearm. Those ranged from 3 millimeters to up to 7 centimeters. I noted 2 red contusions on the dorsal aspect of the right hand. Again, that's the back of the hand. A faint abrasion, a faint scratch on the dorsal aspect of the left hand, and a small 0.5 centimeter abrasion on his right lateral.
There's an incised wound.
I'm sorry, I didn't hear you.
Incised, I-N-C-I.
Incised, yes.
If you could explain the difference between sort of the mechanism and sort of what you observe between a laceration and an incise.
Yes, so an incised wound is what I previously called a cut. So the analogy I like to give is if you have a loaf of bread and you're trying to cut the bread. If you take a very good bread knife, sharp knife, you will be able to smoothly cut the bread. If you take a hammer, which is a blunt object, and you try to cut the bread, you're going to shred it up. So an incised wound is a smooth cut. Knives, razors will cause incised wounds on the skin. A blunt object will cause a laceration. It will break the skin, and the edges will not be uniform, and there might even be some bruising around it.
Now, with respect to the injuries that you talked about as far as the abrasions on Mr. O'Keefe's right arm, how was that located in reference to sort of the circumference of the arm? And what I'm asking there is, was it on top, on the bottom, or everywhere?
I described them as being on the posterior right arm and forearm. So when we examine a body, we examine the body in what's known as the anatomic position, which is the body on the table with the palms upwards. And so the posterior right arm and forearm would be what would be facing the table as the body is laying on the table, the backside of the arm and the forearm.
So the opposite of posterior would be what?
Would be anterior, and it would be this area right here that points up
And as far
or
as
forward.
the anterior of Mr. O'Keefe's right arm, what, if anything, did you observe as far as injuries there?
I noted in my diagrams and my charts that they were mostly on the posterior right arm and forearm.
Now, Dr. Scortibello, if I could turn your attention to the internal examination as far as the injuries that you observed there, what, if anything, did you observe during the course of your internal examination of Mr. O'Keefe?
Okay, the internal examination, I will start with the head. Once the skull was open and the head was examined, I noted that there were skull fractures in Mr. O'Keefe's skull, both in the back and the front aspect of his skull. I noted that there was recent subdural hemorrhage. That is blood that is under the dura, and the dura is a very tough protective cover that sits over the brain. I noted that there was subarachnoid hemorrhage. That's hemorrhage that is directly on top of the brain under the leptomeninges, which is a very thin membrane that covers the brain. And at that point, I removed the brain, and I, instead of examining it right then and there, I saved it in a special solution, and I sent it to our office in Boston for our neuropathologist to fully examine.
And is it your understanding that a neuropathologist ultimately conducted a fuller examination of Mr. O'Keefe's brain?
Yes,
And who was that neuropathologist within your office?
Dr. Stonebridge.
Now, with reference to the head, as far as the skull, you indicated that there were fractures as in plural, correct?
Yes.
And with reference to the fractures, what, if any, relationship did you know between the fractures that you observed and the laceration to the back of Mr. O'Keefe's head that you spoke about in your external examination?
So the laceration on the scalp that I observed was overlying the area of the skull that appeared to be fractured, or at least appeared that the fractures were originating from that point of impact and extending into the rest of the skull.
Now, one of anything, as far as your observations of the skull on that point in the, I'm sorry, which part of the skull was the originating fracture?
This would be on the back of the skull, slightly right of midline.
Is that the medical term that that's referred to as?
I'm sorry?
Is there a medical term that that's referred to as far as the right rear sort of?
It's the right occipital.
And what, if anything, led you to that opinion that that was sort of the originating source of the multiple fractures in the skull that you observed?
Again, observing or looking at the skull fractures and their pattern, there appeared to be a central point with fractures radiating or originating from that central point and going into other parts of the skull.
Now, in reference to that laceration in the area of the originating fracture in the back of the skull, what, if anything, did you determine in regard to impact in regard to that area of the head?
Well, the laceration along with, so the tear in the skin along with the scrape, because they were adjacent, are both evidence of blunt impact. So I knew at that point that Mr. O'Keefe's head had come in contact with a blunt object.
Would that be sort of the point of impact between the blunt object and Mr. O'Keefe's head?
Right.
Now, with reference to the fractures that you would observed, how extensive were the fractures that you observed, the multiple ones?
Well, there were multiple fractures. So by definition, multiple fractures in multiple chambers or parts of the skull. So I would say they were extensive.
Have a moment, Your Honor.
Yes.
What are you thinking there, Joe?
When you're conducting this internal examination, is there sort of a division of the body that you're doing as far as what you're examining and in what order and sort of things that you're looking at from the internal examination?
Well, we examine everything, and usually we start in the external examination, we start from the head and work our way down. During the internal examination, we're doing two things at the same time sometimes. And so I start with the chest, move to the abdomen, and then the pelvis, while at the same time, we're working on the head.
All right, I'm going to pause you there for a minute. We're going to take a short recess and we'll be back.
Doctor, you can step down if you'd like to. You don't have to, but you can step down if you want to, and I'd ask that you just call over.
So, James, about your question, that Terry Coon is on the witness list to testify. So when the state lab,
I'll see counsel at sidebar.
the state lab reached out to UC Davis about how to process the sweatshirt and the clothing. I was not clear whether or not they actually sent it out or not. I think they did. So I think that's why Terry is supposed to testify whether or not dog saliva was found on the sweatshirt. And I think they're also going to get her to testify as to the injuries, whether they're
Well,
consistent
who is
with it.
Terry Kuhn or Kuhn?
She is with the UC Davis Veterinary Clinic.
Have they already certified her as a expert witness?
I do not think so.
Hmm. Oh, she may
That's
not
why.
be.
That's why I said I wasn't sure if they want to call her or not.
That says multiple blunt force hit shows more of a fight, right? Guys, I'm going to push back on that. If someone gets
You
hit with a
are
vehicle
muted.
and knocked 30 feet, where they land and if they bounce before they get there is going to be multiple strikes. Getting hit by a car is not the only injuries from the car is not the only injuries you're going to sustain. Is my view on that. He would only have 2 hits: the state's case, the car, and then the ground. I just it's possible that it's only 2, but it's also I think it's also very possible that you have multiple injuries from that. B says a tail light did all of this damage without substantial evidence left behind. Interesting. Once again, I think we're dealing with more than just the tail light on that.
Yeah.
James says those 2 could have a lot of associated injury depending on the force of impact. Yeah, I agree with that. And his injuries are similar to an MMA fighter. I don't disagree with that either. And once again, I'm not saying that the injuries aren't consistent with a fight as well, but I think you could have some of the same injuries to by being struck with a vehicle. Although there's some injuries I don't see that would make me more comfortable with a vehicle strike. We've talked about this before. You're not going to fly to the ground, fly 30 feet in the air, 200 what was he like 265 pounds, 6 foot, big
170 pounds.
170 pounds.
Yeah.
Okay.
That's what they said the other day.
But either way, getting hit and knocked 30 feet into the yard, you're going to have some injuries. That one on the back of his head is interesting as well because it does look like maybe hit the curb or hit something that's blunt but linear to create that cut in the scalp. But if he's hit and he goes directly to the curb, just a few feet away from where the impact occurred, hits the curb and then bounces another 30 feet into the yard. I don't know. There's some issues there.
But that first ME, she was saying that the what caused all the head or the head bleeding was from injuries to the front lobe or the front of his head, not the back.
Yes.
So, and then they testified that it was not like, if that's what happened, it was not a direct hit. It was a glancing, like it was a glancing hit, like he hit the side of the vehicle or at least that quarter panel. I just don't
We've got,
see all.
and we've all, even the state's got to admit, their story on the injuries are not packaged. They're not very good. It leaves a lot of unanswered questions on both sides of this. Roger asked, "Can a car back up fast enough in the snow that the officers needed four-wheel drive in?" The snow didn't start to get heavy, Roger, until after his body, or about the time his body was discovered. By the time his body is discovered, from midnight until that point in the morning, 2 inches of snow had fallen. When this happened, snow was just beginning to fall, so the roads weren't as bad as they were the next day when all the police can't get out of their driveways and all that other business. So, but that is a point that has been brought up, and I'm not sure. They did pull now. Let's don't forget they did pull the data off the vehicle, and you can dispute it, and we can dispute it. But that vehicle did go in reverse for 61 feet at 24 miles an hour. Now, where it did that can be disputed. I think, especially the way the state outlined it, as far as the way they come about it. But the vehicle did go 61 feet at 24 miles an hour. So it does back up the state's story on that.
Yeah. There's Chloe. On another note, Joe, this is in your area of the woods, and I heard a bit of this the other day. A 12-year-old girl was found in the ditch, deceased, Fox is now saying 2 suspects charged in murder of that case. It was in Houston.
Yeah, you know what? I haven't heard of that.
Yeah.
Let's look into that. That's a sad thing right there. I would be I'd be a person that wouldn't be able to deal with me if that was my kid.
Oh no.
It'd be a problem. I'm not going to say what I would really want to do on this, but you'd hear about it.
I can't hear you, buddy.
James is asking, do they match GPS data to that black box data? No, that black box data didn't have the GPS. They did use the Waze to identify the route that they took, and then they took the mileage from key cycles. It logs in times on key cycles, and then they did the mileage after that to make the determination that the 61 feet was done in front of the house. Now, if she'd taken a different route, if she'd not gone the way the Waze did there, then that all goes into a doubt. So once again, the state's putting on a very poor case. B says my hypothesis he was a dirty department's narc, and they're all in on it. They knew the state needed the car to go to back 60 feet. Could be. You know, that is an angle that hasn't really been explored anywhere else. That he could have been into something dirty all the way to Boston. Boston police is not involved in this outside of the Albert family, who's that guy's retired even, and not actually a Boston police officer, and the victim who was a Boston police officer. But these officers involved in this were not officers at Canton, Guyton, or the state troopers, the Massachusetts State Police, who were all involved in this investigation. Boston police is not involved in the investigation outside of Albert being implicated in the victim being a Boston police officer. But I won't say that's never happened before, B, but there hasn't been any evidence or any hypothesis for that. I think Roger agrees with B. That's just because Roger's being real nice, B. Don't let that go to your head. Roger's a pretty nice guy. But the ME, I don't think it's interesting that the ME didn't offer how the death occurred, just that it's a homicide by blunt force trauma and hypothermia being the two contributing factors. That they're not weighing in on whether this was a vehicle strike. Now, they are laying pretty hard on it was blunt force trauma. The damage being to the frontal lobes is interesting, but I would say that it's consistent both with a vehicle strike and with a fight. And what is us? It says, well, they pulled John's GPS data. They didn't pull Karen's to see if her phone was also believed went backwards at 61 feet. I believe her GPS was turned off on her phone. But believe it or not, I say they used the Waze. They used the Waze to get the route. No, he didn't. Let me go back. The accident investigation guy that did the testing on this, the last trooper that testified, they didn't use the Waze. They didn't use any of the phone data, whether it be Karen's or John's, to determine the route. He said he put into Google from Waterfall Grill and all the potential routes, and the one route that matched up with the mileage is the one he assumed they took. But he didn't go back on the phone data and pull that out, which is kind of lazy in my point. And it also, once again, it leaves a lot of holes in the state's story when they're sitting on the stand. He says, I usually side with the PD, but in this case, it's not straightforward and really bizarre. I don't disagree with you, B. It's bizarre. I just can't figure out if it's criminal or if it's just incompetence and just straight incompetence that court system in that area has been letting them get away with. So they don't understand that it's incompetent. It's normal business for them. A veteran says, have you ever seen an investigation by police be so sloppy in both of our careers? I think is what he's saying. And not to this extent. I've seen some. I've seen some investigations that could have been done a lot better. One in particular was a murder-suicide, and it was my agency. Murder-suicide. The officers get there. It looked like both victims were going to be deceased, a man and woman, husband and wife in their home. She's got some signs of life. They transfer her by helicopter. We're pretty sure she's going to die. Got a gunshot wound, but she doesn't. They didn't bag her hands. They didn't do all the things that they should have done. They really didn't. Just like these officers got lazy. They didn't memorialize that crime scene because they figured two dead people, murder-suicide, case closed. There's not much more to talk about. But she didn't die. And then later, they want to file charges on her. She spent 2 years in jail waiting to go to trial. It goes to trial. And because they didn't memorialize it, actually, I can't say, maybe she wasn't guilty. But because they didn't memorialize it, she was found not guilty. Guys, I got to step away. I got stuff on the stove. I keep thinking this medical examiner is going to go a little longer, and it's not. But give me about 5 minutes. I'll be back, Sean. My apologies.
Okay, no, you're good. You're good. And back to your comment, I'm pretty sure Joe's listening. He knows where I'm going with this. And I've seen it on a personal level, a little bit of sloppiness, and it. I mean, it does make you wonder, but it also reinforces the fact that it does happen for whatever reason, whether it be lack of training, lack of equipment, both. It does happen, but it's like I said the other week. I mean, and I'll preface and say it again. I'm not saying it should be done or anybody should be treated any different. Everybody should be treated the same. But you would think with a law enforcement officer being the decedent, that they would make sure all their I's are dotted and T's are crossed. But yeah, it's just pure sloppiness.
Thank you. Be seated for the next session.
We're back. Okay.
All right, Mr. Lally.
Thank you. Now, doctor, as far as the internal examination was concerned with regard to Mr. O'Keefe, starting with his stomach, what, if anything, did you observe of any significance in that area?
I observed that there were some small hemorrhages, small areas of bleeding in Mr. O'Keefe's stomach.
And are those described in medical literature as a specific type of spot?
They have a name. They're called Wisniewski spots. Wischnewski. And they have been associated with cases of hypothermia.
And how so? How have they been associated with cases of hypothermia?
They have been seen in cases of hypothermia. It's one of the findings that supports the diagnosis of hypothermia. They are not always there, and their presence doesn't definitively diagnose hypothermia, but they are one of the findings that, if present, suggest the diagnosis of hypothermia.
And based on your training and experience, based on other types of literature that you've reviewed in regard to hypothermia, what is, as far as these Wisniewski spots, and thank you very much for saying that until after you had said it. With regard to that, what if anything does it say as far as the causality?
Yeah, she's got
of
zero
that,
sense of
how
humor.
that occurs or is related to hypothermia?
We don't really know the pathophysiology of these spots. There have been various hypotheses. There people have suggested that they are a response to stress. Some people have suggested that hypothermia increases secretion of acid in the stomach, and that leads to these spots, but their exact pathophysiology is still under investigation.
Now, in addition to these areas of small hemorrhage in Mr. O'Keefe's stomach, what, if anything, did you observe in the pancreas?
In the pancreas, I again observed some more diffuse hemorrhage of the pancreas and the tissues around it.
And same question with regard to the spots and the hemorrhages you observed in the stomach. What, if any, relationship do the hemorrhages or the bleeding in the pancreas have in relation to hypothermia?
Again, it's one of the findings that, if present, should alert the medical examiner to consider the possibility of hypothermia.
And as far as the observations that you made, as far as the hemorrhages in the stomach area of Mr. O'Keefe and the hemorrhages in the pancreatic area of Mr. O'Keefe, the sort of juxtaposition of those, what, if any, significance did that have in regard to your hypothermic diagnosis?
When the case was called into our office and when we accepted the case, it was reported to us that this was an individual that was found in the snow, covered with snow, and it appeared that he may have been there for a period of time. So one of the questions for me as a medical examiner is to determine whether there are any signs of hypothermia in addition to what I had already observed, which was the blunt impact injuries. And the combination of the gastric, the stomach, and the pancreatic hemorrhages strongly suggested, given the circumstances and how the body was found, that hypothermia did in fact play a role in his death.
Now, probably should have asked this first as a precursor, but when you use the term hypothermia, what do you understand? What does hypothermia mean from a medical diagnostic?
Right, hypothermia is a term used to describe low body temperature. By definition, 35 degrees centigrade or below. And there are levels of hypothermia, from mild hypothermia to severe hypothermia. It just basically means the body is losing heat faster than it can generate it.
And typically, what would be the sort of core body temperature that would determine someone is hypothermic versus not?
We're usually at 98 degrees or 37 degrees centigrade. So anything higher than that is considered a fever or hyperthermia. Anything lower than 35 degrees centigrade or 95 degrees Fahrenheit is considered hypothermia.
Now, if you could explain to the jury sort of a little bit about the type of diagnosis that is involved in hypothermia, and sort of what other sort of types of information you would be looking at in order to make that diagnosis.
Hypothermia is a difficult diagnosis to make, and sometimes it's a diagnosis of exclusion, meaning that all other possible causes of death have been ruled out and you're left with hypothermia. So a body that is found in the snow or in a cold environment and has a core body temperature of 85 degrees and is unresponsive or asystolic, meaning that there is no heart activity, could be a hypothermic death or it could not be a hypothermic death. And it's up to us to determine by doing the autopsy what other factors are at play. So the example I like to give is a person with severe coronary artery disease goes out to shovel their driveway, suffers a heart attack, and drops to the ground and is dead within seconds. and no one discovers their body for a few hours during the storm. When they're found, they're asystolic, their core body temperature is 80 degrees. But the autopsy shows another reason for their death. It shows a massive heart attack, which is what killed them. They just happened to be outside after they died and they lost heat and their body temperature dropped. Doesn't mean they died from hypothermia. However, if you take a person, an elderly person, or any person, an intoxicated person, a person who is intoxicated with drugs, that goes out into bad weather, gets confused, loses their direction, isn't able to get to shelter, and they die, their body temperature starts to drop, they get more disoriented, they get more confused, their organ systems start to shut down, and eventually they die from hypothermia. So that person will also be found in the snow with a core body temperature of 80, 85 degrees. But when we do the autopsy, if we see those gastric hemorrhages, if we see that bleeding in the stomach, if we see the bleeding in the pancreas, if we look at their toxicology and we see that they were intoxicated with multiple substances, then we can determine, or we can opine, that the cause of death was at least partly due to the hypothermia, because they were still alive when they started losing heat, as opposed to someone who had the heart attack and was already dead when they started losing heat from the body.
Doctor, when coming to your opinion in relation to the cause of death of Mr. O'Keefe, in addition to your autopsy, your internal, your external examination, what, if any, other materials were you provided, and what, if any, other materials did you review in relation?
I was provided with a police report, an investigative report. I was provided with some of his prior medical records. I was provided with records from the hospital where he was first taken by emergency medical personnel. And during the course of the autopsy, of course, I didn't mention this. We also, during the autopsy, collect fluids from the body that are sent to the lab for toxicologic analysis. And after a few weeks after the autopsy, we get a report from the toxicology lab. And in this case, I looked at the toxicology report. As I mentioned, all the information from the investigators, the autopsy findings, the neuropathology findings, and came to a conclusion as to the cause.
Now, as part of the documentation that you received from the investigators, did that include photographs of the scene as well?
Yes, it did, some photographs.
Turning back to the toxicological findings that you received, what, if any, indication did those findings have, or did they indicate in regard to blood alcohol concentration with regard to Mr. O'Keefe?
Mr. O'Keefe had alcohol in his system, and I do believe, I don't have the toxicology in front of me, but in his blood at the time of autopsy, the level was 0.21 grams per deciliter.
Now, contained within those toxicology findings, there's also something listed as a vitreous humor. Is that correct?
Yes.
And can you explain to the jury sort of what that is, where that sample is taken from, and why it is?
Yeah, that sample, the vitreous humor, is taken from the back chamber of the eye. It's one of the routine samples that we take in addition to blood from the body and urine. And it's, again, used to look for the presence of different drugs. In cases of alcohol intoxication, sometimes we will get a value for the vitreous, and sometimes that value might not be exactly the same as the value that we get for the blood. gives us an idea of where in the curve of alcohol metabolism, the individual is.
And so based on sort of the disparity between the vitreous humor level and the, I'm sorry, I may not have asked, what was the level in the vitreous humor?
I believe it was higher. Sorry, I just have to find it. I think it was 0.26. I'm sorry, I can't find it in these notes. I don't know if you have the.
John, may I approach?
Yes.
So he was rather
Yes.
intoxicated.
It was 0.28.
Now, doctor, with respect to the disparity between what was contained as a DAC in vitreous humor versus
3 times the
the
limit.
other number from his blood, what, if anything, does that indicate to you as far, or what, if anything, do you take from it?
That suggests that the level in Mr. O'Keefe's blood had been higher than 0.21, and that's reflected by the 0.28 that was in the vitreous. The vitreous metabolism of alcohol lags. It's a little slower, lags behind that of the blood and the circulation. The alcohol is metabolized in the liver, but the fact that it is higher in the vitreous suggests that the level in the blood was also higher at some point prior.
So at some point, whenever Mr. O'Keefe died, his level of alcohol was on the decrease. Is that fair to say?
Correct.
Now, with respect to, you mentioned that you had reviewed the EMS reports for Mr. O'Keefe as well as his medical records from Good Samaritan. Is that correct?
Correct.
And if you could just briefly for the jury explain your understanding as far as some of the terms within those medical records. Are you familiar with your review of Mr. O'Keefe's medical records that he was labeled as being in cardiac arrest?
Yes.
And can you explain to the jury what that is?
Yes, he was labeled as asystolic or in asystole, which is basically a flat line. So if you attach leads to the body, there is no electrical activity coming from the heart.
Now, with respect to Mr. O'Keefe, as far as certain vital signs were taken in the course of his treatment at the Good Samaritan, is that correct?
Yes.
Including a core temperature, is that correct?
Yes.
Did you recall what that core temperature was?
Yes. It was noted as 80.1.
And that was a temperature reading that was taken at 7:19 a.m., is that correct?
It was taken, actually, this temperature reading in the records that I'm looking at was taken at 6:57 a.m.
And with respect to that 80.1 degree temperature, that's in Fahrenheit, is that correct?
Yes.
And so what, if any, relationship does that have, or what, if any, relationship does that have to your hypothermic diagnosis?
Well, that is the temperature. At this point, Mr. O'Keefe is asystolic, meaning he has no cardiac activity. That is the temperature of his body at the time that he was taken to, that he was examined by EMS and taken to the hospital. So it is a very hypothermic temperature. It is well below the 95 degrees, which we consider hypothermia.
Now, I believe you alluded to it earlier in your testimony, but with respect to hypothermia, what are some of the manifestations of that type of onset as it progresses?
Well, the first evidence of hypothermia, which we have no problem in this room, is shivering. When someone starts to get cold, they start to shiver to conserve heat. But then as the body loses more and more heat, there are neurologic consequences. People can get confused We see this in the elderly all the time. They can get disoriented, and eventually at very low temperatures, below 90 degrees, everything ceases to function. The heart stops.
And would physical weakness be, or lack of strength be one of those manifestations as well?
Yes.
And how many different sort of stages of hypothermia are there from the beginning of or onset of progression to the end?
There is mild hypothermia to extreme severe hypothermia.
If I may have a moment, John.
Yes.
Need you take a moment and speak up? We have to turn this air conditioner off. James is hard on the state's witness. He just called this medical examiner retarded. That's pretty harsh, my friend. A little harsh, I think.
Now, with regards, as far as the type of clothing that someone is wearing when they're outside in these types of conditions, what, if any, relationship would that have with regard to the quickness or the rapidity of the onset of hypothermia?
Clearly, the more layers someone has, the slower they will lose heat from their body. The fewer layers, the faster they can become hypothermic.
And what, if any, information did you have as far as how Mr. O'Keefe was dressed when he was found in the snow on the morning of the 29th?
The information that I was given stated that he was wearing a pair of jeans and a long sleeve shirt.
Now, with respect to someone as far as that hypothermia onset and the rapidity of it, what, if any, relationship would the condition of the clothing? What I'm asking there is more sort of the dryness versus wet clothing. What, if any, relationship with that?
Well, again, wet clothing or wet conditions will speed up the rate at which the body loses heat.
Now, lastly, with regard to this area, Dr.,
B, I would say 80
in
degrees
regard to,
core body temperature
Mr.
would be
O'Keefe
extreme
having sort of
hypothermia.
alcohol on board in his system at the time that hypothermia onset. What, if any, relationship does that have in respect to the onset of hypothermia and the rapidity of that?
Alcohol intoxication, it has been shown to inhibit some of the mechanisms that the body uses to maintain heat. So it's definitely a factor that is a negative factor when it comes to hypothermia.
May I approach?
Yes.
So James has issue with the fact of shivering. You know what? I'm not sure. I've heard too that you shiver to generate heat, burn energy, and moving the muscles is to generate heat to warm the body up
Doctor, I'm
when you're
telling
cold.
you
And yeah, I think 80's either dead or pretty damn close.
document. You could just review that, look up when you're finished. Do you
Yes.
recognize that, Doctor?
I do. It is a photocopy of the exam notes that I took at the time of autopsy.
Does that also contain a body diagram with relation to your notes as far as where you observed injuries on Mr. O'Keefe?
Yes.
Okay. Your Honor, may I approach?
Yes.
I'm off the seat to introduce him as the next exhibit.
No objection. Thank you.
And Your Honor, with the court's permission, if we could publish that for the jury at this time.
Okay.
Doctor, there should be somewhere before you on the desk over there, laser pointer. Coming, if you could, enlarge that just a bit, and if you could focus in towards the top and the head here. Now, Dr. Scortibello, what's up on the screen? Is that what you have before you as the next exhibit?
Yes.
And on this, as far as the examination that you conducted, that also included certain measurements as far as height, weight, things like that, that you did with regard to Mr. O'Keefe's body, correct?
Correct.
And if you could, what did you record as your measurements for both the height and the weight of Mr. O'Keefe?
He was weighed by our staff as 216 pounds and measuring 73 inches, which is 6 feet 1 inch.
Now, doctor, if you could, using the laser pointer before you, direct the jury's attention to starting with the front or the facial area and then to the back of the head, but just with reference to the head area, directing their attention to
That's
what, if
John
anything, you
O'Keefe's
observed,
brother,
in
B,
the area of the head of Mr.
the bald dude. John
In
O'Keefe's
terms
brother.
of injuries, you'd like me to point out the injuries? So as I mentioned, there were ecchymosis, that's another word for collection of blood under the upper eyelids. On Mr. O'Keefe, the ecchymosis on the right eyelid was also associated with a very small laceration. Then there was an abrasion on the left side of the nose. And then on the back of the head, there was a 3 centimeter laceration. So this is the right side. It would be towards, the back lower side on the right side of the head.
And that laceration on the black lower side, or right side of the head, is that in the same area that you observed what you described as sort of the originating skull fracture?
Yes, when the scalp was reflected, there was bleeding under the scalp in that particular area. And then when the skull was opened, that's the area that appeared fractured and appeared to have other fractures originating or radiating from it.
Ms. Gilman, if you wouldn't mind scrolling down just for the middle of the torso. And Dr. Scortibello, if you could again, using the laser pointer, just direct the jury's attention to what, if any, injuries you noted in this sort of middle torso or upper extremity portion of Mr. O'Keefe.
So on the right upper extremity, and again, this is the back of the body. We have this collection of linear abrasions. I think the battery is dead. That measured up to 7 centimeters and extended from the upper arm down to the middle of the forearm.
If I could interrupt you for 1 second, may I switch?
Thanks. This would be the abrasions.
Ms. Gilman, if I could ask you to scroll down for the lower extremities. Again, Dr. Scortibello, if you could.
They didn't burn the
again,
batteries
laser
out the
pointer,
laser
direct
pointer.
Attention to what, if any, injuries you observed on the lower extremities in regard to Mr. O'Keefe.
The lower extremities didn't have a lot of injuries. There was a small abrasion on his right knee area on the side. And if you don't mind pushing the diagram just a little bit more up to see the hands, there were some contusions or some bruises on the dorsal aspects of the right hand and some very faint bruise on the left.
Thank you, Doris. Ms. Gilman, you can take that down.
James is talking about the shaky trooper wasted too much battery trying to get on target. He was pretty shaky. In more ways than one.
Doctor, if I could show you what's a 2-page document, ask you to just review that a couple of minutes.
Yes,
And do you recognize what that is?
I do.
And what do you recognize that to be?
These are copies of diagrams that I used at the time of autopsy to document some of the injuries on the face and the skull.
May I approach again, Your Honor?
Yes.
Commonwealth will seek to introduce in the minutes and next.
You're gonna have to stop. You're killing me, James. You're killing me, man. But you're right. He did do that. B, you're right. It seems like all the apparent injuries are above the waist. We do have the liver. The liver was damaged and bleeding.
And Your Honor, may I return that to the witness?
Yes.
With the court's permission, if we could publish that for the jury.
Okay.
Yeah, ma'am. One moment, Your Honor.
Yep.
Get with it. Get with it, Lolly. You knew this was happening. Let's go.
Okay, Dr. Swartyville, do you recognize what's depicted up on the screen? It's the next exhibit before you.
Yes.
And if you could, again, using the laser pointer, direct the jury's attention to what, if anything, you observed or noted of significance in these particular diagrams.
So the upper eyelids, the areas of the upper eyelids on both sides had ecchymosis or blood under them. On the right side, there was a very small laceration or a small tear associated with that. Both eyes had some swelling to them. And then on the nose, there were two abrasions, two scrapes. One was small at 0.5 centimeters. The other one was 1 centimeter, and it was linear. And I noted them right there.
Come in, if you could scroll down a bit. And again, from the bottom right diagram for you, Doctor, if you could use the laser pointer, direct the jury's attention to what, if any, injuries of significance you noted in that portion of the diagram.
This is the area where I noted the laceration to the scalp. I noted something called tissue bridging, which is a morphologic feature of a laceration. It's what makes it different from an incised wound or from a cut, because again, the skin is crushed and now it's more irregular. The edges are more irregular. And then above that laceration, I noted that there was a scrape as well associated with it. So that was one injury.
In this moment, if I could have the next page of that. Doctor, if I could direct you to the next page of that exhibit before you. And Ms. Gilman, if you could, thank you, really sort of the margin on the top left hand.
Yes.
Now, Doctor, before we get into the diagram that's up on the screen, if I could ask just a bit more, if you could expound upon when you use the term ecchymosis, what exactly does that mean in specific reference to the area of the eyes?
Ecchymoses are a word that we use to describe bruising. Orbital ecchymosis or periorbital ecchymosis or supraorbital ecchymosis just refer to the location of the bleeding in relation to the eye. And when we see ecchymosis or bleeding around the eyes, one of the differential diagnoses, one of the etiologies is blunt trauma to the head, and specifically fractures to what is known as the base of the skull. And this, what you're seeing here, is the base of the skull.
Now, Doctor, if you could, using that diagram up on the screen, explain to the jury, let me ask first, as far as what, were you able to formulate an opinion to a reasonable degree of medical certainty as to sort of how the injuries within the skull and the brain sort of interacted with each other, in particular interacted also with the ecchymosis that you're describing in the orbital region?
So the injuries inside the skull, this is the base of the skull. This is, think of it as the tray where the brain would be sitting on top. The brain has been removed, and now we're looking at the bones. Right here is where I noted the one of the skull fractures to be originating or starting with fractures. These are linear fractures that are extending or radiating from this one point of impact. This is known as the posterior fossa of the base. These two chambers are known as the middle cranial fossa, and this area is known as the anterior cranial fossa. As you look at this, the eyes would be sitting back here. So the eyes are actually very intimately associated with the anterior cranial fossa, which is very thin, and the bones are quite thin and friable. So an impact to the back of the head, as was in this case, because we do have a laceration and we do have an abrasion. So we know that the head impacted something blunt with enough force to break the skull and enough force for those fractures to propagate or radiate into the middle cranial fossa and also the anterior cranial fossa, which is the front chambers of the base. When the anterior cranial fossa are fractured, as I mentioned, they are very thin bones. Blood can seep from this area into the soft tissues and manifest as hemorrhage or bleeding or a contusion or an ecchymosis around the eye when you look at the person face, when you look at their face. So it is a well-known fact that fractures to the base of the skull can present with orbital ecchymosis, and that particular manifestation has a name. It's called raccoon eye because it resembles, I guess, what raccoon eyes look like. But emergency room physicians are always very alerted to any hemorrhage and any bleeding around the eyes, because it could signify or it could mean that there's a much bigger injury inside the skull, and that is not just some bleeding around the eyes, that it actually is associated with a skull fracture.
So the ecchymosis itself, as far as the sort of drainage or seepage of blood, that's coming into, that's what causes the eyes to sort of swell up, is that correct?
Correct.
And Doctor, if I could ask you with reference to, if you could illustrate with the laser pointer on the diagram up on the screen, as far as the...
No range. We're really just getting to the medical examiner's testimony. No big bombshells as of yet.
Bleeding within the brain, what, if any, impact that has on the skull as far as the...
I will say the fracture
building up a
map,
itself.
I think, is consistent.
Subarachnoid
with state
hemorrhage
list.
is a thin layer of hemorrhage on top of the brain, directly on top of the brain under the leptomeninges. The main effect, or I guess one of the effects that subarachnoid hemorrhage has, is that it is very irritating to the brain and can lead to seizures. Subdural hemorrhage is hemorrhage that is due to veins in the dura, that very tough protective cover on top of the brain, that are broken and leak blood into the space between the dura and the brain. That kind of injury, given enough time, you can have accumulation of the blood, and it can cause significant shift into the brain. That's not something that we had here. Here we had some subdural hemorrhage, but not enough that it was what we call space occupying, but it was present. So it was due to bridging veins in the dura being injured from the trauma, from the fractures. And in terms of the effect that all these injuries have, the subdural and the subarachnoid and the skull fractures, anytime the brain is injured, it responds by swelling. And the skull is a closed space without the ability to expand, unlike the skin, where you can have a bruise or a significant amount of blood accumulate under the skin. In the skull, once the brain starts to react to the injury and it starts to swell, there's nowhere to go except for down. And that's the foramen magnum. That is the area where the brainstem and the spinal cord will run out. You know, spinal cord connects, obviously, the brain to the rest of the body. And this is one of the few spaces that the brain can try and squeeze into because he has nowhere else to go. So herniation, brain swelling and herniation are a general response that the brain has to any sort of trauma.
Hey, Ms. Gilman, thank you very much. You can take that down, Mr. Officer. We can have the lights back on. May I approach Sister Retreat?
Yes.
I think the fracture pattern on the brain, on the skull, is consistent to a blow to the back of the head that radiates to the front.
Now, Doctor, with respect to the head injury.
But I'm with
specifically
you
the
again.
fracture,
Too
what,
many,
if any,
too many
opinion
questions,
can you,
James. I agree.
Give or can you say in regard to the type of force or amount of force necessary to cause the fracture to the skull that you observed with regard to Mr. O'Keefe?
I can't really give you a number. I'm not a physicist. I can tell you that the skull is a pretty thick bone. It takes considerable amount of force to fracture the skull. So that was a pretty considerable impact.
Now, with respect to the injuries to Mr. O'Keefe's head and the onset of hypothermia, what, if any, opinion do you have with regard to the timing of those respective to each other?
Well, I do believe the injuries, the blunt impact injuries, were sustained first. These are not injuries that are immediately lethal. This is not something that would cause death in seconds. And therefore, Mr. O'Keefe may have been incapacitated by the injuries or knocked out, if you will, and was not able to get himself into a warmer environment, and therefore hypothermia set in, given the environmental conditions and given the clothing on the body, or the lack of clothing, I should say, no big jacket or anything like that.
Now, when you say something as far as some type of injury being immediately lethal, you give an example of that?
We're still on the state
The
range.
one that forensic pathologists like to use is a gunshot wound to the head that goes from one side to the other, disrupting the neural systems of the brain and causing the person to immediately drop and die within seconds or milliseconds. This is not that kind of injury. This is an injury that took a little bit of time to develop, as is manifested by the fact that we have some bleeding, which means that the heart is still pumping and blood is still coming out of the vessels.
And so I guess to that point, as far as what was it from your examination and your findings and your review of sort of the overall materials that leads you to believe that the head injuries happened prior to hypothermia setting in?
Again, the findings of hypothermia, the blunt impact injuries, if someone is, it's not completely out of the realm of possibility that someone becomes hypothermic and then falls as a result. But the hypothermia would continue along with the brain injuries that took some time to develop. So in my opinion, I believe the impact, the injury to the head came first. Mr. O'Keefe was most likely incapacitated or unable to move into a warmer environment, and then the hypothermia set in.
And if you can, what, if anything, can you say as to the sort of, in contrast to sort of the bullet to the head or the instantaneous death, what, if anything, can you say as to the time that this would take to manifest itself as far as the injury to the head and the hypothermic state?
Again, I can't give you specifics. I would say this was definitely in the matter of minutes, many minutes, or hours.
The impact of the back of the skull, I mean, it could have been something like a 2x4 piece of dimensional lumber or something as well.
Yes.
Now, Doctor, you had mentioned that at some point you had reviewed some photographs from the scene where Mr. O'Keefe's body was recovered. Is that correct?
Yes, I was shown some photographs.
And from the photographs that you were shown, what, if anything, of significance did you observe or lack thereof in the area where Mr. O'Keefe's body was recovered?
Well, based on those photographs, limited number of photographs that I saw and I was shown, there didn't appear to be a lot of disruption around the area where I was told that Mr. O'Keefe's body was found.
And that lack of sort of disruption in the snow around where Mr. O'Keefe's body was found, what, if any, significance would that have to you as far as from a diagnostic perspective?
Well, it suggests that he really didn't travel a very long distance once the injury was inflicted.
And as far as anything related to footprints, drag marks, anything like that, did you observe anything like that in that area?
On the pictures that I saw, no.
Should have been an objection to that. That's not part of her scope.
Now, from your extent of your examination of Mr. O'Keefe's body, what, if anything, did you observe that would indicate any sort of altercation or a fight or anything like that Mr. O'Keefe was in?
I didn't see any major signs of what I would call a significant altercation.
And with regard to that, as far as signs, what are some of the signs, and what would you be expecting to see, and what was lacking as far as your observations of Mr. O'Keefe?
I looked at Mr. O'Keefe's hands. As you saw on the diagrams, I did document that there were some contusions on the dorsal aspect, very vague and faint contusion on the left, and contusion on the right hand. That particular contusion has a central little pinpoint mark that may suggest that it was due to attempts to get IV access on his hand. That's a very common place. But I didn't see any bruising on Mr. O'Keefe's knuckles. His nails were intact. I didn't see any breaks on his nails, and I didn't see any fractures or feel any fractures on any of his hands.
Now, with respect to the diagrams that were up on the screen before, as well as your observations from internal examination.
That's key to this. Police didn't observe the crime scene.
Ribs, is that correct?
Yes, he did have some fractures, I believe, to the fourth and fifth ribs near the sternum. It's a very common location for CPR-associated fractures.
And so I believe you just alluded to it right there, but as far as any fractures to Mr. O'Keefe's ribs, what, if any, opinion do you have as to the origination or causality of those rib fractures?
As I mentioned, those are very consistent with the resuscitation. We see those quite often. Given the history that I was provided, that extensive resuscitation was attempted. I documented those as most likely due to resuscitation.
Now, doctor,
We've
with
got Lisa
regard
with
to
us this
the,
afternoon.
just by way of contrast, you talked a bit about the significant impact or the thickness of the skull. How does that relate to the area of the ribs that you're talking about as far as can be fractured in resuscitative efforts?
Well, I don't understand the question.
Let me rephrase it. What is the difference sort of between the thickness of the bone in the skull versus the thickness of the bone in the ribs?
The skull in general is a thicker bone. It requires more force.
Now, doctor, if I could, are you familiar with a medical term known as vasodilation?
Yes.
And can you explain what that term is and how it relates to Mr. O'Keefe's condition?
I can explain what the term is. Vasodilation means opening up. Vaso refers to blood vessels. So vasodilation is the opening up of blood vessels to bring more blood to the extremities or any part of the body.
And again, that's a bit of an unfair question as far as the relations. But so how does that manifest itself as far as someone who's in colder conditions or has that sort of onset of hypothermia? What, if any, relation does the vasodilation have to that?
Well, you can see vasodilation. You can see vasoconstriction and vasodilation in hypothermia. Initially, the blood vessels will constrict in an attempt to reduce blood flow to the extremities so there's no heat loss. Anyone who has Raynaud's knows what that feels like. But then ultimately the blood vessels will dilate, bringing more blood to the extremities. Again, the normal regulatory mechanisms that the brain has to maintain our body temperature are disrupted when you get into those very low temperatures. And therefore, sometimes in hypothermia, you can see very, very red extremities due to vasodilation.
And with regard to the redness due to vasodilation, is there also a whiteness, sort of discoloration to the extremities that can be observed in hypothermic patients as well?
That's been described as well, yes.
Now, with reference to when you make your observations of Mr. O'Keefe, why is it that, well, let me ask you this. You didn't see any signs of vasodilation or white fingertips or anything like that, is that correct?
Correct. I rarely see signs of vasodilation, especially if someone has died in the hospital.
And can you explain to the jury sort of why that is?
So for two reasons. In this particular reason, Mr. O'Keefe was taken to the hospital and attempts were made at rewarming the body. So he was given warm intravenous fluids and attempts were made to bring the body temperature up with the hope that the heart would start working once that happened. Also, I did not physically see the body until Monday morning. And therefore, I can't really comment on vasodilation or any effects that hypothermia may or may not have had acutely on the body, because I'm seeing the body hours after death, and already the body has been transferred from the scene to the hospital, stored at the hospital, and then transferred from the hospital to our facility. So there's just too much time between when the body was discovered to when I looked at the body to make any reasonable comments on whether there was vasodilation or not.
Mayor Protron?
Yes.
You know, I agree with James. I mean, I see the injuries. I'll say the injuries are consistent with a vehicle strike. You know, in my layman's opinion, and from what I've known from investigating injuries. But it's not proven. There's still a whole lot going on here that the state is just not proven. What does Lisa say? Government is far from proving beyond a reasonable doubt. It's like I'm an attorney. Uh-oh, got an objection from Lisa. Yeah, I agree. After seeing the skull fractures, I will say that you can't rule out being struck by a vehicle, but it doesn't mean that. And I'll also say that the medical examiner's office and this medical examiner on the stand, this doctor on the stand, feels the same way, because they are not saying that. They're just saying that blunt force trauma, as far as they'll go, method or mode of death
I'm actually going to see counsel at sidebar for a minute.
is withheld from the death certificate in their findings. They're just saying that he died of. They're stipulating what injuries he's got. They're stipulating that he died from blunt force trauma injuries to the head mainly, and a contributing factor most likely was hypothermia because of his body temperature. So the ME is not saying that he was struck by a vehicle. They're not saying he wasn't, but they're not saying that he was. So. And B says, no acute hypothermia. A medical team wouldn't attempt to revive unless it was really possible. Well, he still had vital signs when he got there, B. I mean, they're going to, there's folks that have fallen into water and their body temperature's gotten a lot lower. But I think it goes faster. That actually there's a good chance of survival with some of that. But I would say that they wouldn't say, hey, his body temperature's too low, let's don't try to warm him up, when his heart was technically still beating when he got to the hospital.
Rather than showing these two folks now. So, thank you. So we are going to end for today. We are on track. Maybe we are definitely on track for finishing this case next week, partly because of staying all day tomorrow and some of the work we did today and on Tuesday when you all were here. So please follow the 3 instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. We'll see you tomorrow. Thank you.
That's a wrap for the day. I guess we'll get into gory pictures tomorrow. But and B, I understand what you're talking about when you talk about acute hypothermia. But I think if someone presents themselves to the hospital and their heart's still beating, they're gonna they're gonna continue doing life-saving measures and heating his body up. I think would be part of that as well. But you're right; his body temperature 80 degrees is extremely low, and I forget the phrase or the term it is, but not consistent with human life.
Thank you. It does seem like the appropriate place to stop. Does anybody, so we're still in session? Does anybody need me for anything now?
If we could just approach briefly,
Okay.
just regarding scheduling, Your Honor.
Yeah.
They're going to work out their schedule. Yes, Lolly is still doing examination. We're still on direct. We haven't gone to a cross-examination yet. They passed. They had another medical examiner, technician, or doctor that just examined the actual head injury, and I think it did an analysis on the brain post-mortem. The defense had no questions for that person and passed, but I imagine they will have questions for the actual medical examiner that's documenting the cause of death. And B says, my gut is saying something was going on statewide in this case. They were too comfortable being so sloppy. I just don't know, B. I mean, I wouldn't be shocked if evidence came out to say that, but I'll tell you, officers and DAs get comfortable when the courts they go to don't challenge them. That they always make excuses for their poor, sloppy work. It's just not challenged. So it goes from what we would consider sloppiness or incompetence to everyday business. It's always worked like that. Why wouldn't it work like that this time? But this time they've got a defendant that's got some money, and they've got a pretty high-end attorney they're spending some time on this. These guys, both attorneys, when they do cross-examination, they know what they're talking about. They just don't walk into court knowing what they're talking about. I mean, they're attorneys. They're not doctors and all this other stuff. So they're digging into every word that the state is presented is handed over in discovery, and they're going through it with a fine-tooth comb. So I don't know that it's a statewide cover up. It could be a statewide sloppiness, but I'll go back again that I think you blame the court systems that these prosecutors and these police officers are trying cases in, that they go sit on that stand just like they do there. It's been very comfortable for them, I guess, in other cases. But this case in particular, it's not been very comfortable. And I promise you, at least on the state police level, there will be some changes on the way they handle evidence, some way that they document cases, because the state, they're not giving anything that makes any damn sense. We went through the, I don't know if you were with us this morning, B, but when they went through the digital evidence on the GPS data from John O'Keefe's phone, they made something that really wasn't that complicated, super complicated. And this whole thing about how long to die, they brought 3 experts in there to bring so-called experts in there to talk about that. And they've made something that, once again, is not very complicated. They've made it extremely complicated in my part. So this case has been uncomfortable for law enforcement. And I think you will see some changes on the state police level for sure. The DA's office ought to see, and here's the thing too: the DA's office could force every agency that files cases with them to do it by saying, "I won't accept a case like this. I won't accept a case with that." But we'll see. Maybe not. Maybe it won't. But if that happened in my jurisdiction, there'd be some meetings with the DA, with every law enforcement officer in the jurisdiction in the county for sure, to talk about what they're going to accept and what they won't accept, because they don't like to go to court and look like a fool either. Well, my DA didn't. Maybe this DA's Lolly's a little different. But guys, I think John had stepped out to run an errand at the store. I'm going to stay with us to see if there's anything left in the open court, and after that, we're going to close it up. But we've got our show tonight, Night Court with Joe Lanu, 9 to 11 Eastern. Tonight we've got Tickle Text, which is an extra that's actually a South African American. And she migrated to the United States, a naturalized American citizen, lives in Houston, Texas. She's going to talk to us about South Africa's troubles that they've got going on. You've got essentially a failed state, no law enforcement that protects the people. You've got farmers that are being literally killed off their land. And people who live in communes who protect themselves. But it should be a very interesting show tonight, digging into some of the historical issues on South Africa that I didn't know, that I think she's going to enlighten us on. So catch us for that as well. We'd love to have all of you.
All rise in court, please.
And our friend Impractical Tactical, which is AKA Range Minded, thinks that the medical examiner was pretty matter of fact during questioning. I think so as well. I think she said what she said, and she explained what she did. But one thing she didn't say was that John O'Keefe was struck by a vehicle. She wouldn't make that assertion, and she pretty much stuck to what she knew. She didn't get outside of that, and I kind of like that about a witness. Yeah, you're not up there to try to win it for the team. You're up there to tell your part and then let somebody decide. And I don't like it when law enforcement officers do it. I don't like it when anybody does it, to be quite honest with you.
Of requirement.
Excuse me. Let me get back to the stream. But unless somebody's got some more questions, I'm going to shut this thing down here in just a minute. Well, James, we saying that they need mics for the lawyers. You're not supposed to hear the sidebar. That's off record. That's for them to do their wargaming and huddle before they go back onto the record. But that's sometimes they'll bring the reporter in on the sidebars to record something that needs to be recorded, but that's not something we're supposed to hear. Oh, and James, I like what you think. The most important night court date is don't miss it. Most important night court date is tonight. Don't miss it. And B says, I'm enjoying the different vibes. And put some of this up. I'm enjoying the different vibes that you're implementing into your show, Joe's Variety Show. Well, we aim to please B. We're actually, it may not seem like it, but we actually put quite a bit of time and effort into trying to figure all this out and bring something that's both informative, it doesn't stray away from our freedom-loving values, but in entertaining as well. So I do appreciate you saying that. I hope you'll see I hope the fruits of our labors actually come through and provide what we're looking for, both entertaining and informative. Oh, James is saying, now they do have mics, James. Lolly's just, he walks away from his and he's very soft spoken. He probably wouldn't be much fun at a party. He'd just sit in the corner and drink by himself and complain why women won't go out with him. I think that's a Lolly thing. But they don't have lapel mics, but they do have a mic at the podium where they're speaking from. They just don't really speak into it very well. Not for everybody else to hear. All right, folks, I'm going to close it up. I've got a little research to do before we get into our night court show still left to do, and I'm trying to work on some graphics. So I'm going to spend the rest of my afternoon trying to get that. Also, Big Ron is right. Don't forget to like and share to help the algorithm. That is super important for us. We're definitely trying to grow our audience, and the algorithm is sometimes not our friend, but when you like and share, it becomes our friend. We do appreciate you, and thanks, Big Ron, for bringing that up. That's pretty awesome. All right, folks, I'll see you tonight, 9 o'clock Eastern, 8 o'clock Central, 7 o'clock Mountain Time, and 6 o'clock Pacific Time. I think I got them all right. We'll see you there, and we're looking forward to a great show tonight. Of course, we've got the after party coming, and you need to look forward to some trivia. I think we've got the trivia thing just about down, how we can pull that off. We're going to be doing that. And then, of course, you got the smoke show. That's next Wednesday. B was in there last night, and so was James. But that's turning out to be a pretty interesting little concept of just going over the different types of ways to smoke foods, both vegetables, meat, and cheeses, and also how to smoke out and cure them as well. So we got a lot of good stuff coming. Myself and my co-host, we're working behind the scenes to make that happen. If anybody feels the need, has it in their heart, any donations to the show is greatly appreciated. It goes to a good cause. In my the Cash App that's set up for that's actually in the feed here on the ticker on the bottom. It's a $ Joseph Lanou. We appreciate you guys. And we'll see you just a little bit later. Just taking a break. We'll see you later.